Well, welcome to the March 7th, 2016 hearing of the Colorado Oil and Gas Conservation Commission, which we will call to order and ask our boss to call the roll.
Commissioner Allward?
Here.
Commissioner Benton?
Here.
Commissioner Craig is not present. Chairman Compton?
Here.
Commissioner Hawkins?
Here.
Commissioner Holton's not present. Commissioner Randall?
Here.
Commissioner Spielman?
Here.
And Commissioner Wolk is not present.
Looks like we have sufficient number of folks to do business, and we should take a moment and officially welcome Mr. Randall to his role as a commissioner on this body. So thank you for being here.
Thank you, sir. Appreciate it.
We look forward to your good work, and hopefully no one will give you an inordinate amount of grief. Some, but not too much.
Sir, it's you I'm worried about, so.
Okay, you do have a copy or have had a copy of the proceedings from last hearing. We'll just let those stand approved unless I hear an objection.
We also have December.
Oh, okay. We have two of them, two sets.
How about if we move for approval of both sets?
Second.
Okay, motion and a second. Any discussion? Those in favor indicate by saying aye.
Aye.
Opposed, same sign. So those stand approved. Okay, Bob, a report from the Executive Director's Office.
Great, thank you. I'll keep this brief. There are a couple of things on the BLM front I want to update the commissioners on, and then a couple of Endangered Species Act matters that I want to be sure the commissioners are aware of. So first on the BLM, last month the BLM released some proposed rules on venting and flaring that would apply to federal mineral leases. We've been looking at those proposed rules. We met with industry and environmental stakeholders last week, along with CDPHE and COGCC staff. So I want to thank the staff for their work on that, to look at those rules and to find out what concerns folks might have, what questions they might have about how our rules work and how they might fit with the BLM's rules. So stay tuned on that. Comments on those are due, I think, on April 8th to the BLM. Second, with the BLM, we're working with them to implement the Greater Sage-Grouse Plan Amendment that applies in Northwest Colorado. That was adopted last fall. That includes their regional mitigation strategy. We've been working with them on what that strategy is going to look like and how we can help and how our information can feed in. They need to release that strategy in September of 2016, so that's driving the time frame here. Another, I guess, related to greater sage-grouse, but a couple of Endangered Species Act issues. Good progress is being made between the Northwest counties and Colorado Parks and Wildlife to update the greater sage-grouse habitat maps. Those are maps that were adopted in the 2008 rulemaking and are being updated with new information out of Colorado Parks and Wildlife. So they're working with the counties on that. And then the other ESA issue is under the auspices of the Western Governors Association. Governor Hickenlooper this week is hosting an Endangered Species Act forum. There are industry participants in that. This is the third of four fora, I guess is the plural, of such convenings under the Endangered Species Act. This is an initiative of Governor Matt Mead out of Wyoming to look at the Endangered Species Act. The other forums have been in Cody, Wyoming, Boise, and next month it's in Hawaii. So we don't get to go to that one, I don't think. And then finally, just a quick update on the water plan. This week will be a lean event on the federal permitting project or federal permitting process for water projects. Lean is a tool to identify areas of a process that don't add value and essentially result in waste of energy and resources. The focus of that process with federal projects is on the initiation of NEPA and the scoping process. Groups involved include state officials, federal officials, water providers, and other NGOs like Western Resource Advocates and American Rivers. That process will start on Wednesday and on Friday, and we hope that it comes out with some recommendations for how to make that process just as effective, but maybe less painful. So with that, I'll take any questions.
Any questions for Mr. Randall? You're off the hook temporarily.
Thank you.
I guess we'll go to a report from the director, Mr. Lepore.
Thank you very much, Mr. Chairman. Good morning, everyone. I have a few things to cover relatively quickly. First, I'd like to report that you all will recall in April of 2014, you heard a petition for rulemaking presented by Earth Guardians, who sought a development of a rule that would have prohibited all fracking in the state. After a full hearing, you denied that application for rulemaking, and the Earth Guardians appealed to the district court your decision to deny their application. On February 19th, the district court denied the Earth Guardians' appeal. Their denial was based on two arguments, primarily. One, that the Oil and Gas Conservation Act indeed requires the commission to strike a balance between responsible development of the state's oil and gas resources and protecting public health, safety, welfare, and the environment. Plaintiffs had argued that the protection of public health, safety, welfare, and the environment superseded all other concerns. The court disagreed with that position. Secondly, the court found that this commission had held a full and complete hearing on the issues and heard from an array of stakeholders presenting various points of view on the petition for rulemaking. And after considering all of those points of view, plaintiffs had contended that your decision was based inordinately on a legal memo prepared by Assistant Attorney General Jake Matter. Again, the court rejected that position and found that your decision was appropriately based on all of the available evidence presented to you during the course of that hearing. A great deal of that evidence was presented, or significant evidence was presented, by the Colorado Department of Public Health and Environment on public health impacts. So the petition was denied. I did want to acknowledge Jake, Assistant Attorney General Matter, for his fine work on the briefing on that legal case. Staff, led by Deputy Director Coleman, have embarked on an outreach meeting targeting small operators in the state. Kind of a strategic decision that small operators don't always have all of the resources available to participate in all of our processes the same way that some of the larger operators do. So Mr. Coleman and staff have arranged two meetings specifically for small operators. The first of those was held March 1st in Lyman, Colorado, attended by something like 40 representatives from 40 small operators. Very, very positive feedback from those operators on the outreach meeting. That a large number of our staff attended to be available to answer questions and engage with operators on specific topics. A second such meeting is scheduled for March 16th in Fort Lupton at Ames Community College. And again, we have a similar number of operators signed up. So obvious great deal of interest in the regulated community on the Process server, thank you, is the sheriff. And so the sheriff is attempting to serve process, and I will keep you present to you Chris Eisinger, along with Ken Robertson and the field inspection staff and many others, has been working very hard on a risk-based field inspection protocol that is data-driven, that is systematic, and that is automatic, meaning that we've identified certain criteria that drive risk for wells, and we are pulling data from the database for every single well, all 53,000 wells in our database, to give those wells a relative risk profile. Relative meaning to each other, not an absolute risk, but a relative risk. That data changes in some cases daily. One of the criteria is when was the last field inspection. So if you go do a field inspection, the risk profile changes. And inspectors will use those risk profiles to prioritize their field inspections. It's a terrific tool for us. It's a great use of our data. It's been a major project for our IT people, Ken Robertson and Chris, along with the field inspection units, as I mentioned. So we want to give you a little preview of that tomorrow. We'll have a short presentation on that for you. And with that, I'll take questions if there are any.
A couple of comments, Director. I would say a hearty amen to your comments about you're receiving some thank yous that certainly shouldn't go to you. They should go to the staff.
Absolutely.
And by the same token, I get a lot of thank yous. A lot of folks let me know that they think the COGCC staff is doing a pretty good job. So thank you, staff, for working hard. And, you know, there are a lot of people out in Colorado, a lot more than just those that complain to you. So I think you are doing a pretty good job. Keep up the good work. Another comment, Director, there was a landowner, royalty owner in Red Mesa Holdings area that was didn't know exactly where the production is going and if in fact he is going to receive any royalties from it. And of course, as I always do, I directed him to you and to your excellent staff. So I hope you'll keep at least him informed what's transpiring. I'll relay to him I'm sure he knows the sheriff, and that'd be a good guy to complain to. So,
thank you, Mr. Chairman. Assuming it's the same person, we have been in communication with an individual that fits that description, and keeping him apprised of what is transpiring.
Thank you. Any other questions for the director? Any comments on the staff's good work?
Certainly. Although you said it all, I would have to again thank the staff for a lot of hard work and some very difficult times when they have some difficult decisions to make, and appreciate that. And certainly think it's going to be a tough year coming forward, and again, appreciate your hard work as we go forward.
Bob.
So if I could, and this is just following up on Matt's comments about the employee engagement survey. I agree, and we saw some of the same reporting from employees department-wide about satisfaction with their job, a sense that what they do is valuable and valued by the public. We had over 900 people in a department of about 1,400 participate in the employee engagement survey, which is, you know, on the upper half of department's responses across the administration. The thing I wanted to just let the commissioners be aware of is we've created what we're calling an action team to look at those employee engagement survey results The action team includes people that have been going through the OSPB Performance Management Academy. This is a 3-month, every other Friday sort of training session to train department personnel in performance management, in leadership, and process improvement and things like that. Dave Kuhlman is going through that as we speak, and will be a part of that action team. We're meeting later this month to look at the engagement survey results and try to tease out 2 or 3 things that we think are, important to our customers, important to our employees, and areas where we can make some improvement. So I look forward to maybe reporting back to the commission, maybe early summer, on what those things might be and how we're going to go about improving them.
Thank you. Any other questions? Commissioner comments? Looks like the first item there is reclamation discussion. I'm just going to take a wild guess. Commissioner Allward.
So, thank you, Mr. Chair. Enrique, I have the document. I think it starts with unreclaimed well pads. It might be in the upper corner. So just real briefly, last hearing, since a couple commissioners weren't there, I had presented this document that has not, the one that has 9 well pads on it, which may be different than what you have right in front of you, but it's projected up there. And this was during the January hearing, in which what these well pads demonstrate is the lack of initiation of interim reclamation. These are aerial images from 2015, and in each of these wells, in each of these well pads, thank you, the last well drilled and production started was somewhere between 2006 and 2013. So no interim reclamation had begun from 2 to 9 years after completion of drilling activities, or in some cases, no wells had ever been drilled. The well pad was cleared and then no wells were drilled, and so no interim reclamation had been initiated. So we had a brief discussion about that situation last time. And as you can see, these are very clearly no reclamation of any kind has been taken. It's still a flat well pad. We have some issues with how does the staff find out that interim reclamation should have begun? What triggers it? That's our current rules are insufficient to let staff know that something should be taking place, and that they can then go out and inspect for whether interim reclamation has taken place. Subsequent to that hearing, I asked staff to help me look for how final reclamation might be progressing. And so you were emailed by the director a spreadsheet with a number of well pads. I had asked for roughly a dozen well pads or locations. I wanted to know ones that were in significant wildlife habitat, because that's one situation in which I think we should be very cognizant of what's going on with reclamation. And I tried to help focus it so it was just in Garfield County, Rio Blanco County. And if you recall from the staff report on reclamation rules, they had divided up well pads or locations based on the rural environment that they took place under. So between different rule makings, so what rules could have been enforced. So I asked for them to stick within one rule-making environment, not the most recent one, but I think from when passed between 1996 and 2008. So it turns out that's quite a bit of work, especially searching for things within sensitive wildlife habitat, that doesn't seem to be a possibility right now, and that might be something to go into our risk assessment even. And so let me see if I can get the next document up. And you have this in front of you. And nothing seems to be. And is this the next one?
Yes.
Great. So this is what you have in front of you with 8 images on it. So I believe the spreadsheet has 13 locations, 13 well pads on it. And I quickly went through them and with 2 criteria for whether I pursued any further information about them. One was, were they within sensitive wildlife habitat using COGCC? And then could I see evidence of a well pad from the earliest aerial imagery that were available, usually 1993. And the reason for that was, in some cases, the locations are not correct. And I didn't want to be trying to make assessments about something in which the reported location was not the same as the actual location. So I wanted to be able to document that there was evidence of a well pad there before looking at what were the reclamation outcomes. So that narrowed it down to 7 of those 13 well pads, that there was clearly a well pad there before, and it was in wildlife habitat. And so these are in front of you then, images from Google Earth of those 7 well pads. One of the well pads, there's 2 images of it. And in the legend there, what's kind of cryptic, the dates for each, there's a well pad, the API number, the date, the year it was plugged and abandoned, the year it passed its final reclamation, and then the year that this aerial image was from. So this is the most recent, the first aerial image available following the final reclamation. Okay, in some cases that's 6 years later. In some cases it's later in the same year. And in some cases, like in figures A and B, things look pretty good. It's really difficult to see that there was ever a well pad there. In these cases, the aerial images are from 6 years after they were passed, but I'm pretty satisfied, at least from this view. You can't tell what species are there or if there's other stuff going on, but I'd be pretty satisfied if this was the typical outcome. And it may well be. This was a limited selection just to see if there was anything worth pursuing. In some cases, I want to look now at the images in D and H. It's very difficult to determine what's going on using this approach with the aerial images. There's been a whole lot of activity in the vicinity subsequent to the final reclamation. There's a lot of construction, there's well pads in H, there are well pads and or auxiliary facilities on, I think, 3 different sides of this, and it looks like some other sorts of activity going on in the vicinity of the well pad. So I don't think we can make any evaluation on the status of final reclamation in these 2. And then the remaining images are of great concern to me. In these cases, these locations passed final reclamation, and yet it is very clear from C, D, and E that there's still bare dirt well pad, and in the case of E, you can still see the cut and fill slopes. So it hasn't been recontoured, but yet it passed final reclamation. And so, ability to look back through the data and see how many well pads have passed versus what's actually happened on the ground is a problem and that I think we need to address. And so, and in the case of E and F, I've got, let me see if I can, the first photo, E, is from 1993, 3 years after it passed reclamation. And the next photo is from 2011. Still very limited progress. It probably should not have, would not have passed under the current staffing in this situation. I would hope not, at least. So I think we have a problem. And I would like to think that there's general agreement on that. And I would be very interested in hearing the opinions, concerns, the comments of my fellow commissioners, and especially thinking about what do you think our next steps should be.
Commissioners, any thoughts?
If I might ask a question, always mindful of ownership of the surface and what the surface owner requests for reclamation. And then if all of these are on public lands or if they're, I know you said they're all sensitive wildlife habitat, but is there any differentiation between public or private surface here?
According to the data that staff gave me, they're all on private surface. They're all listed as fee. And I don't know who, we just got this week, and this was the most I could do in this week was just to get a sense of what's there on the ground. I have no idea what the surface owner requested, what steps an operator took, what inspections took place. I don't know any of that. This is a first pass. And it apparently took a significant effort on the part of staff to get this. I feel kind of bad about asking for something when I really have no sense of what is available.
Another reason to thank the staff, though.
Yes, another reason, yes.
And again, so I'm always concerned about that is that, having and actually still being a landowner in the state in which had some wells drilled on our property, that sometimes the landowner may ask for something different with respect to the reclamation, and something that they may believe that improves their pasture, improves their the surface, and may prefer to. So I always get worried a little bit about how that may conflict with what we want to do with respect to reclamation overall, and sort of signing off on what's final. Would be worried that if it was left in the state that you could see some erosion or something along that line, or lack of revegetation. From this, it appears that perhaps some more work needs to be done, because there are several of these locations you would think, particularly the ones in E and F, you would wonder, it looks like hasn't been a lot of revegetation in those two over that period of time, and is there something else that needs to be done? But always concerned of being mindful about what the surface owner has asked for as well in reclamation.
I'm in agreement with you, Commissioner, and I think these all have passed a final reclamation criteria. And we don't know then if there was a variance involved in any of them.
We don't at this point. I don't know if staff has any insight, but they've probably put in a sufficient amount of work at this point. And
I would, go ahead.
Go ahead. No,
I would just say, obviously there are some of these that appear to need a little tender loving care going forward. I would be hesitant to open up all of these sites that have passed final reclamation by the set of rules we had, I forgot the dates, but at least prior to 2008. I would be hesitant to open those up in light of, as I recall from the report we got from staff a couple of months ago, there's a sizable number out there that are still active to one degree or another. And it's going to take a near Herculean effort to address those. So I'm not sure exactly what, how much effort we want to expend on these in light of those other pressing needs. So,
to address that comment first, Mr. Chair, if I may, I agree. This is not, these have passed, and so it's in the past. I don't intend to I don't see any point in revisiting these in terms of reclamation. The point is that well pads, just because they have passed, does not mean that we've got some verdant Garden of Eden that's been reclaimed, or even a patch of cheatgrass. And so, but that there has been a shortcoming in our rules, our enforcement of the rules, our ability to enforce the rules. And that, because if there was no problem, I think we could drop this issue. And I wanted to start with something that was done in the past, the recent past, and not be imposing on staff to be concerned that they were being critiqued immediately also. And so I've used these just to say there is a problem. And as far as the landowner wishes, I'm also very supportive of that. But I do want to make sure that it is actually the landowner's wishes, not an event that's taken place because the operator's having difficulty reclaiming an area, and then suddenly there appears a surface use agreement that seems highly beneficial to one party versus the other. And I do think the state has an interest in C, for example. It's hard to tell in this black and white image. I wanted to point out in each of these cases, the yellow line is approximately 50 meters. So it gives you some sense of scale. But in the lower right corner, I believe that's Peons Creek. Okay, so we're within, the edge of that disturbance is within 30 meters of a waterway. And in ENF, I think it's pretty obvious given the shape of those slopes in the lower left that this is pretty steep terrain and potentially very erodible. And so people who live downstream, landowners downstream, may be impacted by this sort of a situation. And, you know, we do in the state have concerns in which we can direct landowners to control noxious weeds, for example, even if that's what they want to grow on their land, because it impacts others. And so I think we need to recognize that the state does have an interest, and that the landowner may not know that he or she has an opportunity to, in sensitive wildlife habitat, to contribute to improving wildlife habitat in the state.
Other comments or questions?
Mr. Chairman,
Commissioner?
I just think that this is an issue that, obviously we may have some problems in the past, but I think we could have even more in the future, particularly in our price environment. And we've got aging wells and aging fields, and it's something that we don't want to leave as a scar on our surface in the state. And I don't think we want to allow operators just to be to not take care of their business, I guess is the way I would put it. And I think that it's an issue that can kind of get pushed under the rug and forgotten. And so I think maybe it is something we should be looking at in a little more detail on how do we manage it. So I agree with your comments.
Well, I'm not sure what you would suggest going forward. I guess today, just from reports over the last 2, 3, 4, 5 months, Margaret and Denise have kind of presented to us a fairly robust enforcement of these now, and they're working on a pretty sizable, I guess we'll call a backlog. So I'm not exactly sure what you would see us doing about these situations today. I think Richard said this is just an example of what has happened in the past. I don't think I heard him suggest we want to go in here and do some work. He's saying this is an example of what can happen if we don't do our work today. I have the feelings are important, that staff is doing a pretty good job today. So where do we go?
I don't know if you, but I could come up. I've got a few options. I'm sure there are many options. So one is, and I would really appreciate a decision of some kind today as to a direction forward. One would be to direct staff to initiate a rulemaking by some certain date, or a stakeholder sort of prelude to a rulemaking. Another would be to direct staff to convene, for example, an expert advisory panel, for just a descriptive term, that might be able to look more closely at what is the current situation or more recent situation, and make recommendations for moving forward. An alternative would be to not burden staff with that, to direct me to convene a science advisory panel to look into, and report back to the commission with recommendations by some date. Or you could request that I go away.
How would I phrase it?
I'm sure you could be creative, Mr. Chair.
Okay, the report that we got from staff, whenever that was, a couple months ago, as I recall, indicated that there was some potential for a rulemaking if they didn't get things worked out exactly the way they wanted. That's kind of my memory. I don't know what the current status of that is. Director?
Thank you, Mr. Chairman. Staff has mapped a path forward based on the report that we did and presented to you. That report, I think in relatively clear detail, lays out how we arrived where we are at the moment with some of these circumstances, probably not every single one of those. We haven't had an opportunity to look at these images in detail or understand the specifics of what's going on at each of those locations. I don't think staff is shocked to learn that there are circumstances that look like that. The first image, my best guess would be that most of those result from something that is acknowledged in the staff report, which is the conductor setting policy that was put in place several years ago and has had that unintended consequence of operators set conductor casing and tell us they intend to drill week or month or year, and have told us that for a decade now. We are in the process of revising that policy so that that will come to an end. But staff's belief, having done the report and the review, is that we should dedicate our reclamation staff resources to reducing the backlog of inspections that need to be done for final reclamation inspection, to check off the ones that pass and know the status of the ones that haven't and why they're there, to update some of the policies like the conductor setting policy that didn't work the way they were planned to work. We have more reclamation staff than we've ever had before. We feel like we need to deploy those resources for the things that are identified in the staff report. With that, some months down the road, with an opportunity to see how those fixes play out, there were some things, some relatively minor things in the rules that we think maybe need to be revised. But we sort of feel like after we see how we can do with some guidance documents and policy documents. I think Commissioner Allward, I think Commissioner Allward is raising a separate question. And the separate question is, even if you comply with our rules as they exist on the books, and you undertake what is required by those rules in terms of interim and final reclamation, will you have a successful ecological outcome? And I think that is a different question. And I don't think we've done the research on that. I don't think Dr. Allward has done the research on that. If that is research that somebody wants to undertake, I don't think it's the staff's place to do that research, to be perfectly candid, for a variety of reasons, but all of those have to do with money and manpower. So if there's a private entity out there that wants to do some kind of study, that's not our place. If this commission thinks that that's the highest priority facing the commission today for staff resources, then that's your decision to make. I'd certainly like to give Margaret a chance, Ms. Ash, to add anything, and if she'd like to, but any details, anything I've left out.
I think you covered it.
My tendency would be to let this play out. They have a plan in place. They're going to look at some policies. They've made some adjustments. I understood you to say already made some adjustments. They're looking to make some additional adjustments. So you let it play out for whatever, a few months, 6 months, 9 months, or whatever. And then if the staff feels at that time we need to do some additional efforts, for example, in the arena of rulemaking. We love rulemaking, of course. That was tongue in cheek. But that would be my judgment. I don't know what my colleagues think.
Mr. Chairman, if I may.
Please, Commissioner.
Thank you. I tend to agree strongly, and let me thank Commissioner Allward, who's clearly, if not one of the, but I think the commission expert on the topic. You keep us reminded of the importance of the policy, the regulatory, and the environmental importance of reclamation as a part of the overall process of developing our state's oil and gas resources. I don't think even if we wanted to, we could set a new rulemaking today. We haven't noticed that. I frankly was wondering why we had 30 minutes of commissioner comments on the agenda today, and I figured that out 24 minutes ago. But I thank you, Commissioner Allward. I know the staff is working hard, as they do on all topics, on follow-up from that report. And I, for one, would like to, I think as the chairman said, let it play out a little bit, but remain mindful of the issue and the policy imperative, and see what new procedures and new focus that Director Lepore and staff are undertaking yield. So that would be my comment, sir. Thank you.
Thank you very much. Other comments?
Related to this, or?
Related to this, yes.
So, thank you, Mr.
We only
Chair.
have 30 minutes.
I know, I'm down to a few seconds.
Commissioner Allward.
Thank you, Mr. Chair. I appreciate my fellow commissioners' comments, but I would argue that we've been allowing this to play out for 9 some years, and in another 6-9 months, the staff still will not have any scientific information about what's going on with reclamation. They will have some more policy information. They will have some information about revegetation gained through their own efforts of the reclamation staff. But that will only be for those sites that they happen to visit in the next few months. And I think if they come up with some policy concerns, they will still be lacking information from restoration ecologists who have been studying this and could add some insight to help with what would be an appropriate policy stand to take. And so having something going on simultaneous with what the staff is pursuing, I think would be advantageous to the state of Colorado. As far as what research is out there for the ecological recovery of these sites, I would, in one case, refer you back to a paper I had published that came out January of 2015, which showed that even after 60 years, ecological function was severely curtailed on old well pads, that we could find very little evidence of ecological function recovery. And I think that that is the state of research right now. It's very difficult to find any published research that says we have achieved ecological recovery. And as Commissioner Hawkins pointed out, we're seeing right now, for example, in the coal mining, with companies that are self-bonded, that we may be having difficulty getting reclamation there. I'm concerned, given the low rate of bonding in oil and gas that would not cover the costs of reclamation, that we are setting ourselves up for a problem. And I don't think letting it play out for another year or 10 years or whatever is really a responsible, balanced approach. Thank you, Mr. Chair.
Thank you. Thank you. Okay, is there any specific action the commission wants to take here? Okay, thank you. We will.
Have one comment. I would like to kind of hear what the staff, after they have a chance to look at their policy and look at kind of, where they are with this in the next couple of months, to come back to us and give us some recommendations on where they think we should be going, and if we need to make some more changes or put more scientific study into this.
Okay, you heard Commissioner Hawkins' suggestion. the commission agree with that. And not seeing any disagreement. If we-
A question about is what I what I heard in there is that you're asking the staff to perhaps undertake some more work. So, and I'm concerned is that how does that fit with the staff's current efforts on ensuring that current reclamation efforts are undertaken and properly concluded? Do they really have the appropriate time to sort of add this to their to-do list?
Well, I think what I'm asking them is just to give us their recommendation on how they think we should be proceeding with this. And if, yeah, we definitely want to take, stay on top of our current reclamation efforts, but is there something, are we lacking? Is this, in their opinion, something that needs to be addressed, and how would they recommend addressing it? Commissioner Allward obviously thinks that it's something we need to move forward with, and he's an expert in this field, and I just feel like we need to get the staff to think a little bit about it and give us some of their thoughts too.
Well, I'll go back to my argument that I think the staff, in fact, has given this a fair amount of thought. And that's when they did their analysis that they presented to us a couple months ago, kind of laid out a framework moving forward. Here's how we anticipate attacking this problem. And certainly I would expect a report from them, but I don't think next month or the month after that. I think they need just a little more time to take a look and see what their efforts, what direction their efforts seem to be going in, and if they do need some rulemaking support, then the commission can take it up at that time. That's my studied judgment.
Chair,
Commissioner.
just one brief comment. I'm sorry to belabor this, but I'm hesitant to ask the staff to do more myself too. I think they've got considerable workload, but I do think it's an option of the commission if they want to support some investigation, advice, recommendations from a convening of restoration ecologists who are experts from CSU, from CU, et cetera, who might be able to devote some time to this and provide recommendations. The staff with the commission be supportive of that and endorse it, or that is another option that could happen concurrent, and then the staff would have full information when they have completed their investigations also.
I won't belabor it either. However, if after a period of time they've had a chance to work their work and they see a need in this area, and that would be a recommendation from them, I think it would be something the commission could consider at that time. Mr. Randall.
You just said it better than I was going to. My concern is that convening such a group cannot be done. I guess it takes effort. And I'm very aware of the commission's need to forgo filling vacancies. And everyone is doing, in some cases, more with less, some cases more with same, but that is additive work. And I think the approach set out initially by the chair, at least for the interim, to try to identify any gaps that we think need to be filled at the staff level is appropriate.
Okay, I think then we'll let the staff's efforts play out. Director, do you have any comments?
Thank you, Mr. Chair. Looking at the hearing calendar, we have hearings scheduled in June, July, maybe April's a little early. We certainly would be more than happy to at least update the commission on progress, say in roughly July. Just pick that number, pick that hearing. We did that when we presented the report to you a few months ago, noting how many inspections had been completed in the few months since the report had been issued. So let us do that. Let us tell you where we are with some of these policies. I think by then, I'm confident by then we will have rewritten the conductor setting policy, and we can have that conversation. We can talk about how many inspections we've gotten under our belts in that meantime, and look at some of the other things we laid out there and give you a report on where we stand.
Okay. Commissioner Benton, we still have a few minutes left on commissioner comments, so take it away.
Okay, Enrique, I don't know if I can run this from here or not.
I don't know what this is.
In spite of, it's supposedly a mouse, even though it doesn't have a tail. So we can, assuming I can close that out. And bring up some photos. So last week, we've talked briefly about some of the issues with some of these large volume gas producers that have been drilled and completed on the western slope. Came pretty close to home last week. We drilled and completed a number of wells out near the Quebec last year, and we have a limited amount of processing capacity. So some of these wells get shut in for a period of time, and then they're brought back on production. This particular well was on our Homer Deep 911 pad. This is the 911A well. Been shut in for, not sure, but at least a month, perhaps a bit longer. When we brought it back on production, it brought up some sand along with the gas. And the sand went to the gas production unit, proceeded to cut the choke, which is, you can see that right in here. It cut through the choke, and then the gas stream went more or less at this elbow and cut the elbow out. And so we had an accumulation of gas, which mixed with the air on the surface, eventually came into contact with the burner and the fire tube and caught on fire. So we had a fire. We estimate that the total length of time the fire lasted was, in the more or less uncontrolled flow, lasted about 3 hours. The well estimated flow rate during that time was up to about 14 million cubic feet a day, about 1,600 PSI, so fairly substantial rate. About 900 MCF, the estimate, we worked with the BLM, the estimate was about 900 MCF was actually released during this period of time. There was no explosion. Another lease operator saw it, phoned it in. The fire chief was notified about 6:20 in the morning. By 7:30, we had the well shut in and the fire was out. As soon as we closed the well in, the fire went out. But certainly something worth considering, and we've talked about some of the safety procedures that perhaps we should look at for some of these large volume wells. We're going to take some steps as an operator to change how we set these completions up to minimize the risk of this happening again. I wanted to show you a couple other pictures quickly, and then we'll move on. And I'll reopen for questions as well. So these are the three separators. This is the 911A separator over here, the B and the C. Well, so you can see the last one is potentially there's some salvageable equipment off of it. This is actually steam. It's not fire. That's steam left over because the ground got heated and it's still wintertime out there. And I'll hit two more. This is the liner under the tank was damaged, so likely when we go back and replace this, we're going to have to replace the liner under the tank. And finally, we had some damage to the pit netting, so we'll have to do some repair work on that as well. So just thought it would be something worth bringing the attention of the rest of the commissioners to know that this occurred and give you a little bit of background information about it, and I will answer any questions.
Any questions?
So do you have any idea what created the issue at the choke in the first place?
Yeah, the sand,
The sand.
the frac sand flowing back. And so the well had been flowed back and cleaned up. We'd already flowed it back, cleaned it up, gone through the production testing period, and then we shut this pad in to produce some other wells through our gas plant. It's not our gas plant, it's actually Summit's gas plant. So when we cycled back to bring these wells on, they brought this well on, and it came on
brought back some more sand.
And it brought back some more, and it probably flowed at a rate higher than what we expected. These are actually turned out to be rather nice wells. You know, if it was $4 gas, we'd be quite happy. $2 gas, we're not so happy about the rate. But it came on a bit stronger, so when you think about that sand, it just works like a sandblaster and cut that choke out.
So maybe opened up some other cracks that hadn't cleaned up yet.
Could have something else that happened there. So, you know, notionally, you'd add a second choke at the wellhead, perhaps an automatic valve at the wellhead to shut the well in if it senses successive pressure drop across the wellhead to shut the well in automatically. Notionally, you got to it pretty quickly. This location is, I think it's 15 or 20 miles outside of the town of Quebec or something like that, but you could see the flare. It was pretty obvious. It was a pretty good sized flare. But we did get it under control quickly. Nothing got off location, didn't set fire to anything else. But you know, nevertheless, it's something that we need to continue to be aware of as operators here in the state. We're going to continue to drill these Mancos horizontal wells. I don't think a lot will happen right now given the current price of natural gas, but eventually that price will come back and people will go back to drilling these wells.
Okay, thank you for that report. I want to make just a real brief comment. I had the pleasure of attending the University of Stanford's Natural Gas Initiative project, and it's very, very interesting. I really enjoyed that, and I've given some of the information to Mr. Lepore for his review, and I actually would encourage any oil and gas companies that might have any interest in that, let me know, and I'll tell you about it, because I think it's a fairly worthwhile project that the university is doing. Okay, with that, we'll close commissioner comments, hopefully, and move on to audience. I'm sorry, Director.
Forgive me, Mr. Chairman. Commissioner Holton is in, and he just emailed me a question that would be for Commissioner Benton. Would you mind?
No, not if it comes from Commissioner.
Not at all,
Holton, no.
particularly from the mayor.
So the mayor asked Commissioner Benton if a downhole shutoff valve would have stopped the situation on your pad there. We think that is a possibility, and we have investigated that. We believe the estimated cost to install downhole shutoff valves somewhere in the $20,000 to $30,000 range on a per well basis. So we are looking into that as a possibility instead of either retrofitting these wells or making that a part of our completion procedure for future wells. And can I ask, for my own edification, would the trigger for that shutoff valve have been the change in pressure inside the well once that hole developed?
More or less. So if you think about the way those valves work is that they measure the pressure drop across a slight restriction in the tubing. And that pressure drop increases as flow rate increases. So it's set up to where if that pressure drop gets to a certain amount, you can actually, the new ones I think you can actually set those stops and measure that. And if you measure that pressure drop, that goes above a certain rate, the valve will close and shut the well in.
This is like an offshore.
Essentially, it's a
Yeah.
surface controlled subsurface safety valve. Yeah. So that's, we've had these offshore for, I don't know, 30 or 40 years. Yeah. I worked offshore as a kid in college and we had those at that point in time. So I think that's, it's a technology we could bring onshore and potentially apply these to some of these bigger volume wells.
When you were in college?
I was. That was a long time ago.
That is ancient technology.
It is.
Okay, anything else, Director?
Thank you, Mr. Chairman. No.
Thank you. Ms. Murphy, do we have audience comments?
Yes, sir, we do. We have seven?
7,
Seven.
all on different subjects.
I believe that 5 of them have coordinated to not give repetitive comments about the same topic.
Okay. Okay, we're, as you're all well aware, have a full agenda. So how about we set a 3-minute limit for comments? And for that group of 5, I think you said, I'm going to just assume you've kind of coordinated that. And we can probably do all that in the 3-minute, not all 5 of you in 3 minutes, but concise as possible. Okay, first comment comes from
Mr. Lowell Lewis. And Chairman, he previously provided a handout to me, which I'll pass out to commissioners.
Thank you.
Does it matter which table?
Whichever mic works.
So the front side actually is my comments if you choose to follow those. And the back side is a map of the project site with buildings marked that are within a 1,000-foot buffer zone. I would first of all like to make note of the fact that I am from Greeley, which is in Weld County, and on behalf of a lot of people in Weld County, I'd like to give you a virtual hug. And you. They don't speak for all of us. Good morning. My name is Lowell Lewis. I'm a retired civil engineer and registered professional engineer. But when it comes to oil and gas issues, I am a 4-month-old newbie. I'm here to speak in opposition to the Triple Creek Directional Oil and Gas Project proposed in the city of Greeley by the applicant, Extraction Oil and Gas LLC of Denver. Since Greeley's 1992 state Supreme Court loss regarding its ban to drilling within city limits, it has virtually opened its corporate arms to embrace all applicants. Known to some as Colorado's most fracked city, Greeley is certainly among the friendliest, witness the more than 450 wells within the city boundaries. And yet, the City Greeley Planning Commission recently rejected the Triple Creek project in a unanimous 6-0 vote, certainly a first for Greeley. The operator has appealed, and we will meet with the City Council tomorrow night for their final verdict. We citizens in opposition to this huge 22-well project understand that oil and gas is an integral part of the Weld County economy and a necessary component of our national energy policy. But this proposal has several issues. First, Extraction committed in September of 2014 to go tankless. Now they not only want to install 22 permanent tanks, they also want to install 2 or 3 modular large volume tanks, which radically changes the proposal provided by the staff here. Indeed, the correspondence from the commission staff to the operator states that a new application would be required if the project intrudes into a buffer zone. Second, Form 2A was approved on the operator's assertion that no residential building unit is within 1,000 feet of the project. We now have received independent analysis that recent modifications to the site design makes that not only not true, but also makes this proposed site a UMA. With 22 wells and 22 hydrocarbon tanks, this would certainly be a large UMA site where the new regulations you recently adopted in effect. In fact, it is over 2.5 times the size requirements of a large UMA. Tomorrow night, the Greeley City Council will render its decision. One requirement for granting Form 2A was that the operator be required to obtain a special use permit from Greeley. If the City Council rejects the permit, as we hope, we humbly ask that you enforce your stated requirement and reject the approved Form 2A and the pending Form 2s for failure to obtain the required permit. Mr. Chair, I'm about 90% of the way through. Thank you. If Greeley does approve the special use permit, as we fear, we ask that you take the following steps. 1, reassess the siting of this proposal to verify that it is now, in fact, in a UMA, and if it is, to reject the approved Form 2A as inaccurate and require a new application. 2, require the operator to make a robust and intense search for an alternate site, several of which appear to exist in agricultural areas nearby. We believe it is the duty of this commission by established regulation to ensure that this is the best, if not only, site from which to recover these minerals. 3, attach a BMP requiring pipelines to be used to remove the product from the site as per the operator's original 2014 commitment. And 4, due to the size and location of this site, require that all enhanced mitigations and best management practices approved in the latest rulemaking be applied. Thank you for the opportunity to speak before you. If you have any questions, I will attempt to answer them.
Thank you, Mr. Lewis. Are there any questions?
If anyone wants to chat with me during breaks, or I'll be here up until lunch as well.
I guess that was a hint then about the break.
Yeah, no, it's your call.
Thank you very much.
Thank you.
Mr. Arrington? Sure.
You bet.
Commissioner Benton, can you? Thank you, sir.
Good morning. My name is Doug Saxton, and I am the co-chair of the Battlement Concerned Citizens and a resident of Battlement Mesa, an unincorporated community of 4,500 people near Parachute. I'm here this morning to ask the Commission to strictly interpret and apply the large UMA facility rules to the 52 gas wells that are being proposed on 2 locations within our PUD. The vast majority of folks in our community think that URSA should have the minerals it wants, but keep its distance. I was informed by mail several years ago that a different operator would be drilling from about 4,000 feet away directly under my home. While it didn't happen, this would have been entirely acceptable to me. The fact that drilling from 4,000 feet away is technologically feasible makes it all but impossible for me and my neighbors to believe it has to place its wells less than 1,000 feet from homes. To operate at a distance is the least invasive way to access minerals from beneath a residential community. Distance alone would mitigate every complaint we have, from health risk to abundant noise and odor nuisance to visual impacts. Battlement concerned citizens were involved in the most recent rulemaking. While we were very disappointed that the rules were not more broadly applied, they do apply to Battlement Mesa. URSA is proposing a 25 well pad and a 27 well pad within an urban mitigation area. Battlement Mesa is the first place that the new rules will be tested. The rules require operators that want to have large UMA facilities to demonstrate that they have analyzed all other more remote locations from which the minerals can be accessed. URSA must make every effort to find locations farther away from homes. If locations farther away from homes are not possible, residents are relying on the COGCC to use its resources and expertise to identify the best available technologies that will mitigate impacts to residents to the maximum extent achievable, as required in the new rule. Battlement Mesa residents and Garfield County lack the expertise to know what technologies are best and what level of mitigation is achievable. URSA has stated that the 52 wells will be drilled and completed within 3 years. For the scores of residents that live in homes and apartment buildings within 1,000 feet of these locations, those 3 years could be like an eternity. Thank you in advance for your assistance and oversight on this issue.
Thank you, Mr. Saxton. I want to ask a question. I don't know if maybe council or Director Lepore, these new rules were just passed last month of January. When do they go into effect? How does this impact Panama Mesa project, for example?
Thank you, Mr. Chairman. Actually, I apologize. I meant to mention that during my director's report. The new rules will take effect on March 16th. However, we did something a little bit unusual or out of the ordinary from the past by making it explicit in the rules that the best management practices that you adopted would be applied to any application pending when you approve the rules. So those requirements under the new rule that pertain to best management practices, et cetera, do apply to the Ursa location, and staff has been very actively engaged with the location. We have a meeting scheduled with the operator here in a couple of weeks or so to talk about that, and we've been engaged with the citizens on their concerns as well.
Thank you for the clarification. Thank you again, Mr. Saxton.
Always a bit more difficult to get all set up here, but I do have some slides here for you. So, my name is Bob Arrington. I'm a registered professional engineer in the state of Colorado, and I wanted to thank the commissioners this morning for hearing us. I'm a resident of Battlement Mesa, and of course there are plans to drill right in our PUD right through the center. I would remind the commission here that the welcome statement of the COGCC website states that the Colorado Oil and Gas Conservation Commission is charged with fostering the responsible development of Colorado's oil and gas natural resources in a manner consistent with the protection of public health, safety, and welfare, including the environment and wildlife resources. Our agency seeks to serve, solicit participation from, and maintain working relationships with all those having an interest in Colorado's oil and gas natural resources. This slide shows an incident on the tanks in Greeley near the airport, and we do notice a tank flying probably over 300 feet in the air. Ursa, the drilling company, has not complied with its obligation to pursue other sites further away from homes in accordance with the COGC Rule 604 C2E. The phase one of their plan to drill is on 2 pads. Later, they have planned 3 more pads to complete removal of all the minerals within Battlement. Over 25 wells planned to be drilled from each of these 2 first pads, and with storage of over 9,000 barrels, not counting separators, and over 11 homes and apartment buildings located less than 1,000 feet of these pads, these proposals are the first large UMA facilities to qualify under this new task force rule recently adopted. As such, Battlement concerned citizens and myself are hopeful that you will direct the COGCC staff to thoroughly examine these applications to require robust alternative site analysis from Ursa and add necessary permit conditions to assure the protection of the public health, safety, and welfare of all the Battlement Mesa residents. As an engineer, I do not like stating problems that do not have solutions. However, I have offered a solution to Ursa. And with that, on the handout papers, I would have you look at the attachments of email exchanges with Mr. Don Simpson of the Ursa, the vice president. And I have given him charts that show him how with drill reaches of 65-degree and 60-degree inclinations as offset reaches, I've given him a drill chart that reaches of reaches on a pattern plot to show coverage to downhole location bottoms that they need. I've also shown him a USGS map of potential basement faults in the area because their future plans include injection wells. And I've given him a mudslide inventory map that was neglected in all their preseason work and submittals to the county. And
Mr. Erickson, you're out of time. Now, can you conclude fairly briefly?
right, I was right to the summary statement here, if you will. In summary, Ursa could drill from the outside of the PUD and use existing pads that are already in place. And that would further mitigate the impacts on the health, safety, and welfare. In doing so, they would eliminate a pipeline cluster within the PUD, cutting through the middle of the PUD. The pipelines are planned to go down a hillside, and like the one that was destroyed, the WPX had, rain induced a landslide in that same material and caused that fire. So with that, I would like to take questions or.
Okay, thank you very much. Director Lepore, do you have this information available to you and your staff? If it's of any benefit, perhaps when you meet with the company?
In comments, I have sent in even a further extensive package on this.
Okay, thank you very much. We appreciate that. Okay, now we're up against the wall on time, so if the remaining folks that are going to comment on Battlement Mesa and that project will be as brief as you possibly can.
I'm Leslie Robinson, Chairman of the Grand Valley Citizens Alliance, and I'd like to address Comprehensive Drilling Plans Rules 216. To appreciate the enormous cumulative impacts of Ursa's proposed activities in Battlement Mesa, the current and future applications should be looked at in the context of a Comprehensive Drilling Plan, CDP. Although a CDP is a voluntary action, the development in and around Battlement as a UMA should trigger an obligatory comprehensive drilling plan. Citizens deserve some indication how long and where additional drilling will occur near and in their neighborhoods. In addition, the CDP should encompass the location of the pads, tanks, injection wells, disposal facilities, and existing wells and infrastructure. Take into consideration the scope of the current project, including future development and how it will impact residents for years. For their county and COGCC applications, Ursa had to develop a traffic management plan indicating future injection wells, an emergency plan, noise and abatement response, etc. And yet the most important information to citizens, where will the remaining 10 pads be developed, have not been requested. A CDP would alleviate much of the citizen uncertainty. Ursa's current applications plus their future development within the PUD will contribute significantly to impacts that have already been experienced in the Battlement community by existing projects as indicated by this map. Ursa's application should be considered in the context of cumulative impacts of all current and future development happening within and outside Battlement Mesa PUD. Facilities proposed in Battlement Mesa cannot and should not be considered in isolation to others. A comprehensive drilling plan should bring a proper perspective to the current and future permitting decision for all UMAs. Thank you.
Thank you very much, Ms. Robinson.
My name is Betsy Leonard, and I'll be speaking about the nuisance of noise and odor. Now, I have lived in Battlement Mesa, Colorado, in the Willow Creek Village since October of 2005. Over the past 3 years of operation, URSA has had difficulty in reducing noise and odors on its well sites located outside the PUD, but still within hundreds of feet of homes and apartments. Many of our residents have made complaints over the years, although not all have been captured in the COGCC database, as many people have been told to call URSA's employees rather than filing a complaint with the COGCC. Based on this experience, it is evident that better technology needs to be deployed, especially if the new pads will now be within the community boundaries. Noise has been the subject of repeated complaints from people living as far as 2,000 feet from URSA pads, existing URSA pads. Sound barriers have been ineffective for many residents. Property owners have complained that they could not entertain people on their deck because they cannot hear over the den. People have been awakened repeatedly during the night. Others have not been able to hear their TV. Due to these many incidents, I doubt that the conclusions offered by the sound study will reduce the noise to appropriate residential levels. I am particularly concerned for homeowners directly above the B pad. Even sound engineers have stated that this will be a difficult situation to mitigate. Noise regulations must be strictly enforced by the COGCC and penalties leveled for every day URSA is out of compliance. We do not want the current situation to continue where a sound complaint is made and temporarily resolved and then happens again without any repercussions. URSA is not given any incentive to create long-term solutions for the long duration they will be occupying our community. Similarly, odor regulations must be strictly enforced by the COGCC and penalties for every day URSA is out of compliance. Odor complaints have also been pervasive in Battlement Mesa. Results from well pad episodic events have ranged from persisting eye irritation, nose irritability, and unbearable odors inside a home. As a solution, URSA has offered to put people up in a motel until the event is over. Our residents would rather be able to live in their homes without fearing for their health. What is needed is the best available technology to eliminate these impacts. We look to the COGCC and the CDPHE for your expertise. If carbon blankets, pressure control, and adequate seals do not reflect the best technology, then other technology should be deployed. As with noise and based on URSA's performance to date, I have no confidence that these stress-inducing occurrences will not be repeated for years to come. Thank you for the opportunity to address you.
Thank you, Ms. Leonard. We have another from this group that Leslie's going to really bring all this together.
I would just like to summarize very quickly, again, by saying that this is, we believe, the first UMA large-scale application to go before the COGCC under the new rules, and we all spent a lot of time working on those rules, and although we may have some differing opinions of where they ended up, we do appreciate the changes that were made, and the Battlement Concerned Citizens and Grand Valley Citizens Alliance are coming to the table in good faith, trying to work with those rules, and we just, you know, we know how hard everybody worked on them, and we hope that everybody embraces this opportunity to show how these rules can work on behalf of impacted people. So thank you very much for this opportunity to speak to you today.
Thank you very much. Excuse me, Ms. Murphy, you have another audience commenter.
I do, and I believe it's our final public commenter, Mr. Simpson.
My name is Don Simpson, and I'm the Vice President of Business Development, Land, Regulatory, Environmental for URSA Operating Company. Appreciate the opportunity to speak today. One of the things that's not been told here, and there's a lot of things not been told, but there was a resolution in 1981-82 period that set up this development, this planned unit of development for oil and gas operations. There's an SUA in place. The SUA has been there for many years. It started with 14 pads. It was reduced to 10 pads. Now it's 6 pads or less, and that's on using better technology and moving away from the PUD as much as we can. URSA has held many regular meetings with public meetings, and also I've had one-on-one meetings with everyone who spoke today regarding this thing. The resolution, was a good county process. The county had a lot of foresight, Garfield County did, to put this thing together. It consists of not only public meetings that we had meetings specifically, public meetings to talk about why we couldn't drill 8 miles away. This is Williams Fork production. It's not Niobrara production. We can't drill horizontally to capture the hydrocarbons. It starts with a planning commission, Garfield County Planning Commission meetings. They had public meetings, had on-site meetings, 6+ hours of testimony from everyone in the community that wanted to have a say. It resulted in a 6-to-1 vote. Some of the comments, you can go online and listen to the Planning Commission commissioners' comments. Said we went over and above the regulations. We have many best management practices in place. We have 46 conditions of approval that go way above the state's regulations. After we went through that process and the 6-to-1 vote, we went to the county commissioners, same process, on site, 3 solid days of 12-hour+ comments that were exhausted, resulting in a 3-0 vote in the favor of the permits from the county commissioners. With regard to some of the comments today, it's hard for me to believe them, that some people can say that. I implore you to talk to Kirby Wynn, the Garfield County Oil and Gas Liaison. We've been above board in all of our operations. We're doing all this prior to the rulemaking. We don't believe these 2 pads should be under the UMA. None of the people here that talk today are within 1,000 feet of either of the pads. In fact, we have successfully operated the Monument Ridge pad, which is closer to any house than any of these 2 pads, except for 1 trailer. And it's been successfully operated, and we're reclaiming it now. We're starting the interim reclamation. I don't know what else I can say, but how many bites of the apple can they have? We've had public meetings, planning commission, county commissioners, and we still meet with the community. We have a meeting scheduled for next week, actually, next week. So I don't know if you'd have any questions about our pads. I'd be happy to answer them.
Okay, thank you, Mr. Simpson. Have any questions, commissioners? Again, thank you, sir.
I believe that concludes public comments.
Okay, on the advice of, I don't remember, Mr. Lewis or Mr. Saxton, I think we're going to take about a 10-minute break, and then we'll reconvene here at about 5 minutes until 11. Okay, we're ready to reconvene. I was anticipating a motion to go into recess to hear the sheriff's retirement remarks, but I didn't hear one, so I guess we'll just go on with Peyton Manning. Today. Okay. Consent agenda. So as usual, I think we will hear the consent agenda together with the exception of the enforcement orders by consent. So do any of you need to
Recuse.
politely recuse yourself from consideration of any of these items?
Mr. Chairman, if I may?
Please.
Thank you. I will need to recuse myself from several items on the agenda today. In Group C, docket 1601000036 and 1603001114. And in Group E,
Yep. Delta.
Delta.
Echo.
Echo.
not Delta?
No, nothing in Delta. And in Echo, it's docket number 1601000028.
Ms. Murphy, did you write those down? I didn't get them, so you'll pull those separately.
It's everything in Charlie and the second one in Echo.
Any other
Thank you, Mr. Chairman.
Recusals? Okay, hearing none, let's consider the remaining items, excluding those mentioned by Commissioner Spielman at this time.
So absent those, I would move approval of the balance.
We have a motion for approval of the consent agenda with the exception of the items listed by Commissioner Spielman.
Second, Mr. Chairman.
And a second. Any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, same sign. Motion carries. The three items that four items. 1, 2, 3, 4. Okay, 4 items. Commissioner Spielman listed.
Move approval for those items.
Second.
Mr. Chairman.
Motion and a second. Any discussion? Those in favor indicate by saying aye.
Aye.
Opposed, same sign, and they stand approved. The enforcement items. Okay, what's your pleasure?
Seeing no concerns about recusal, I would move approval of the enforcement items.
Okay, motion to approve the enforcement items.
Second.
And a second. Any discussion? Hearing none, those in favor indicate by saying aye.
Aye.
Opposed, nay. Those stand approved. Okay, SWN Production Company, LLC's unconventional resource units. Ms. Dorancy.
Good morning, Commissioners. Jill Dorancy, Hearing Officer. This matter comes before the Commission for a semi-annual review on the unconventional resource units. On March 25th, 2013 and October 28th, 2013, the Commission approved a total of 18 unconventional resource units for Axia Energy and pooled all interests within each unit. In September 2014, SWN Production acquired Axia's interest in the unconventional resource units. Since that time, 5 of the units have been vacated and 13 units remain. This presentation serves as a review required by Commission order of the units. SWN will provide a presentation on the status of the units and expected development. A memo dated January 22nd, as well as the supplemental letter dated today has been provided to you for your review. Additionally, a 510 statement has been provided by the Rollins Investment Company. Cindy Bargel, as counsel for the Rollins family, is also prepared to supplement the statement presented by the Rollins Investment Company. At this time, SWN will begin its presentation.
Welcome, Mr. Jewell.
Thank you, Mr. Chair, Commissioners, Director. Thank you very much for your time and making time for this report today. And also want to thank Jill for her professional and efficient handling of this matter. And it's Ms. Bargel and her client as well. My name is Michael Jewell. I'm shareholder, head of the Oil and Gas and Minerals Department at Burns, Figa, and Will, representing, say SWM, but they pronounce it Twin, of course, Twin Production Company, a wholly owned subsidiary of Southwestern Energy Company. Since last time I was at this table in July, we had a list of to-do items, including updating the status of our permits and the status of the URUs, following up on a promise to consider the termination of other URUs that may not be slated for development in the foreseeable future. Most, if not all, of those items were taken care of. A few caveats. Number one, you did vacate one of the URUs in orders 5, 40, 27, and 39 in the January hearings. Mr. Rancy is correct. We are down to 13 with one URU under production from one well, so leaving us with 12 that are lying dormant. Since July, we have been in discussions with the Rollins Investment and Mr. Harold Rollins and his sister, who, by the way, I want to thank Lorraine for driving all the way from Salt Lake City here. We really appreciate the dedication that they've shown to their minerals. Since July, unfortunately, the environment has only worsened. But I hate to just stand behind prices. It almost sounds cliche that, well, prices, we can't develop, we can't drill. But I think, unfortunately, at this point, there's really no other reasonable suggestion. Thankfully, we're up 27, 30% in the past few weeks, so we'll continue to cheer that on. But the foreseeable future, things are not looking too well to develop in the Sandwash Basin. You may recall, if you keep up with industry news, at the time when I submitted the January 22nd report, which is in front of you and I believe was in January as well, Southwestern commenced their second round of layoffs, totaling over 40% of their staff in the United States, mostly based out of Houston. There is a silver lining. They did retain a healthy portion of their land team, including our Sandwash team. So I sit before you today representing that should that time come, we're ready to develop. All other financial options are indeed on the table at the moment. We reported to you earlier with a written report that we were looking for joint venture partners, but now any financial solution is on the table. However, prices rebound, we're still there, and we still want to honor our obligations not only to the Rollins family, but to all stakeholders. I want to take a few minutes, though, to recognize what the Rollins stated in their 510 statement, which, again, I thank them. I thank Harold for generating that response and appreciate greatly the openness with which we are able to communicate through counsel and also with himself. But number one, they had a concern about the release of the lands that was stated in this 510 statement. They thanked Southwestern for releasing lands upon request, had some concern about the titling of those lands moving forward. We will certainly be speaking with them to ensure that all industry standards are maintained and it's absolutely clear which of their lands remain under lease and which are not. We want them to have that level of comfort. There was a statement about control of the units. Now, I do want to be clear that Southwestern recognizes that when it purchased the assets from Axia, it inherited the obligations that came with the lands, and which is why I'm here before you today. And Southwestern intends to continue to honor those duties and commitments. However, that does fall short of full control of the unit. We no more own that unit than any other operator would own their drilling and spacing unit. Don't get me wrong, we'd love to be the operator that opens up this whole basin for development. But as of now, technically, others who are an owner, as defined by the rules of this commission, can submit their APD and develop as well. But I do want the Rollins family to know that as long as we are the owners of these lands, and hopefully things continue, hopefully that will be us. Thankfully, with the downturn lasting so long, we don't need to see $100 oil like we used to have. That number will be lower. We just don't know what that number is right now. And lastly, the Rollins desire a commitment and a plan for development, particularly for the one Bulldog unit that is producing. And this is a conversation I've had with Ms. Bargel several times, and we understand their concerns, most notably that when the URU is developed, I believe their chief concern was dilution within those immediate lands. However, that dilution will be mitigated through the drilling of, say, 8, a dozen or more wells. I'm not sure what Axie had promised at the time, but you know, dilution but more wells equals a net outcome. But we have 12 URUs. We have at least 3 larger drilling and spacing units that fall short of URUs, but have important stakeholders as well, including the federal government and the state of Colorado. So as soon as those prices recover, we will be able to gauge which of those units receive that priority. If and when that unit is the one, the Rollins family can be assured that we'll give them a good faith drilling plan. So to conclude, I hope for your mutual patience and understanding. I mean, you, the commission, I anticipate working with Jill and even Jane Stancic continually, and we'll owe Jane and Jill an updated spreadsheet for all our permits in the unit this week. Also with all stakeholders, not only the Rollins family and other protesting parties, but also with the local government and any questions and concerns they might have. I continue to be retained by Southwestern despite the inactivity in the basin, so questions can be directed to my attention. So with that, thank you very much for your time, and I'll be happy to address any questions or yield to Ms. Bargel. Thank you.
Michael, does the company you represent have a number in mind for the price of the product to make it economically feasible to go in and?
If you could accept an informal number, you know, as we just chit chat on the phone, for instance, that number would be similar to what the Wattenberg would suggest. And if I could be so bold to say crossing that $50 threshold would be great, crossing 60 would be happy. Somewhere in there. Now consider though, if you would, that this is the same, geologically the same Niobrara, a little thicker, which I understand can be exciting, but there's not nearly the amount of infrastructure that's in the Sand Wash Basin as there is in the Greater Wattenberg area, as you would correctly assume. But to say that we can compete at a relative price point, I think says a lot for my client's desire to get back in and develop.
Thank you. Any questions for Mr. Jewell? Okay, I think if Ms. Bargel is willing to come forward, and I'm sorry, I jumped in front of you.
No, I've already spoken. But
Good morning, commissioners. Good morning still. My name's Cindy Bargel. I'm here with Harold Rollins. I'm going to let Mr. Rollins speak first, and then I'm going to fill in a couple of gaps on the URUs and just some of the continuing questions that we have with respect to their ongoing existence. And so I'm going to let Mr. Rollins start, and then if you'll indulge me just a minute or two, I'll follow up.
Okay. I'm Harold Rollins. I've been here before. I'm still very concerned over these units. It's been 3 years and we have no rules on how they are to be, developed. I'm in favor of these larger units because of, certain circumstances we have, like in Moffat County with the sage chickens, we can develop things, what they can do. But we need to sit down
and come up with some fair rules so they are developed in a timely manner instead of one well sitting there holding them indefinite. It's not fair to the mineral owners, in whether it's there or anywhere in the state. And I would appreciate if, sometime we could get a commitment, we could work on some rules. Thank you.
Thank you, Mr. Rollins.
And that was certainly well put. And I'm just going to follow up. It's been suggested, and I understand with the pricing, that there are significant issues with respect to going forward with development. So here's really my questions with respect to these existing URUs. When they were approved, there was no plan to say what had to happen in a URU to continue it in existence. It's been 3 years, many of the permits had expired, and it's not just about reporting and it's not just about dialogue, although we really do appreciate that very much. But the question is, even with these other 12 existing URUs, let's say they decide to drill one. Okay, well then you're going to be in the exact same spot with a producing URU with a single well or maybe two without knowing what has to happen with those URUs on a going forward basis. And so even though Southwestern might be the only game in town right now, and Mr. Joe was entirely accurate that someone could come in and lease, they would still be under that particular URU and the pooling order if development were to occur. And so that would temper someone's view, I believe, of the area and what they might want to do to develop, although I can't speak for a developer. I don't know what the solution is with respect to how you say development should occur. URUs work perfectly in some areas. This is unfortunately one of those where you have a test case where all the things that you didn't want to see happen probably have happened with that single producing URU. And so the question is, what's going to be different with these other 12? Even if they keep them in existence, if they continue to examine, if they decide to drill a well here or there, how is that development going to occur consistent with what you guys look at with respect to fostering the reasonable development of oil and gas in this very unusual circumstance? And again, we appreciate Southwestern. There may be somebody else out there that has another idea, but we also think that it may, in this instance, be incumbent upon the commission to look internally at whether these URUs should continue to exist, or maybe they should be terminated. And we do go back to the drawing board if someone comes in with an idea in the area, instead of having these lingering units that unfortunately they have to come in every 6 months and say, we're sorry, we can't do anything. After a while, the question is, what will be done? So again, thank you to Southwestern. They have been very open, great with dialogue, but we're asking for action. We're asking for action on the Bulldog. What do you see happening on that particular unit, or what should happen on that unit with respect to development? And we're asking for action on those 12 other units, other than let's let it play out, because playing out means leases are expiring, permits are expiring, new ideas can still come from Southwestern, but they don't necessarily have to be under Axia's old framework. Thank you.
I apologize for my ignorance. Is the Bulldog producing?
Yes, it is the one producing URU out of 18.
Any questions?
A comment, I think, and I'm not sure what the current Bulldog well is producing, but in reading through this material, I was mindful that it appears that the Rollins family agreed to see their royalty diluted for future potential in that one particular producing URU, I think, which does make some sense if there's some plan out there for the future. Even with federal exploratory units, once you get your paying well determination, you've got up to 5 years and you have to go drill something else, or else the unit starts to contract. So we're sort of open-ended, and then we're also sitting with 12 others in which no work has been done. And in a federal unit, sometimes you can get some extensions, for some mitigating factors. but never more. And, this has been, what, 3 years now, I think, something like that.
3 years for some and 2.5 years for others.
Yeah. So you sort of get to the spot where perhaps we ought to look at terminating all the ones that don't have anything drilled. And let's go back to the drawing board and look at that. And then it gives, it's not a great time. And it may be that there are no other companies out there willing to come in and lease, but you sort of have this overhang of this going on. If I was coming in to look at that area, I would say, well, I've got these URUs I have to deal with that are set in place with an existing operator, and that may just complicate it more. And maybe it would be better off to say, let's terminate these. Prices improve, you could always come back and reapply. And I know that costs a bit of money to do that, but it was good to hear that Southwest thinks $50 to $60 oil sort of gets us there. That's good. I'm glad that they gave us that range. But when do we get there? Is it going to be another 5 years? I don't know. Yes, ma'am.
With your permission, Commissioner Compton, I appreciate what you're saying about the existing URUs. And again, termination may not be the best solution for anyone. I mean, I understand that should be examined, but the other option would be, well, if they're going to stay in place, then what are the rules with respect to how someone would come in and actually develop them and get the work done out there? Because that's the other part that's open-ended. They just exist. And so, if there was some confidence that yes, someone would come in and do the work, including Southwestern, who again has been very open, that would be great to know. It's that uncertainty of they're unusual and they exist, and what are we going to do with them?
Yeah, and I'm very sympathetic to Southwest's position. It's just, this is not a time to be drilling exploratory wells. Unfortunately, most of us in the industry are not doing that. And even in the development area, you look at the Wattenberg, I think it was mentioned in the paper the other day that I think Anadarko's budget is reduced to $500 million from $1.3 billion last year. So you don't want to penalize them for taking that on and then suffering with the current price. But I agree with you, to not sort of have it open-ended. It's as if there's not a commitment to do something, then these units shall terminate. The model to me, again, is the federal exploratory units, in which once you form one of those, you have a time frame in which you have to conduct some activity. And if you don't conduct some activity, then the units dissolve. And that's sort of the opinion. We're at 3 years now, and sort of what's next?
Are you? Well, I don't want to interrupt.
No, I'm at a bit of a dilemma. I mean, it just, to me, I think that we should look pretty seriously at terminating at least some of these units at this point. And I look to the rest of the commissioners and even Ms. Durancy and Mr. Jewell to provide some input, as well as you, Ms. Bargell. Sort of, I'm kind of curious about what the Rollins family thinks as well.
We realize at this time, because of the prices and that, no, things aren't going to happen. What we would like is things put in place. So down the road, if you don't do these things, there's a penalty. And maybe I don't have a total solution to it all. Maybe it's going to have to be contracted. I don't know. But when we start doing that there, everybody in these units shares in this well where it's at right now. We start cutting people out, I think we're going to create a mess too there. Could be. I don't know.
I guess my only concern is I'm not sure what our authority to require development is similar to the federal unit obligations, because the federal unit obligations have the federal government as the royalty owner, so they kind of make that part of their obligation to maintain their leases. And I I kind of feel like that we need some other input on whether or not we have that kind of authority. I do think we probably have authority to contract the unit to the portions that are at least producing, contributing to protect correlative rights. So I think we might be a little bit limited in what our options would be, other than either to terminate the units if they don't produce within a certain amount of time, or contract to what is producing in order to protect relative rights.
I'd have to agree. I don't think we have, I mean, I have to look to some experts, but I don't think we have the ability to mandate you have to drill it. Because we're still treading new ground, but potential for contracting the unit exists. And say, well, let's contracts. Again, federal as a model contracts to your producing area. And then you have these, and then
maybe the director might have thought about this a little bit.
When we
throw him under the bus.
when we establish these unconventional units, excuse me, one of the reasons we ask for a company to come in periodically and tell us what was going on, what progress was being made, because we had some concerns that progress would be made. And I guess those are realistic. You have some thoughts, sir?
They're not profound, I assure you. But to Commissioner Hawkins and Commissioner Benton, I will say that I think no question that you have authority to dissolve the units or reshape the units, clearly. I think concepts like setting milestones and imposing penalties for failure to meet those are much less clear as far as the ability to do that. I suppose if an order along those lines was proffered and the operator consented to the terms of that order or agreed to the terms of that order, that would probably hold up as a binding agreement. But yeah, I was just reflecting kind of in my own mind, this came to pass 3 years ago when the landscape was wildly different in terms of prices and prospects and developing and wildcatting. And we did put in place this annual review process exactly so we could see the large acreage positions here, in my own mind, only make sense if they are being developed. You are impacting correlative rights if only one well is producing and the owners of those minerals are sharing it with people quite a ways away, with a long horizon for sharing in the production of the adjoining minerals. I don't think anybody here could answer the question. If you dissolve the units, is anybody going to step in and drill? I wouldn't hold my breath, not at today's prices. So, I mean, if staff, the hearing officer have brilliant insights, I invite them to speak up as well. I can see, certainly appreciate Southwestern's position, and they have always been transparent with us as well. It probably is of some value to them to have these URUs in their portfolio. I think we have to ask the question of whether it may serve as a slight, but perhaps not inconsequential, deterrent to another operator thinking about this area and this acreage. I can't answer that question, but I think it has to be posed. And none of this may really matter on the ground for the next 6 or 9 months.
If I have a question for Mr. Joel, within all I think you said, I believe there's 1 active, 12 inactive URUs. Is that correct?
Yes, sir.
Do you have within each one how much acreage within each one Southwest has currently leased?
We do. We maintain a spreadsheet that I believe Ms. Stancic developed, and that's the spreadsheet I indicated that we will have completely updated by the end of this week. And the way that spreadsheet is oriented is they're ranked by the ones that have the highest working interest in downwards, because of course you could argue with some success that the higher the working interest in Southwestern, probably the relative priority therein.
Certainly. So there are cases where that URU essentially has leases in which Southwest does not have an interest. And does that spreadsheet also include sort of when all those leases start to expire?
It does, and the communication Cindy has indicated is that we're watching the ones that are set to terminate and trying to make sure that we do right by them as far as releasing lands where appropriate, or even discussions for releasing at appropriate time. Releasing, sorry.
Understood. So maybe there's some middle ground there where the ones in which they hold a majority interest get retained and ones that have a smaller interest get terminated. I'm sorry I sort of jumped in here again because I know you have some other comments.
Yes, sir. If I may continue. We're still keeping an eye on among the 12, as things continue to cinch in and get more difficult, which can we release and let go? And I will continue to advise my client that we should keep looking at those 12, particularly ones that don't have the right permits in place or the ones that are showing the most age. It makes sense and it respects the landowner. And I think to your point, Director, if I might, I think it's a good point, possible deterrence. However, we have shown a willingness to release URUs so far, and as I indicated, we'll continue to do so. My concern, speaking on behalf of Southwestern, and possibly, I don't speak for other operators, but possibly the industry at large, so were the commission to move toward terminating these units, that creates a little uncertainty as far as decisions that are made. I understand these were made at probably URU's infancy, if not the very first infant, and perhaps they're better off and running now, or perhaps now 3 years in, we have a better way to devise future URUs. But we have these today. So I implore you to reconsider before thinking about terminating, because that does inject some uncertainty, which perhaps other lawyers in the room would agree. We don't need that kind of uncertainty right now, that if we create something with you, that it could be subject for revocation at some time. And because these are a hybrid, if you allow me to consider URU a hybrid of a traditional drilling and spacing and a federal type-ish unit, that federal unit is probably the best idea that we have, the best industry experience we have. And as was already indicated, you drill that first, you get your PA, you have 5 years continued development. Not suggesting we want to wait 5 years. However, that is an industry norm that at least in the Western United States, we feel and understand. So I think movement toward termination would be premature. Thank you.
Let me clarify one of the things. Once you form that federal unit, and I don't remember the exact, but I think you have 180 days, you have to drill a well. So you have less than a year that you have to drill a well. There are 12 of these that are now been 3 years with no activity. To me, that's a concern for the relative rights for the mineral owners there. Yes, ma'am.
If I may, and again, I don't disagree with what Mr. Jewell is saying and the question about certainty. The issue that the Rollins have placed before the commission several times is, to the extent you continue the units in place because of the analysis and to add to the certainty, it would be very helpful to avoid the situation that exists on the Rollins URU, to have a better understanding of what the expectation is for those continued URUs. And maybe it is some sort of obligation to terminate if it's not developed within a certain time, if you're looking at your jurisdictional authority and think it's limited in that way. All we're trying to say is evaluate, analyze, but please, if they stay in place, help us, and I don't know the solution, but help us avoid having the same problem on the next URU that you have on the Bulldog URU. And it might take sitting down at a table and analyzing what potential rules would go along with, say, extended URUs, honestly. But again, we're just saying it's uncertainty on both sides. Where is some middle ground to me?
Director.
Thank you, Mr. Chairman. Ms. Stanzik has set me straight on this, I think, important point. Any mineral owner within the URU could come forward at any time and ask you to modify that URU, that order. So in terms of a deterrent, as long as they understood that they had that right to come forward and say, listen, you know, we're thinking about drilling here, but we don't want the 1280 or the 2560 or whatever's been created. They have that right. To address, I think, Ms. Bargel's question about could a URU order mandate some kind of continuous operations, my belief is that you do have the jurisdiction to impose that kind of a requirement, that an initial well must be drilled within X period of time, a subsequent well must be drilled within Y period of time. I think, you know, we'd want to run that to ground a little bit, but my hunch, my instincts are that you would be well within your authority to set forth those kinds of requirements.
And the penalty, so to speak, would be we could terminate that.
Terminate it, shrink it.
And that is correct. If a mineral interest owner is unleased, they would have the ability to do that. Least mineral interest owners can't, so they're silent on that because that's the extent of their authority. But really what you're doing is asking people who, as these leases expire, to understand, first of all, what a URU is, which I think a lot of us are only beginning to understand, and then saying, well, as a mineral interest owner who doesn't have a lessee in place, we want you to come before the commission and ask to vacate this URU because it hasn't been developed. And respectfully, not every mineral interest owner travels from Salt Lake City to come to a hearing or would understand that that is what they have the ability to do. So while that's a solution that a mineral interest owner could come before you and ask to vacate this URU, I think it's in practice something they other than perhaps the Rollins family, you won't see. That this is a creation of the commission where they're looking for these being utilized for the responsible development of the mineral resource, and the question is that happening?
Okay.
Thank you.
Any other comments? Questions?
I guess the question is, should we modify the existing orders to put some kind of a obligation or time frame on maintaining the URU?
Absolutely. We could ask staff maybe to look into that. We could ask staff maybe to engage with SWIN. Was that happening?
Flint Production Company.
To see if there's possibility of the company voluntarily allowing some of these units to go, some of the ones that you see less potential for than others. Whatever discussion they could have to see if there's something we can do to help facilitate the timely development of these minerals. I don't know. Is it something staff would be willing to do, able to do?
Absolutely, Mr. Chairman. I think we can set up a meeting with SWIN, relatively short turnaround time here, and try to get a better understanding of what their desire is to keep these in place and have some understanding. I mean, they may have a much better crystal ball than I do as far as what the future holds.
And if it's not inappropriate, I would encourage you to invite Ms. Bargel into that conversation seems like a smart lady, may have some ideas.
Whether
outside the box.
it's one conversation or two, we'll make sure that we understand Ms. Bargel's thoughts.
Okay, Pam.
Thank you. And I failed to say that NARO too continues to watch this. Just, it probably goes without saying. So, thank you.
And you and NARO have a job in front of you to educate your members about these.
Yeah. I would like to ask Mr. Report, if you discuss these things and come up with some ideas and as you progress along, I would appreciate it if you would keep us informed. And I know Moffett County would like to be informed. Me and the recourse officer over there, we communicate quite often. And he's more or less on the same page I am. If they aren't being developed, there's no wells in them not being developed, let them go. So somebody else can come in and lease them or whatever, But if like ours, we're already got a well, we need something so we can continue to get it developed. And I'm hoping, like everybody else, the prices will come back. And until they do, I realize we're not going to get something right now. But when they start, we ought to have something in compliance somewhere where we can do.
Moffett County has a designated liaison already in place. Okay. Okay, thank you all very much. Any final thoughts?
Just one.
Maybe three, actually. Maybe three.
First, maybe three.
I'm sorry I asked. Okay, let's start.
If you don't mind, I would just like to see the staff maybe come back to us at the time I'd like to hear what the conversation was like and what their recommendation would be, and then maybe give the commission an opportunity to weigh in on whether or not we should put some kind of obligations in these URUs and use that as a model for future URUs.
Commissioner Spielman.
Yeah, I was going to ask the staff, I don't entirely understand what our decision space is here on this issue. And maybe that's something when this issue is brought back before the commission, we could spend just a little bit of time on, please. Thank you.
And I agree with Mr. Spielman because I'm not sure exactly what we can or cannot do. I would think that we could on our own essentially make a motion to terminate those units, but not quite yet prepared to do that. And like to see what other options we may have. And I think with the staff, if we could get some guidance on, say, maybe it's two things. One is you have a unit where you have one well. Currently, Mr. Rollins' interest in that particular well, if it was just that one well on that lease, he'd have a higher royalty income. But he's holding out for some future opportunity for other things. So maybe there's something to address what URUs with an existing well for timely future development or contraction, and those that don't have any activity over a period of time for a time frame for termination.
And we have met previously with the Rollins family, and we've asked Southwestern to update the spreadsheet that we prepared for them to include the information regarding the leasehold interest of the Rollins family. We do have information regarding which units have active permits and which ones have inactive or expired permits for the commissioners, but we can provide that to you at our next review, or we can do that at the next hearing if the commissioners would prefer.
I'd appreciate just having the spreadsheet by the next hearing. It'd be great.
Certainly, we'll have that for you.
Commission's all right with that? Okay. I get the impression that Mr. Jewell and his company wants to do the right thing here. And so we certainly look forward to your conversations. Okay, thank you very much.
Thank you.
Okay, we'll proceed to enforcement hearing matters.
We will.
I'll let you introduce them. I can't pronounce all the numbers.
That's very gracious, Chairman. First up, we have docket 1603-00095 against Rancho Trace, operator number 73372, Mr. Davenport is the staff's representative on this matter, and my understanding, which may have changed over the weekend, is that Rancho Trace will not be participating.
I'm sorry, that your last statement was they would not be here to, okay.
Good morning, Commissioners. Kyle Davenport, Assistant Attorney General, appearing on behalf of staff. Appreciate the introduction from Ms. Murphy. As far as I know, it's correct that Rancho Trace is not appearing here today, and this is a default. However, I received communication from the surface owner where this well is located last week, and they were unclear with me whether or not they'd be wanting to appear and make a statement. So at this point, I'd like to see if the surface owners, the Savage family, any representative of the Savage family is here to make a statement. Okay.
I don't see Roy out there, and
And it was Roy who might have been, Roy Savage might have been appearing in front today, but doesn't look like they're here. So I realize that we're running significantly behind our schedule, and this is a default. I am prepared to give a presentation to commissioners if they'd like to hear some of the background and facts here. Otherwise, staff does request that the commissioners enter staff's proposed order. It's in page 9, starting on page 9 in your packet there. It's up to you, whatever you'd like me to do.
I don't know what the commissioners want here. I know we are in a time bind. You being an attorney could, like, I've heard there are briefs. I don't know exactly what they are, but if...
I will endeavor to be brief. This is a domestic well. It's located in Garfield County. You can see the yellow pin up there is exactly where that well is located. I've got a couple of pictures. They're in your packet as well. The pictures are on Bates labeled numbers 7-9 and 8-9. As I said, this is a domestic well. It's operated in the commission's records by a company called Rancho Trace. This well was spud in 1961, and according to commission records, it has never had any production reported and has never had an MIT performed on the well. As far as we can tell, Rancho Trace is defunct. It is not an entity. It is a trade name of an individual, Dr. William Haynes. We have no good contact information for Rancho Trace or Dr. Haynes. We have sent multiple communications to the address that is on file with the COGCC. That's where the notice of hearing went. Notice of hearing was also published in the Denver paper and Garfield County paper as required by rule and statute. And so service of the notice of hearing is effective. The surface owners and the surety in this case received notice of this proceeding. And procedurally, a pre-hearing conference was held on February 18th. No one other than staff appeared at that pre-hearing conference. Hearing Officer Bach issued an order at that pre-hearing conference directing for any objections to the relief requested by staff to be made by 5 p.m. on February 24th. No objections were received, and as you know, no one from the surety, the landowner, or Rancho Trace has appeared in front of you today. I'm going to, unless you have specific questions about the timeline and when attempted communications were made, as you can see on the slide in front of you, multiple letters were sent to Rancho Trace. 2 inspections were also done at the end of Feb 2014 and September 11, 2015. Those inspections indicated that this well is probably abandoned. It appears to have been shut in. We can't see any power lines, flow lines to the well, and you can see just based on the condition of the well and the pictures, it doesn't look like a lot's going on out there right now. I will go to the requested relief. As you can see in the proposed order, staff is requesting, in effect, that we have the authority to foreclose on the $5,000 bond that Rancho Trace has, the financial assurance Rancho Trace has with the commission, as well as to take any other actions necessary to plug, abandon, remediate this well site. That hopefully was brief enough to satisfy you.
That was exemplary.
Thank you very much. And if you have any questions, I'm happy to answer them. We also have Ms. Martha Ramos here who can answer your questions. She was the staff member who was communicating or attempting to communicate with Rancho Trace, and she can give you more information.
So your intent is to plug and do full reclamation?
Our intent, staff's request right now is intended to get the authority to foreclose on the financial assurance and do whatever it deems necessary to do in the future out there. I don't believe staff has any specific plans for this well in the short term.
Okay, commissioners. Any questions, comments, motions?
Chairman, if I may,
You may, sir.
I would make a motion that we enact the orders as per spelled out by the staff. And I can go through and read those if you wish.
No, I don't wish. I think we have those on record.
Yes.
Yes, I believe that's correct.
So, as written.
Second.
Motion and a second. Any discussion? Further discussion? Hearing none. Those in favor indicate by saying aye.
Aye.
Aye. Opposed, same sign. So that request is approved. Thank you very much.
Thank you.
I suppose we could always refer some staff to you occasionally for lessons on.
I think this is my only opportunity so far, so please don't hold me for that in the
Excellent.
future.
Okay. Next item.
Chairman, next up is a consolidated hearing. There are 3 separate docket numbers that have been consolidated to allow a single presentation by the parties and hopefully avoid some degree of repetitiveness to the commission. Those docket numbers are 1510-00676, 1601-00078, 1601-00079. These are against CM Production, their enforcement hearings. Hearing Officer Jim Rouse, I think, will start by giving an overview of how these 3 dockets came before you to frame the conversation. At that point, staff will take over. I presume at some point the commissioners will get hungry and want lunch, so let us know when that time is.
Okay. Mr. Rouse.
Thank you, Mr. Chairman, Commissioners. This matter is before the Commission today for a hearing on CM's application filed in docket number 151-000-676 and a mandatory order finding violation hearing in each of the 3 cases. The cases have been combined for purposes of hearing in order to save time and make for a more efficient presentation, and for purposes of taking one deposition of Mr. John Teff, the business manager for CM, instead of deposing him 3 separate times. While the evidence the staff will present varies from case to case, the Rule 510 statement on behalf of CM are the same in each case. Rather than have the Commission sit through the 510 statements 3 times, the decision was made to consolidate the 3 cases for hearing purposes. You will still need to decide each case independently, and I believe there will be one order that encompasses your decision in the 3 cases. And frankly, it'll be much easier for you to take them one case at a time, and I think that is probably how the presentation is going to be made. There are 7 pages of stipulated facts for the 3 cases that were previously provided to you as attachment number 2 to the staff's pre-hearing statement. The Commission is bound by these factual stipulations, and they should be treated as findings of fact by the Commission. The first case is docket number 151-000-676 in the matter of the application of CM Production regarding the disposition of order numbers 1V412 and 1V413 and withdrawn docket number 1505-00143 regarding alleged violations of the rules and regulations of the Colorado Oil and Gas Conservation Commission, Jackson County, Colorado. This case has been before the Commission before at its special hearing in November of 2015. As you may recall, at that hearing on September 11, 2015, CM filed an application for a hearing and asked the Commission to allow CM to do the following. First, present evidence and arguments relating to corrective actions and environmental improvements made to date in the Lone Pine Field in Jackson County, Colorado, under order numbers 1V412 and 1V413, which were issued in 2013. They asked to be able to present evidence and arguments regarding the substantive and procedural issues raised regarding a certain 2015 AOC and subsequent demand letter sent by the Director for payments due under order numbers 1V412 and 1V413 and the subsequent withdrawal of the 2015 AOC by staff. They ask you to vacate the Director's demand for a penalty assessment under the demand letters. Finally, CM asked that the commission approved the 2015 AOC entered into between commission staff and CM. This AOC was previously presented on the consent agenda for the commission's May 2015 hearing. The matter was withdrawn from the consent agenda and continued to the commission's July 2015 hearing. Prior to the July 2015 hearing, staff withdrew its request for approval of the 2015 AOC. Staff responded to CM's application with a motion to dismiss filed on October 9th, 2015, and at the November 2015 commission hearing, oral argument on the motion to dismiss was presented by the parties. The commission decided on a 7-2 vote to deny the motion to dismiss and have a hearing on the merits of the application, hence we are here today. On December 3rd, 2015, staff filed its protest claiming the right to withdraw from the 2015 AOC prior to it being approved by the commission, and that the 2015 AOC was therefore null and void. Staff asked for the application to be denied. Staff also in this case filed a notice and application for hearing alleging violations of orders numbers 1V412 and 1V413. Staff is not seeking penalties for those alleged violations. The disputed issues in docket number 151000676 are as follows. Whether CM's application should be granted, which entails approval of the 2015 AOC and withdrawal of the director's demand letter, or whether the application should be denied. Second issue is whether CM violated commission order numbers 1V412 and 1V413. Third issue, whether the director's demand letter should be upheld. Fourth, if CM violated order numbers 1V412 and 1V413, whether CM has any valid reasons or excuses for failure to comply fully with order numbers 1V412 and 1V413. Fifth issue is whether CM's financial condition is a mitigating factor in the violations alleged by staff and or the corrective actions requested by staff. And finally, what if any corrective action should be ordered by the commission? The second case is docket number 16010078 in the matter of the alleged violation of the rules and regulations of the Colorado Oil and Gas Conservation Commission by CM Production LLC in Jackson County, Colorado. In this second case, staff alleges violation of Commission Rule 326B for failure to conduct mechanical integrity tests on 5 wells in Jackson County, Colorado. Staff seeks an order requiring CM to perform the 5 mechanical integrity tests and penalties totaling $327,630. The disputed issues in docket numbers 16010078 are as follows. Here, ordinarily, whether CM violated Commission Rule 326B for failure to conduct mechanical integrity tests on 5 wells in Jackson County, Colorado would be a disputed issue. However, in this case, stipulation paragraphs 24 through 45 show that MITs on the 5 wells at issue were required but have not been performed. So the issue then becomes whether CM has any valid reasons or excuses for failure to conduct the mechanical integrity tests, whether CM's condition is a mitigating factor in the violations alleged by staff, the penalty proposed by staff, and or the corrective actions requested by staff. You also need to decide what, if any, penalties should be imposed by staff and what, if any, corrective actions should be ordered. In the third case, which is docket number 16010079, in the matter of the alleged violations of the rules and regulations of the Colorado Oil and Gas Conservation Commission by CM Production LLC in Jackson and Washington counties, Colorado. In this third case, staff alleges violation of Commission Rule 707A for failure to provide additional financial assurance for 23 shut-in wells in Jackson and Washington counties, Colorado. Staff seeks an order requiring CM to provide additional financial assurance in the amount of $210,000 and a penalty of $64,510. These disputed issues in docket number 16010079 are as follows. Whether CM violated Commission Rule 707 subparagraph A for failure to provide adequate financial assurance for the 23 shut-in wells in Jackson and Washington counties, Colorado. If you find that CM violated 707A, whether the additional financial assurance sought by staff is calculated accurately. If CM violated Rule 707A, whether CM has any valid reasons or excuses for failure to post the required additional financial assurance. Fourth issue is whether CM's financial condition is a mitigating factor in violations alleged by staff, the penalty proposed by staff, and/or the corrective actions requested by staff. Lastly, you must decide what, if any, penalty should be imposed by the commission and what, if any, corrective action should be ordered. The exhibits admitted for this hearing are set out in the final consolidated pre-hearing order entered in this case on January 25, 2016. These are the exhibits proposed by staff. Benchmark did not propose any exhibits or witnesses. CM did not propose any witnesses. Originally, CM was represented by attorneys in all three cases. Subsequently, on January 7, 2016, the attorneys filed a motion to withdraw from all three cases. On January 11, 2016, the hearing officer granted the motion to withdraw. CM is a limited liability company with one owner. It is not currently represented by an attorney. On January 15, 2016, the hearing officer entered an order regarding representation by CM. I can go through those orders in detail, or we can suffice it to say that CM is required to have an attorney represented if it wants to introduce evidence or cross-examine witnesses. No attorney has represented has entered an appearance saying they are representing CM, and no attorney appears for CM today. Therefore, on behalf of CM, Mr. John Teff, the manager for CM, may make an oral Rule 510 statement at the hearing under oath and subject to cross-examination. So he will be sworn like any witness and subject to cross-examination, but he may not cross-examine other witnesses himself or introduce exhibits. Mr. Teff has already submitted a written 510 statement, which has been provided to you. Mr. Anthony Martin, a royalty owner in the Lone Pine Field, also submitted a 510 statement on behalf of CM. Pursuant to the order regarding unopposed motion to consolidate issued on February 9, 2016, written Rule 510 statements were required to be filed no later than February 19, 2016. There are two written 510 statements that were included in your portfolio for these cases. The written 510 statements were filed late and are not notarized as required by Rule 510. However, you may, at your discretion, accept the statements and give whatever weight you deem appropriate, giving due regard to the fact that the statements are not under oath and are not subject to cross-examination. Staff has been allotted 2.5 hours for its presentation, including opening and closing statements, its case in chief, rebuttal, and cross-examination. Mr. Teff will have 45 minutes to make a 510 statement. These times are exclusive of commissioners' questions and parties' responses to those questions. The case presentation at hearing should proceed as follows. First, a determination of whether any commission members have a conflict of interest. Any preliminary matters that need to be brought up, of which I am not aware of any at this time. Any opening statement by staff for all cases that will be made by one attorney on behalf of staff. And you will have presentation by staff in docket number 151-000-676 with Ms. Beckstead as counsel for staff. You will then have the presentation by staff in docket numbers 1601-00078 and 00079 with Mr. Davenport as counsel for staff. Then it would be appropriate to hear the oral 510 statements. Then there will be rebuttal presentation by staff, a closing statement by staff, again with one attorney making the closing statement, and then the closing of the record. You will then need to make a finding regarding CM's application in docket number 150000676 and whether it should be granted and the 2015 AOC reinstated. If the commission denies CM's application in docket number 151000676, you need to make a finding regarding whether CM violated order numbers 1V412 and 1V413, and if so, a determination of whether the director's demand letter should be upheld and the corrective action required, if any. Then you should make a decision regarding docket number 1601-00078, finding that CM violated Commission Rule 326B, and a determination of the corrective action required and the penalty imposed, if any. And finally, regarding docket number 1601-00079, whether CM violated Commission Rule 707A, and if so, a determination of the corrective action required and penalty to be imposed, if any.
Okay, Mr. Rouse, I'm going to have to depend upon you and Ms. Murphy to keep us on track, which comes Next.
Well, I think at this point in time, it's appropriate for you to determine if anybody on the commission has any questions about what we're doing here. And otherwise, it's time for a determination of whether any commission members have a conflict of interest in this case and need to recuse themselves.
Okay, let's do that.
Okay?
Questions? Any recusals? I am going to suggest that before we get into the heart of the matter, we go ahead and take a lunch break. Is that unreasonable, Ms. Murphy?
Not unreasonable in my mind, sir.
Well, Mr. Chairman, if I might, would the commissioners like a paper copy of the stipulated facts to have in front of them, or are you okay with your computer copies?
We have electronic, or I have electronic. I guess we all have electronic copies, probably suffice.
Okay.
I'm sorry.
I only might have a paper one just to make sure that my electronic version is accurate.
A belt and suspenders guy, I appreciate that.
Well, I will go to my electronic copy and print you a paper copy then.
Okay, without objection then, Ms. Murphy, let's take 30 minutes for lunch. I know that kind of crowds some of you all, but it'll be good, just trust me. So we're going to get cranked up here again at pretty close to 12:30. the delay, I made an error in judgment. We had lunch scheduled for 12:30. So we didn't have any lunch when we showed up at 12. So what may happen here, I hope what happens is we're going to get a bite of lunch and maybe eat while we're listening. And Ms. Schwal has promised watch out that we don't ask questions with a full mouth or anything. So I'm guessing as soon as Commissioner Spielman makes it back, which will be any moment, we'll go ahead and reconvene. And then probably be a good idea right after we reconvene for Mr. Randall to confess. Okay. We're ready to.
Excuse me, Mr. Chairman, thank you.
No worries. I was just waiting on Enrique. Okay, we'll reconvene our hearing. Before we continue on, Mr. Randall has a proposition.
So, thank you, Mr. Chair, and we discussed this on the break. I apologize to the parties. I need to step out for a conflict. I will be back before CM Productions provides its 510 statement, but I do want to get on the record that I've reviewed the materials in dockets number 151-000-676, 160-1000-78, and 79. I'm familiar with the staff's pre-hearing statement. I'm familiar with the undisputed facts and the disputed issues. So I do feel comfortable having reviewed those materials, stepping out for just a bit and returning in time for portions of the presentation that I haven't seen. So we'll be back for that.
Thank you very much, and council concurs that's appropriate.
It's fine.
Thank you. Okay. Do we, shall we just go ahead and swear in?
Sure.
You gentlemen don't mind doing whatever she says.
Chairman,
I don't know if they want to do that.
I'm sorry, ma'am.
we also swear staff's witnesses.
Yeah, we can swear everybody in all together. So, would everybody who's going to testify in this matter, please stand so we can see who you are. And raise your right hand and repeat after me. I swear or affirm.
I swear or affirm.
That the testimony I'm about to give.
Testimony I'm about to give.
Is the truth regarding the matter in this proceeding.
Is the truth regarding the matters in this proceeding.
Thank you.
Okay. Now, staff is going to present. Remember, you promised to keep me on track. Staff is going to present their case, and
I think they'll start with an opening statement and then launch into their case in chief.
thank you. Well, welcome, Ms. Beckstead.
Thank you, Chair. Good afternoon, Commissioners. Britta Beckstead, Assistant Attorney General and Counsel for Commission Staff in docket number 1510-00676, which we will refer to as the environmental violations. I'd also like to introduce Kyle Davenport, Assistant Attorney General and Counsel for Commission Staff in docket 1601-0078 and 79. We will refer to those as the MIT violations and financial assurance violations, respectively. You should have a packet of materials at your seats, which was handed out to you before the break. And in that packet is a map of the location, an exhibit to a revised order that lays out staff's claims and requested relief, and the revised order itself. Staff submitted this revised order for a variety of reasons, which I'll explain a little bit later in the proceeding. And there's also a hearing portfolio index with Bates reference pages to the exhibits in case you need to figure out where anything is. Okay, let's dive in after you've had a chance to look at those briefly. Mr. Rouse had described before the break how we got here, but why are we here? CM has had at least 3 opportunities in 3 years to show it can remediate the Margaret Spalding location. During this time, the only thing that it has proven is that it cannot fulfill its obligations or meet its chosen deadlines. CM also has had 3 chances to show it can comply with the Commission's mechanical integrity and financial assurance requirements, but has done nothing. CM has had 3 strikes. The majority of the times today for staff's presentation will be spent on the environmental violations. The environmental violations encompass CM's application, which is asking you to approve the 2015 AOC and vacate the director's demand for payment, as well as staff's application for a finding of violation that CM failed to decommission pits 4 and 5 by November 1st, 2014. These 3 issues, staff's application, CM's application, are all linked because they involve CM's compliance with orders 1V412 and 1V413 at the Margaret Spalding location. Staff will also show that CM violated the Commission's mechanical integrity testing requirements at 5 wells and has not even attempted to correct these violations almost a year after the warning letter was issued. Lastly, staff will show that CM violated the Commission's financial assurance requirements and has not even attempted to negotiate a graduated plan to post these funds. First, I'll discuss the environmental violations, the failure to decommission the pits, the 2015 AOC, and the demand for payment. These 3 issues pertain to the remediation of the Margaret Spalding location, which is shown here on Exhibit 3, well, an adaptation from Exhibit 3, and also provided as a handout. There are 5 former produced water pits, which we will refer to as pits 1 through 5, an overflow treater pit, and a large soil stockpile containing E&P waste at the location. This case began with 2 agreements, where the deadlines and terms were carefully negotiated by the parties. Based on these discussions, staff had the expectation that CM would follow through with the agreement and the hope that the Margaret Spalding location would be remediated within a reasonable time period. In 2014, staff granted CM's request for an extension with the belief that it would meet its chosen deadlines. CM did not. Instead, the likelihood that CM could meet its obligations under those orders slowly declined, culminating in a complete loss of faith after the 2015 May hearing. Here's a timeline of the important events regarding this location. In May of 2013, the Commission approved 2 orders, which were agreements between Lone Pine Gas Incorporated, CM, and staff. These orders are Order 1V412 and 1V413. They're also Exhibits 7 and 8, base numbered pages 243 to 258. These orders created obligations at the Margaret Spalding location for Lone Pine, and CM is its successor in interest. These obligations were treating or disposing of the soil stockpile pursuant to an approved Form 27 by September 1st, 2013, stopping the use of the produced water pits for produced water or other E&P waste by November 1st, 2013, decommissioning the pits to Table 910-1 standards pursuant to an approved Form 27 by July 1st, 2014, and continuing groundwater sampling. The focus today will be on the decommissioning of the pits and the remediation of the soil stockpile. In addition, under these orders, the $150,000 penalty was suspended, pending timely and satisfactory compliance with these corrective actions. The unsuspension of this penalty was tied solely to the director's discretion and his or her determination that the corrective actions had not been correctly completed. It is also important to note that Order 1V413 expressly states that CM made the business decision to accept the responsibility for cleaning up the site, even though it had not caused the contamination. This assumption of responsibility included accepting the director's discretion to unsuspend the penalty. In June of 2013, CDPAG entered into 2 orders with Lone Pine and CM. The first one we've referred to as the CDPAG and Lone Pine consent order, and the second as the compliance order between CM and CDPAG. These are exhibits 9 and 10, Bates numbered pages 259 to 278. The CDPHE consent order with Lone Pine references Commission Order 1B412, and in particular the decommissioning of the pits. This helps explain why CDPHE has been involved with the location and especially the 2015 AOC in particular. On June 25th, 2014, the director granted CM's request to extend the 2013 order's deadlines. These deadlines were extended to decommission pits 4 and 5 to November 1st, 2014, and to decommission pits 1 and 3 and remediate the soil stockpile by July 1st, 2015. CM's request is Exhibit 20, and the director's grant of that request is Exhibit 21 at Bates pages 352 to 355. On November 21st, 2014, staff issued an NOAV to CM for violations of the 2013 orders for the failure to decommission pits 4 and 5 to Table 910-1 standards. This is Exhibit 32, Bates pages 444 to 468. On April 24th, 2015, the 2015 AOC was signed as a proposal to resolve the violations alleged in the 2014 NOAV. It is Exhibit 37, Bates pages 507 to 513. On May 18th, 2015, the 2015 AOC was withdrawn from the consent agenda due to timing issues with CDPHE's Water Quality Control Division. The minutes from this hearing are included as Exhibit 42, Bates pages 558 to 559. On June 26, 2015, the director issued the demand for payment pursuant to the 2013 orders. The demand for payment unsuspended the $150,000 and required its payment, or in the alternative, the posting of a $75,000 bond and the negotiating of a new deadline. This is Exhibit 55, Bates pages 632 to 636. On July 8, 2015, staff withdrew its notice and application for hearing on the 2014 NOAV, which the 2015 AOC proposed to resolve. Today, staff will demonstrate that CM assumed these violations voluntarily, with knowledge of the site conditions and confirming that the deadlines were achievable. Staff will also show that CM failed to decommission pits 4 and 5 by November 1st, 2014, its chosen deadline, which will focus on the events leading up to that date. In addition, staff will show that CM has failed to make meaningful progress on the remediation of the location, in particular, decommissioning of the pits and the soil stockpile from 2013 to the present. It is important for this point to distinguish between CM's limited activities at the site with what was actually required by the orders and the approved work plans. This lack of meaningful progress became even more apparent to staff after the May 2015 hearing. As the proponent of an order approving the 2015 AOC and vacating the director's demand for payment, CM has the burden of proof to show that the relief it's requested should be granted. But CM does not have a legal or factual basis for its request. The law is clear that AOCs are not final until they are approved by this commission. And the director was authorized to issue the demand for payment pursuant to approved commission orders. However, today staff will also go into its factual reasons for withdrawing the 2015 AOC, as well as issuing the demand for payment. These decisions were the result of careful consideration, a clear analysis of the law, and new information that only came to light either shortly before or after the May 2015 hearing. For staff's presentation, this will focus on the events from the May 2015 hearing to the July 2015 withdrawal, which will include CDPHE's concerns. Staff will call 3 witnesses regarding the environmental violations today. First, Director Matt Lepore, who will provide the Commission with the context surrounding the 2013 orders, as well as provide an overview of the reasons why staff withdrew the 2015 AOC and issued the demand for payment. Second, Kelly Morgan, the Environmental Protection Specialist in the Water Quality Control Division's Enforcement Unit, will provide the context of CDPHE's orders with Lone Pine and CM, as well as CDPHE's involvement with the 2015 AOC. Lastly, Alex Fisher, COGCC Western Environmental Supervisor, will walk the Commission through what was required by the approved work plans and what was actually accomplished at the site from 2013 to present. This testimony, along with the documents in the record, will show that CM failed to decommission pits 4 and 5 by November 1st, 2014, that the 2015 AOC should not be approved, and that the Director's demand for payment should not be vacated. For the environmental violations, staff is requesting that you deny CM's application and find CM in violation of Orders 1B412 and 1B413. I referred earlier to a revised proposed order that was handed out to you today. And the reason that staff submitted this revised proposed order, was to create a second option for CM. Under this revised proposed order, CM can either pay the $150,000 and then complete the remediation by September 1st, 2016, or post a $200,000 bond and negotiate a deadline with staff. The reason why this was added was to mirror the demand for payment, which also offered this alternative. In addition, the revised order clarifies that it does not impact the deadline set forth in Order 1B412 and 1B413. In addition to the environmental violations, staff has already shown that CM violated Rule 326B at 5 wells by failing to perform mechanical integrity tests on them within 2 years of their initial shut-in date. The hearing officer has issued an order confirming that CM violated Rule 326B based on the undisputed facts. It is undisputed that CM was required to perform MITs on 5 wells in 2013 and 2014, and has failed to perform those MITs as of today, almost 2 years after their original due date. It is also undisputed that staff sent CM a warning letter 8 months before the NOAVs in this case were issued. Because liability is undisputed, staff will not be calling a witness regarding these violations in its case in chief. Staff is requesting a $327,650 penalty for this violation and performance of the MITs. This penalty was calculated pursuant to the Act, Commission rules, and the enforcement and penalty policy, including the application of the duration matrix. Staff gave CM the opportunity to avoid even getting to the penalty assessment stage in the process. In addition, CM also has had the continuing opportunity to perform the MITs and reduce the days of violation. CM has had 3 strikes: the original due date of the MITs, the warning letter, and the NOAV. CM did not perform MITs at any of these points in time, and the result is a significant penalty. Lastly, staff will show that CM violated Rule 707A by failing to provide the required financial assurance for excess inactive wells. Under Rule 707A, operators are required to post additional financial assurance based on a formula set out in the rule and depending on the number of inactive wells they have. It is undisputed that CM operates 23 inactive wells and has a $60,000 plugging bond. Martha Ramos, COGCC Financial Assurance Supervisor, will testify that based on the formula provided in Rule 707A, CM is required to post an additional $210,000 in financial assurance. It is undisputed that CM was sent a warning letter and given an additional 30 days to post the required assurance. It is also undisputed that CM did not and has still not submitted this assurance. Staff is requesting a $64,510 penalty for this violation, as well as the posting of the financial assurance. Again, staff gave CM an opportunity to avoid this penalty assessment, and CM has had the opportunity to perform the corrective action and reduce the days of violation leading up to this hearing. 3 strikes: the original due date, the warning letter, and the NOAV. To recap staff's requested relief in these 3 cases, for the environmental violation, staff requests that you deny the relief requested in CM's application, find CM in violation of the 2013 orders by failing to decommission pits 4 and 5 by November 1st, 2014, and require CM to either pay $150,000 and then remediate the location by September 1st, 2016, or post a $200,000 bond and negotiate a deadline with staff. For the MIT and financial assurance violations, staff requests that you find CM in violation of 326B and 707A, require the corrective action, and impose the recommended penalty. In each of these cases, staff has given CM multiple opportunities to comply. These chances have been ignored. If CM's excuse today is lack of funds or capability, then there is even less hope that they will be able to obtain these in the near future. This is why staff is unwilling to allow additional time without adequate assurance that any new promises will be fulfilled. If CM's excuse today is to blame staff, then it is time for CM to take some responsibility. The consequences for CM's inaction have been prolonged long enough. Staff, and likely this commission by the end of today, is out of patience. Thank you.
May we take 2 minutes? The lunches have arrived. My apologies for their tardiness before jumping into the case in chief.
Fine with staff.
That's okay with you guys. We'll just run and get lunch and come back. We'll be in a bunch. I can't guarantee. We won't be in any better mood, but. Okay, go grab lunch quickly.
What? Oh, right. Yeah, right. Now he doesn't. It's like your quality of life is gonna change too. You guys are operating with culture. We are. We used to get glorious box lunches when Mac had the executive assistant. Yeah, we started cutting back. Yeah, this is results of the cutback. We feel the pain. And chocolate chip cookies go in there. Yeah, there's a dog there.
I officially missed the other first time.
Right, right. It was bound to happen.
Turns out the hearing was on 7 o'clock.
Right, imagine. I hope you heard me say it.
Yes, it's
We got it all the way out there.
It's easy to do.
I think so. Do you want your lawyer? Here she is.
No, but that's why I'm trying to eat half a sandwich, so that's about 10.
Okay, Mr. Secretary, I think we're.
No problem. It's more a concern that our first witness is still chewing.
Ready.
Staff would like to call Director Matt Lepore. Director Lepore, could you please introduce yourself for the record?
My name is Matt Lepore. I'm the director of the Colorado Oil and Gas Conservation Commission.
And when did you become the director of the COGCC?
I became director in August of 2012.
Did you become involved with Lone Pines compliance issues at the Margaret Spalding location shortly after becoming director?
Yes, I did. In August of 2012, I attended a meeting at the Colorado Department of Public Health and Environment regarding discharges of discharges of water to the surface waters that contained hydrocarbons, including oil and other compliance issues related to pits on the Margaret Spalding location.
And what were staff's concerns regarding Lone Pine and the Margaret Spalding location at this time?
At that time or soon thereafter, we understood that the principal of Lone Pine had been killed in an airplane accident, that his successors in interest had no interest in operating an oil and gas operation, including the Margaret Spalding location, and that they were actively seeking an alternative, hopefully, and they were looking to find someone to buy the assets and operate them.
And when did CM become involved in staff's conversations with Lone Pine regarding the location?
CM entered the picture, to the best of my recollection, by no later than January of 2013. I am aware of meetings that were held between CDPHE and CM and my staff in January of 2013. Some of the commissioners will recall that we were in a rulemaking in January 2013 on setbacks. So I'm not sure I attended that January meeting. In February of 2013, I had a meeting with Mr. Teff, who is the principal of CM, regarding that potential purchase and sale transaction.
And what was CM's plan for the location?
CM's plan was to revitalize the location, to take care of the environmental issues that we made sure that they were aware of, and to increase production at the location, and fundamentally turn the site around into a viable, profitable, productive, and compliant site.
Did the conversations with Lone Pine and CM result in commission orders in 2013?
They did. I want to back up a little bit here, because I was aware of the environmental issues at the site. I was very concerned about a potential sale transaction. We did not want the state of Colorado, to be left holding the bag if the Lone Pine operators sold, got proceeds from that sale, and disappeared, if you will, in some way without taking care of the site. We understood that the site had environmental issues on it that occurred during Lone Pine's management operation of the site that likely ran into the multiple hundreds of thousands of dollars. We did not want Lone Pine to sell the site, walk away from those liabilities. We made that expressly clear to Lone Pine, and we said to them, we don't have a lot of good options here. Our best option is to impose a NOAV on you with a substantial penalty and have an order from the commission for a large penalty, so that if you get some proceeds from a sale, you're obligated to pay that penalty. They understood our concerns. These were frank but candid, fair conversations. But they were concerned that if we issued that NOAV, it would make it much more difficult for them to find a buyer, make it much more difficult for that transaction to go through. Then, as I said a moment ago, in February of 2013, Mr. Teff came and met with Assistant Attorney General Matter and I, and we explained again our concerns to him. And in that process, we explained very clearly the environmental issues at the site that we were aware of, the magnitude of those issues, the fact that the site needed to stop discharging from the ponds into these surface streams. They were in violation of CDPHE's standards at that time. Those standards are going to go down and get more stringent. CDPHE was concerned about how they would meet those more stringent concerns. And again, our concern that the state ultimately be left holding the bag for this liability. We discussed with CM and Lone Pine some alternatives. One alternative was an escrow account that, rather than hand the money over to Lone Pine, CM could put money in an escrow account that would be available for the remediation. We discussed a couple of different alternatives, but always with the idea of somehow ensuring that the state and the people of the state of Colorado were protected. Ultimately, Mr. Teff volunteered that they would sign an agreement pursuant to which they would be liable for the cleanup of the site and the penalties for an NOAV that was issued against Lone Pine. And so the combination of orders 1V412 and 1V413, which this commission approved in May of 2013, if I have my timing right, that's what those two orders accomplished. They accomplished a $150,000 penalty against Lone Pine, compliance deadlines for corrective actions, and then a separate agreement with CM, with John Teff, that they would pay that penalty or they would comply with those deadlines. Those deadlines were negotiated, not forced down their throat. Those were agreed upon deadlines that Mr. Teff and CM agreed to.
Or, you said that was an option. And or, I
pay the penalty? Who?
The intent, Mr. Chairman, was that they would do the remediation of the site. They would meet the compliance deadlines. If they met the compliance deadlines, the penalty was suspended in its entirety. So it was a $150,000 penalty suspended contingent upon the remediation and meeting those deadlines.
And Director Lepore, why was that penalty unsuspension left to the director's sole discretion?
I think there are quite a few reasons. I think the root cause goes back to the strong desire to protect the people of the state of Colorado. The second was that the commission had an opportunity to review that order, enter that order. The third is that it is staff who see the day-to-day activities, who's on the site, who does the inspections, and whose expertise certainly I rely on, and I think the commission relies on. So the order was drafted such that upon my determination that they were not meeting those deadlines, we could demand payment of the penalty.
Okay, let's shift to CM's extension request in 2014. Did CM request extensions of the deadlines in Order 1V412 in 2014?
Yes, they did.
And when did discussions regarding those extensions begin?
I recall a meeting with Roger Freeman, who is an attorney with Davis, Graham, and Stubbs, who was representing CM. Mr. Freeman requested a meeting with me in April. Let's double check. In April of 2014. And the main purpose of that meeting was to request an extension to some of the compliance action deadlines that were in Order 1V412.
And do you recall what CM's requested extensions were?
The one that I recall specifically, a request to extend a July deadline until November. So July 2014 until November 1st of 2014. That was to clean up pits 4 and 5, to decommission pits 4 and 5. Decommission meaning cleaning those pits up to table 910-1 standards. And I remember that in part because clearly in retrospect, they didn't ask for a whole lot of time. They asked for a matter of a few months, not a deadline imposed by us, a deadline requested by CM. The other extensions of time were for approximately 1 year, from July of 2014 to July of 2015, and that pertained, I believe, to other pits and maybe to the soil stockpile. I would have to refresh my recollection on the details of what those extensions were. I do know the time frame was the 1 year until July of 2015.
Did staff grant the extension to the deadline CM requested?
Yes, ultimately I signed an extension for the timelines as requested by CM till November 1 for pits 4 and 5 into July of 2015 for the couple of the other cleanup requirements.
And did CM comply with its chosen deadlines?
No, they did not. And well, I'll stop there. No, they did not.
Okay, let's turn to the events after the May 2015 hearing. Did staff meet internally regarding the 2015 AOC after the May hearing?
We did. Would you mind if I backed up and said why there was an AOC?
Of course, go right ahead.
CM missed the November 1 deadline, that short extension of time that they asked for. They failed to comply. So in late November, I believe the date was the 21st of November, staff issued an NOAV for that failure. That NOAV was resolved purportedly through an AOC, a new AOC. So this gets a little confusing, but now there's a 2015 AOC that has an extension time for the deadlines. That was scheduled to be heard by you in May 2015. Do I have my years right? In May of 2015. You will recall that Commissioner Walk asked that that be taken off the consent agenda because CDPHE had raised some issues. But we were there because CM missed the November 1 deadline, NOAV ensued, AOC ensued. Now we come to May, now we take it off, and now you can ask me that question again.
Did staff meet internally regarding the 2015 AOC after the May hearing?
We did. To be candid, we were a little bit embarrassed that we had failed to confer with CDPHE about that AOC. So that AOC granted an extension of time of 3 years for the compliance deadlines that had been negotiated back in 2013. Granted an extension of time out to 2018. We did not confer with CDPHE about that, and they were not happy about that. So first we met internally, just among staff, so that, quite frankly, I would have a better understanding of the status, the state of play, and because clearly we needed to get on the same page with CDPHE.
At that time, had staff heard anything about CM's environmental consultants?
My best recollection is that prior to putting the AOC on the May docket, we did not have, or I did not have information about CM's environmental consultants. But again, best recollection following in that first internal meeting, we learned that their environmental consultants had stopped working, that they had no intention to do additional work, and it was our understanding that the reason for them having stopped working was that they were not being paid for the work that they had done.
And did COGCC meet with CDPHE after the May hearing?
We did. We had a meeting here. Kelly Morgan, Ken Custer, and Mike Harris from CDPHE attended that meeting. Alex Fisher, Peter Gowan, and myself are those that I recall from COGCC who attended that meeting. That was just an internal meeting, again, for us to understand better CDPHE's concerns and really their overall sort of posture as it related to Margaret Spalding location and CM production.
And what was discussed at that meeting?
I think the main part of the discussion was the extension of the compliance deadlines. We certainly also discussed the status of the site and what was happening at the site in terms of advancing the remedial actions at the site. CDPHE, and you'll hear from Kelly Morgan later, but I will say that CM had ceased discharging to the surface streams. They had done that in late October of 2014. And in our minds, that was CDPHE's chief concern. So I think we felt that since CM was no longer doing that, CDPHE's issues had sort of been addressed. That turns out to have just been a mistake on our part. CDPHE had a separate consent order or compliance order on consent that was tied to our deadlines. It was tied to our reclamation compliance deadlines. So an extension of those did have an effect on CDPHE, and that was a focus of the conversation.
Did COGCC and CDPHE then meet with CM?
Yes, we did. Again, there was a fair amount of conversation at that meeting between CDPHE and COGCC as to the financial status of CM, whether it had a revenue stream. It didn't have a revenue stream as far as we knew. CM has never brought the wells at the Margaret Spalding location back into production, which was sort of the plan from the get-go, was they would bring these wells back on production. They have not done that to this day. So we were concerned that they didn't have a revenue stream. We heard that they were not paying their environmental consultant. There were questions about whether they were paying their attorneys. So we agreed, CPHE and COGCC agreed that the next step was to have a meeting with CM and talk about the compliance deadlines and the state of remediation.
And who attended that meeting on behalf of CM?
CM was represented at that meeting by Roger Freeman, who participated in that meeting in person, and Mr. Teff participated in that meeting by telephone.
And at that meeting, do you recall Mr. Teff making any statements regarding CM's finances?
Mr. Teff stated that the company was in dire financial straits. And an option that was discussed with Mr. Teff at that meeting was that they put some additional bonding in place, some additional financial assurance. Mr. Teff's response to that was, do you understand that that would be a cash bond? We said, yes, we do understand that. And he said, I cannot afford to pay a cash bond.
Prior to the May hearing, were you aware that CM was in financial distress?
Not to the best of my recollection.
And at that meeting, did you also discuss CM's failure to submit progress reports under the 2015 AOC?
We did. So there was this AOC that had been docketed for hearing in front of you that was taken off. The terms of that AOC included a requirement that CM provide us some reports. I think also that they do some sampling. Keep in mind that from our point of view, the corrective actions from the earlier ALC are still in play. Those that were due in July of 2015 are still in play. When we met with CM, which was June 10th or 11th, they had failed to provide the reports required under the AOC. And we discussed that with them. And they had not done any sampling that we felt also should have been done by that time. And we had that conversation with them as well.
What were staff's conclusions regarding the likelihood of CM's compliance with the 2013 orders as a result of these meetings?
Our conclusion, quite frankly, was that CM does not have the capability to comply with the 2013 orders, and that giving them additional time really was an exercise in futility. Mr. Teff had flat out said he couldn't afford to bond up. It was clear that there were issues paying their third-party vendors. The progress made up to that time on the remediation that had been agreed to in April-ish of 2013 was unsatisfactory. The site was not producing. There's no revenue stream. One of the key pieces to bringing the wells back on production was to get a UIC well in place. And Mr. Teff had gotten the UIC permit from COGCC. I think he thinks that that was an arduous process that took more time and perhaps cost more money than he expected. Nonetheless, he had a permit. They had spent money to get a pipeline in place that would deliver the produced water to the injection well. And yet, for lack of an electrical, I think transformer is what was needed, but basically in a lack of an electrical connection, they were not running the injection bit and the injection well. And without that injection well, they can't produce. So all of that, and there's one more piece to this, but all of that led us to the conclusion that granting the 3-year extension, certainly that was in the AOC, was futile. It was not what CDPHE wanted to see, and that kind of led to the next step, which was the demand for payment.
And when did staff issue the demand for payment?
The demand for payment was issued by me to CM on June 26th, so it's about 2 weeks after our meeting with them. One other thing that had happened in that intervening 2 weeks was that Alex Fisher had gone to CM to the Margaret Spalding locations on June 25th. I was kind of waiting for a report back from Alex. Alex's report was that virtually nothing had changed. There was no progress. I want to back up to one other part of the meeting. The meeting we had with Mr. Teff, we asked him questions about next steps and what was happening at the site and what the plans were. And quite frankly, Mr. Teff was at a loss. It was clear in my estimation that Mr. Teff didn't really know what was supposed to happen next at the site and whether it was or was not happening. So now Alex goes to the site on June 25th, reports back that little or no progress has been made. That, in essence, was the last straw for me. I issued the demand letter pursuant to the 2013 orders demanding that the $150,000 be paid. I did want to give, as I think is essentially our standard practice, an off-ramp, which would amount to one last chance. And the off-ramp was this. Under the order, we had the right to demand payment within 30 days. I extended that by about 2 weeks. I think I gave them 45 days. And I gave them the option of bonding up, as we had discussed in the meeting, $75,000 of additional bonding, and then sit down with us and negotiate an extended deadline. It wasn't going to be 3 years by any stretch of the imagination, but internally we had talked about the potential of a 1-year extension of time if they bonded up. I think the next question is, did they respond, or how did they respond? And the answer is they never responded to that demand for payment. No response whatsoever by the deadline.
And why has staff increased its requested financial assurance for the remediation of the location from $75,000 and the demand for payment to $200,000 in the revised proposed order?
It really all comes down to the same thing we started with in 2013, which is some protection for the people of the state of Colorado. And you know, $200,000 may or may not be enough, but in my mind, it's my personal opinion, it's unconscionable to allow CM to continue to operate this site without a significant financial assurance in place. And in reflection, $75,000 was not enough. $200,000 is a more appropriate number.
Let's turn to the 2015 AOC. When did staff withdraw its notice and application for hearing that led to the 2015 AOC?
I probably can't from memory tell you exactly the date that we withdrew it, but the time sequence was that Commissioner Walt took the matter off the consent docket. We had the meetings that I've just described. We came to the conclusion that we no longer supported that AOC. That AOC was a negotiated agreement between staff and CM. That's what an AOC is. When we agree, we put it in front of you for your approval. Until you approve it, it's just a negotiated agreement. We no longer supported that negotiated agreement, and we certainly do not support it now. So at some point, and I apologize, I don't have the date at my fingertips. Perhaps I can find it, but within a few weeks after issuing the demand payment or that their failure to meet that deadline, we withdrew the demand for payment, or withdrew the notice of hearing.
How did the withdrawal of the notice impact the 2015 AOC?
To our minds, the 2015 AOC is a nullity. It doesn't exist. You know, if you have negotiated a contract and before the contract takes effect, one party walks away from it, you don't have a contract anymore. Here, we negotiated that, we put it in front of you, you did not approve it, new information came to our attention that I've described here that we could no longer support that AOC. So by withdrawing the notice in our minds, it's a nullity.
In this case, did you know about CDPHE's concerns, CM's finances, and CM's default on the agreement before the 2015 AOC was placed on the May 2015 agenda?
Did we know all of those things before it was placed on the agenda?
Yes.
We did not.
And before staff presents assigned AOC for the commission's approval, does staff evaluate whether the AOC is in the best interest of the people of Colorado?
Yes.
And is that evaluation based on the information available to staff at the time?
Yes.
Does staff support the approval of the 2015 AOC today?
Under no circumstances.
Thank you, Director Lepore. Staff would now like to call Kelly Morgan. Ms. Morgan, could you please introduce yourself for the record?
My name's Kelly Morgan, and I work in the Water Quality Control Division at the Colorado Department of Public Health and Environment. I'm in the enforcement unit.
And how long have you worked with CDPHE?
Almost 10 years.
And can you briefly describe your typical work duties?
So the purpose of my role is to ensure compliance with the Colorado Water Quality Control Act, and I do so through compliance and enforcement of the act, and it's implementing regulations and permits. So my typical job duties include evaluating instances of non-compliance and then following up on that non-compliance with formal enforcement action, penalties, and determining the appropriate injunctive relief.
Can you explain CDPHE's interest in the Margaret Spalding location using this demonstrative exhibit based on Exhibit 3?
Sure. So historically, there was a surface water discharge from this site that Matt talked about earlier. And that surface water discharge was permitted under the Colorado Discharge Permit System. So after the produced water was treated through the oil water separation, it went consecutively through ponds 1 through 5 and then discharged out of pond 5 into Spring Gulch. So, along with that permit, I don't know how familiar you all are with our system, but there's limitations in the permit that are set to protect the receiving water, limitations on the pollutants that can be discharged.
And were you involved in CDPHE's enforcement at the Margaret Spalding location?
Yes, so there were multiple exceedances of those permit limitations that I talked about earlier, and that led us to moving forward with using our enforcement authorities to take care of the problem. And so in 2012, we issued a notice of violation cease and desist order to Lone Pine Gas, and I was the case lead for that. And then we subsequently filed a complaint for injunctive relief and penalties in the Jackson County District Court.
And can you explain the outcome of those enforcement actions?
So following up on the enforcement actions, Lone Pine Gas did an evaluation of various water management options for the site and determined that underground injection was the preferred alternative. But as Matt spoke to earlier, Lone Pine Gas decided that they didn't have the means or the desire to follow through with undertaking one of the wastewater management projects and continuing to operate the field. So they decided to sell their assets to CM Production. And at that time, CDPHE entered into 2 separate settlement agreements, one with Lone Pine Gas and the other with CM Production.
Okay, let's discuss those 2 agreements more in depth, starting with the agreement CDPHE executed with Lone Pine. When did CDPHE enter into a consent order with Lone Pine?
On June 24th, 2013, and that was made a final order by the court on June 26th, 2013.
Can you describe the requirements of CDPHE's consent order with Lone Pine?
So our consent order with Lone Pine was geared towards resolving their penalty liability. We had assessed a $150,000 penalty against Lone Pine Gas, which was to be paid in a combination of cash and environmental projects that had some type of environmental benefit. And so $100,000 of that $150,000 penalty was to be spent on decommissioning the ponds 1 through 5 that were associated with the wastewater treatment system.
Does CDPHE typically offer this option in its agreements to resolve enforcement actions?
No, we do sometimes allow an entity to pay a portion of their penalty through the performance of an environmental project, but that would be in addition to any activities that they have to do to return to compliance. So this was certainly atypical of a traditional settlement for us. And again, as Matt noted earlier, that every agency that was involved somehow in this site had concerns that the operator would walk away and the state would be left responsible for funding the remediation. And so we wanted to facilitate the cleanup, which is why we did something outside of our normal protocols to allow this penalty to be invested into a corrective action.
And how is CDPHE's consent order with Lone Pine linked to COGCC Order 1V412?
So we linked our $100,000 penalty credit to the pond decommissioning that was outlined in the order 1V412.
And why did CDPHE choose to link this consent order with the commission order?
Because we don't have any standards for remediation, so it made sense for us to link it to the standards and the deadline that were outlined in OGCC's order.
And why in particular to the decommissioning of the pits?
Since the pits were used as part of the wastewater treatment system, addressing the decommissioning of those was most closely linked to our interest at the site.
Was CM involved in the negotiation of CDPHE's consent order with Lone Pine?
Yes.
Did CDPHE expect that CM would undertake the decommissioning of the pits required in the Lone Pine consent order?
Yes.
Did CDPHE communicate this expectation to CM?
Yes, and that was the mutual understanding among all three parties during this settlement negotiation process.
Okay, let's turn to the agreement CDPHE executed with CM in 2013. When did CDPHE enter into a compliance order with CM?
So we entered into the compliance order with CM on June 24th, 2013, the same day that we entered into the agreement with Lone Pine.
And can you describe the requirements of this compliance order?
The basic requirements of the order were for CM to transfer the discharge permit to CM production, also to maintain the status quo on the quality and quantity of the discharge water, meaning that they couldn't increase production and increase the volume of water they were discharging. And most importantly was that they would cease the surface water discharge by November 1st of 2013.
Did CM request an extension to the November 1st, 2013 deadline to stop the discharge of the produced water to surface water?
Yes, on October 28th, 2013.
And why was CDPHE reluctant to give CM an extension to discharge the produced water?
We were concerned about the ongoing non-compliant discharge and the lack of progress that had been made at the facility.
And when did CDPHE receive CM's notice of termination of the discharge permit?
On June 23rd, 2014.
Did CDPHE's interest in the Margaret's Welding location end after the produced water discharge ceased, or the notice of termination of the discharge permit was approved?
No, we were still interested in the pit decommissioning because it was linked to the Lone Pine consent order.
Okay, let's talk about that pit decommissioning. Did Lone Pine submit documentation to CDPHE regarding qualification of pit decommissioning costs towards the $100,000 credit under the CDPHE and Lone Pine consent order?
Yes.
What was submitted?
We received 2 affidavits, one from James Hicks, who was the environmental consultant for CM, and another affidavit from Fred Solis, who's the VP and Chief Engineering Officer for CM, along with invoices for certain work activities that were conducted in the 2013-2014 time period.
What were the total costs submitted by Lone Pine for qualification as a dollar-for-dollar credit?
$138,480.
Based on CDPHE's assessment of the costs, how much did CM spend on pit decommissioning from 2013 to 2014?
$18,500. And based on the information that was provided to us, the only costs that we could, in good faith, say were invested directly in pond decommissioning was capping the line, the discharge line, and then also capping the lines that go between the ponds themselves so that the discharge could be prevented. And after further consultation with COGCC, we decided that we were willing to accept costs associated with groundwater monitoring and also various meetings that that CM and or Lone Pine had with either agency. Even though the scope of those meetings and monitoring served a broader purpose, we were willing to accept some additional cost. I should point out, though, that we are still going through the dispute resolution process with Lone Pine that was ordered through the court, so a final determination on the actual cost hasn't been made yet.
And what activities did the remainder of the submitted costs go towards?
So generally, they fit into a few categories. One would be soil stockpile remediation, labor and equipment, central tank battery improvement, and then general CDPHE and COGCC compliance.
In your opinion, is additional work towards the pit decommissioning necessary to satisfy the requirements of the CDPHE consent order with Lone Pine?
Yes.
Okay, let's turn to CDPHE's involvement in COGCC's actions in 2015. First, before the May 2015 hearing. When did CDPHE first become aware that COGCC staff and CM had entered into an AOC in 2015?
On May 14th, 2015. And we learned that through a phone conference that we had with the attorney for Lone Pine Gas. And the purpose of that phone conference was to talk about some of the cost information that they had submitted to us. And during the course of the conversation, he mentioned that the AOC existed.
When did CDPHE first reach out to COGCC regarding CDPHE's concerns with the 2015 AOC?
On that same day, May 14th, 2015, I reached out to Alex Fisher and Peter Gowan.
And what were CDPHE's concerns with the 2015 AOC?
The deadline for decommissioning the pits was going to be extended to September 2018.
Okay, let's talk about the events after the May 2015 hearing. Did CDPHE make comments to the 2015 AOC and provide them to COGCC staff after the May 2015 hearing?
Yes, and our comments were aimed at establishing a new compliance schedule rather than extending the deadline in Order 1B-412. And the reason for that was the deadline in our Lone Pine order could be automatically extended if OGCC issued any extension of the deadline. And by modifying the language that we were suggesting, we were hoping that we could break that link and that we would be able to pursue Lone Pine for their failure to comply with the environmental project.
Did CDPHE meet with COGCC regarding the 2015 AOC after the May hearing?
Yes, on June 3rd, 2015.
Was this the same meeting that Director Lepore referred to in his testimony?
Yes.
What is your recollection of what was discussed at that meeting?
So we discussed our concerns with the extension that was outlined in the AOC, and then we also discussed some ideas for a path forward.
Did CDPHE and COGCC meet with CM regarding the 2015 AOC?
Yes, on June 11th, 2015.
And was this the same meeting Director Lepore referred to in his testimony?
Yes.
What is your recollection of what was discussed at this meeting?
That was the 2015 AOC.
And at that meeting, did Mr. Teff state that CM had no plans to get going until CM had money to pay vendors?
Yes.
Do you recall Mr. Teff stating anything about CM's ability to post a bond for the decommissioning of the pits?
Yes, he said he couldn't put up the money for the bond.
Okay, and lastly, why does CDPHE not support an extension to September 1st, 2018 as provided in the 2015 AOC?
When we originally negotiated our settlement agreement with Lone Pine, the deadline for decommissioning the pits was July of 2014. And we likely would not have included that in our settlement agreement if we knew the work was going to take this long to complete.
Thank you, Ms. Morgan. Staff would like to call Alex Fisher.
Oh, no. I'm challenged technically.
Right, but company.
Yeah. Presentation.
Yeah. There we go.
Good afternoon, Commissioners. I'm Alex Fisher, the Environmental Supervisor for the western part of the state. And I'm going to walk through the remediation at the Margaret Spalding location from 2013 to the present, focusing on closure of the pits, as well as remediation of the soil stockpiles that have been referred to earlier. So the Margaret Spalding location is located northeast of Steamboat Springs and approximately 11 miles west of Walden, Colorado in Jackson County. Overlooking the location, we're going to focus on, again, soil stockpiles and the 5 produced water pits and a heater treater pit. So walking through the location, the facility, when the field was in production, oil and produced water would come through the tank battery processing facility. Produced water would then go through a series of pits, as we've referred to them before, as the production water pits 1, 2, 3, 4, and 5. And underneath the discharge permit with CDPHE was discharged to a drainage that led into Spring Gulch and then ultimately Hell Creek. There's also a treater pit that is located on location. The treater pit is actually the source of the soil stockpiles, as well as to the south, there is a treater pit for the Knopfsinger lease. And that was excavated prior to CM Production acquiring the assets and is also a source for the soil stockpiles. And the treater pit accepted from previous operations, oily waste, perhaps tank bottoms, venting was occurring into the pit, but some of the records even refer to it as a slop pit. So it was a pit that took a bunch of undesirable EMP waste. Also on location is a approximately 80-foot by 100-foot land application area or land farm area that CM Productions constructed. We have 2 injection wells, the Margaret Spalding 4B, and then the Entrada 128 that was permitted in February of 2014. The location, the Margaret Spalding location, can be very challenging as far as its situation, its physical location. It's a little over 8,200 feet above mean sea level. 5 months of snow cover typically covers the location per year, and below freezing temperatures 7 months per year. Therefore, the months from May through November are the critical months that must be utilized effectively for addressing remediation of the pits and the stockpile. And I just want to bring up that the COGCC does not prescribe methods for how the operators should be remediating their EMP waste. We ask for compliance to Table 910 standards as well as a reasonable time frame. The Margaret Spalding location is also located in a sensitive area for the reasons of the proximity to Spring Gulch. It's less than 500 feet. Shallow groundwater, 11 to 32 feet below ground surface. Hydraulic conductivity of the underlying clay, sand, and gravel is 10 to the minus 2, 10 to the minus 3 centimeters per second. And we've had concentrations of total petroleum hydrocarbons, the TPH, in the pits, the stockpile, and the land farm that exceed our Table 910 standards, which is 500 milligrams per kilogram for total petroleum hydrocarbons. Additionally, free-phase hydrocarbons have been observed during each inspection on the fluid surfaces of the pits. So walking through CN's obligations under the 2013 order, by September 1st, it was agreed that they were going to treat and dispose of the soil stockpile pursuant to an approved work plan. Again, by September 1st of 2013. Then by November 1st, stop the discharge of produced water into Spring Gulch and ultimately Hell Creek. And then decommission the former produced water pits to Table 910-1 standards by July 1st of 2014, all the while continuing to perform groundwater sampling. There was a series of groundwater wells that were installed around the pit complex during the initial remediation of the treater pit prior to CM taking responsibility of the site. Shortly after CM Productions took over the Margaret Spalding location, they were responsible for treating the oily waste that was excavated from the treater pit at the Margaret Spalding location, as well as the Noffsinger location immediately south. And here we see accumulation of fluids, including oil and water that has emitted from the excavated stockpile. So this stockpile has not initially been treated. They were also responsible for the decommissioning of the pits. And so these photos were taken on May 8th. We can see that the pits, the field is still in production with produced water running through the system. Also, I want to point out this, again, the soil stockpile in the background. So what needed to happen to comply regarding the stockpile were to treat the soils until they met 910-1 standards. And the plan was to use the treated material for backfilling some of the pits. What needed to happen to comply regarding the pits was to pump out and dispose of the fluids from the pits and dispose it either into the Entrada 128 injection well or off-site at an approved facility. Treat the oily waste along the sides of the pits until they either met 910-1 standards. This could have been done in situ or through excavation. Sample to determine if the materials beneath the oily waste meets 910-1 and backfill the pits and reclaim. I'm going to talk a little bit about active versus passive remediation. Again, the COGCC does not prescribe what methods the operators typically will use for remediation. We allow the operators to come up with the best, how they feel is the best method for where they are. Here is from June 2nd of 2015, the constructed land farm, again, approximately 80 feet by 100 feet, with approximately 3 feet of material that has been leveled off there. We also have pit number 2 with aerator that CM and the previous operator, Lone Pine, operated. And CM was using the aerator to help evaporate the fluids from the pits. Not the most effective means, but the main reason for the aerator was, again, to help meet some of the discharge permit requirements for the CDPHE effluent discharge. And we can see the oily material, oil accumulation along the surface of the pit. Passive remediation at the Margaret Spalding location really is not an option for some of the reasons that I mentioned before. The elevation at 8,200 plus means sea level. The 5 or so months of snow cover per year, the up to 7 months of below freezing temperatures, it really doesn't make passive remediation much of an option here. So during the 2013 field season, the CEM did provide a Form 27 COGC staff reviewed and approved with various conditions of approval. And through July and August, CEM treated the 6,600 cubic yards of stockpile material through a method called soil shredding, as well as treating it with a peroxide solution. Stockpiles were collected from the soil samples were collected from the stockpile, and they exceeded table 910-1 for total petroleum hydrocarbons. And then in October, CM did, at the end of October, CM did stop the discharge of produced water into Spring Gulch and ultimately Hell Creek. The proposed actions at CM, and these are actions that they have proposed, were again with an improved Form 27 work plan, dispose of water into the UIC well or off-site at a commercial facility. they were going to retreat the soil stockpile, and that was to begin in June of 2014. If samples were above 910.1, they were going to then propose to land farm and work the materials by tilling, disking on a weekly or bi-weekly basis. CM also did request an extension to November 1st of 2014 for removing the EMP waste and backfilling of the pits 4 and 5. And at this time, it felt staff felt with CM's consultant, people are on the same page with the project somewhat moving as far as they had an action plan to go forward. CM's action in 2014 consisted of continuing to pump fluids from the pits from 4 and 5 up to pits 3 and 2 and aerating the fluids in pits 2. They did collect samples from pit 5 in the stockpile. The stockpile was not retreated as they stated they were going to do. They did cap the pipes leading to the pits, as Ms. Morgan had mentioned. And sample results in October of 2014 indicated that concentrations of total petroleum hydrocarbons did exceed table 910.1. As part of the conditions of approval, we had asked CM to notify staff prior to sampling and remediation activities. They did not notify staff when they were collecting samples or conducting any remediation. Again, they did not initiate remediation by the second week of June of 2014, as they indicated they would. This stockpile, as I mentioned before, was not retreated as he stated they would. We have not seen results of 14 composite samples that were to be provided to COGCC. Again, active pit remediation not performed, and the soil samples have not been submitted for pits 1, 2, 3, and 4 to characterize the current impact of table 910.1 constituents. These are pictures, photos from a November 7th inspection of pits 4 and 5. We still have residual fluids, which comprise of water as well as the petroleum hydrocarbons in the base of the pit. A little difficult to see, but in pit 5 here as well. These pits, these particular pits are not netted, and we can see along the side walls of these pits residual oily material coating the sides of the pits. And if I recall, I believe these pits are approximately 10 to 15 feet in depth. This was taken in on November 7th of 2014. No remediation of the pits had occurred during the critical months of May, October timeframe. Same date, November 7th, pit number 1 is netted. We still see fluids on the pit with residual hydrocarbons. Pits 2, fluids on the pit. The aerator is not in operation. Pit number 3, we still have fluids on the pit. The bucket and a hose along the sidewall of the pit, and again, the banks of the pits show quite a bit of oily E&P waste just along the banks. The treater pit, we can see evidence of surface water flow from the Margaret Spalding location into the treater pit. Again, no remediation of the pits had occurred. On November 21st, staff issued, of 2014, staff issued a notice of alleged violation. CM had already received an extension to remediating the pits, and the date of the extension was at their request. The November 7, 2014 inspection of the slides you just saw, the observations showed no active pit remediation at all, and the October 23rd, 2014 sample results from pit 5 exceeded 910.1. And there were no sample results submitted from pit number 4. So the notice of alleged violation was issued because CM did not decommission pits 4 and 5 to table 910.1 standards by the November 1st deadline that they had asked for that extension. 2015, CM's proposed actions were that they were going to submit a amended Form 27 for land farming and a detailed work plan on how they were going to manage the material. They were going to pump fluids out of pits 4 and 5 and dispose of in one of the UIC wells or dispose off-site in an approved facility. They were going to apply a chemical treatment to pits 4 and 5 in situ to see if this chemical treatment would remediate the oily E&P waste along the banks of the pits. They're going to begin remediation of pits 1, 2, and 3 by July of 2015. Again, pump out water and collect samples to characterize the sidewalls and base of the pits. They were going to collect samples of the pits and from the land farm and submit for chemical analyses. Again, they had proposed treating the impacted soils from the soil stockpile in the land farm using an aggressive approach. I mentioned the pilot program applying chemical treatment with the product or smart hydrocarbon cleaner to treat the materials in the bottoms of the pits in situ. What they did do in 2015 was, well, they did submit the land farming work plan as promised in April. They did construct that 80 by 100 foot land farm and put approximately 3 feet of material in it. They collected samples from the soil stockpile and the land farm, as well as the treater pit in October of 2015. The results do exceed table 910. When they continue to pump out, once again, similar to year 2014 fluids from pits 1 through 5. Active pit remediation was not performed. The land farming was not worked on a regular basis. Again, samples were not collected from pits 1 through 5. And results of the pilot program on of the in situ treatment of pits 4 and 5 were not made available to COGCC. Kind of walk you through the 2015 field season. We have May 13 of 2015, and we have September 30th of 2015. These are the critical months of working remediation up in North Park. Pit 1, very similar, again, fluids. We have some hydrocarbon machines. Pit 1 is netted. However, the net's in disrepair. You can see very little to no change between the May 13 inspection and the 2013 inspection of 2015. Pits 2, or pit number 2, the aerator is working. We have hydrocarbons on the surface of the pits. And in September, quite a bit of the fluids had been removed. We have hoses and buckets along the sides of the pits. You know, again, I'm not sure how much the aerator helped, but we don't have as much fluids here in September. But the aerator for evaporating the fluids doesn't seem like a practical method for evaporating or disposing of the fluids. When indeed they said that they were going to either haul off site at an approved facility or dispose of in the injection well. Pit number 3 during the 2015 field season, again, May and September. Fluids, water, hydrocarbons, oily waste, a boom for skimming oil, September, fluids, hydrocarbons, oily waste, no change. No remediation had occurred during that critical time period. Pit 4, same thing, water, oily waste, fluids, water, oily waste, virtually no change throughout the 2015 field season. And again, these were between May and September, the critical months for doing some remedial activities. Pit 5, we have the fluids. We do have some free product on the surface. We have oily waste along the sidewalls. September, same story. There is a surface disturbance, and actually in both of these, that perhaps could have been when a sample was collected from Pit 5. But again, no remediation had occurred during the 2015 field season. And at this time, CM could have implemented their in situ treatment of the sidewalls of the pits that they had proposed back in February of 2015. The treater pit during the 2015 field season, we can see where surface water has run off and created rills from the marker's polling location into the pit itself. We had soil stockpile in the background. September 30, 2015, similar soil stockpile. Everything remains virtually unchanged. In June of 2015, we did do an inspection of the constructed land farm. Again, virtually things have remained unchanged. Approximately 3 feet of material that was placed in there with a rubber mount front end loader. Typically, if there's going to be an aggressive land farming approach, material is brought in and say 1.5 feet or so lifts, 18 inches, and be it tilled weekly, bi-weekly with an aggressive approach. Here, it appears that not much has happened. 2016, CM's proposed actions, they submitted the supplemental work plan for the land farm in treatment of the soil stockpile. This work plan was the one that I believe was promised in April of 2015. The soils, the plan included the soils will be placed in the treatment area to a maximum thickness of 1.5 feet. The soils were going to be tilled monthly from spring until October. The soil samples would be collected periodically for headspace analyses, and samples would be collected every 2 months for lab analyses. And in the work plan, it was stated that CM's goal was to meet Table 910-1 standards by October of 2016. Again, CM promised to submit this plan in April of 2015. Staff did not approve the work plan, as the work plan did not provide sufficient detail, nor did it appear to be based upon attainable outcomes. The work plan did not address any remediation of the produced water pits. So, summing things up from July of 2014, CM has had plenty of time and has been given plenty of time to remediate this location, the pits, the stockpile, and they have very little to show for it. We had the July 2014 pit closure deadlines pursuant to the 2013 orders. The extended November 1st, 2014 deadline for the pit closures has come and gone. Pit 5 in 2015, September 30th of 2015, again shows no progress. It's been almost 3 years since approval of the original 2013 orders, when CM took ownership and responsibilities of completing the remedial action at the Margaret Spalding location. It's been close to 1.5 years after the first closure deadline of July 1st of 2014, and 11 months after the extended November 1st deadline. CM has not made progress on remediating the pits or the soil stockpile. I started this presentation as CM's production's remediation progress from 2013 to the present at the Margaret Spalding location. So in 2013, just to recap, CM assumes responsibility. There was 6,600 cubic yards of EMP waste that required treatment. There were 5 produced water pits that needed remediation and closure to Table 910-1 standards, and 1 treater pit that needed remediation and closure to Table 910-1 standards. So here we are today, 2016. We have 6,600 cubic yards of waste that still require treatment. We have 5 produced water pits that still need remediation and closure to Table 910-1 standards. We have 1 treater pit that still needs remediation and closure to Table 910-1 standards. And we have a land treatment area that needs remediation and closure to 910-1 standards. CM is no further along today in the remediation of this location, of these facilities, than they were in 2013. Thank you.
Any questions for
Mr. Chairman,
Commissioner?
a couple of short ones. Just out of curiosity, what's the TDS on the produced water here? Approximately.
You know, since it hasn't been producing since,
or I guess better ask, what was sitting in the pits because they got pumped out and you allowed, I'm assuming they got to be put in the...
that I don't know offhand.
Okay.
A lot of the fluids that we saw in the pits from 2013, 2014, 2015 is from precipitation.
Just rainwater, because it looked like
snow
most of the wells have been shut in since 11 or 12 or somewhere in there.
Well, all of the wells, the field was shut in on October 31st of 2013.
Okay. All of the wells by October 13, none of the wells were produced.
Correct.
Okay. All right. And you mentioned that the limit of the 910-1 standard was 500 milligrams per kilogram, and they did work the soil, you said, in August of 13. Did that reduce the content of the hydrocarbon content of the soil at all?
It did. It did. The one photo I had up there of the soil stockpile pre-treatment, we actually had free product in there. Okay?
Right.
And so it did reduce it, and elevated TPH concentrations are range from, I want to say that they were close to 9,000.
After post-treatment?
After post-treatment.
And unsure pre-treatment, you know, you could actually get liquid hydrocarbons out of the pre-treatment.
Correct.
Okay. Thank you.
Thank you.
No, we have no idea how the magic formula treatment would work because it was never done.
That's correct. And we're dealing with the heavier end hydrocarbons as opposed to the lighter end.
Okay, any other questions?
I have a few follow-up questions for Mr. Fisher, if you don't mind. Mr. Fisher, could you describe your professional background as it relates to the remediation of oil and gas locations?
I've been with the commission for a little over 10 years. I've been the environmental supervisor for the western part of the state for approximately 7 years. And prior to coming to the commission, I have 20 plus years of environmental consulting experience, working with not only oil and gas operators, but other clients dealing with hydrocarbons, including investigation and as well as remediation.
And you mentioned that staff does not typically prescribe the method of remediation. Is staff's approval of the method for the remediation done through the Form 27 process?
It is.
Can you describe that process?
Staff will review the operator's plan for accuracy for the site conditions, the technical feasibility of their proposed remediation of the existing impacts, as well as a schedule on when things were done.
And when setting that schedule, does staff defer to the operator's suggested schedule if it is achievable?
Yes, we do.
And you talked a bit about passive remediation, but can you explain what passive remediation is in layman's terms?
Layman's terms, do nothing, pretty much nothing.
And does staff typically disfavor relying on passive remediation for the cleanup of E&P waste?
We do.
Did staff ever approve of Form 27 describing passive remediation at the Margaret Spalding location?
No.
Okay, let's turn to the meetings leading up to orders 1B412 and 1B413. Were you present at the meetings with Lone Pine and CM leading up to the approval of these commission orders?
Yes,
Did you discuss the need to actively remediate the pits with CM?
we did.
Did you discuss what would be required to decommission the pits to Table 910-1 standards?
We did. It was sample characterization, treatment, resampling to meet 910-1, and ultimate pit closure.
And did you discuss the need to actively remediate the soil stockpile?
Yes,
Did this include the need to treat the soil until it reached Table 910-1 standards?
yes, it did.
And why was staff so careful to make sure that CM was aware of what they were taking on regarding the remediation?
We wanted to see them to be aware so that they're not set up for failure.
Was CM confident it could remediate the pits by the July 1st, 2014 deadline in Order 1V412?
They were.
Was CM confident it could treat or dispose of the soil stockpile by the September 1st, 2013 deadline in Order 1V412?
They were.
Were these deadlines achievable?
Yes.
Okay, let's discuss CM's failure to meet its requested deadlines. The 2014 extended deadline has been discussed today. Do you recall exactly what the deadlines were extended to?
The pits 4 and 5 were extended to November 1st of 2014, and pits 1 through 3 to July 1st of 2015.
And was the deadline for the remediation of the soil stockpile also extended?
I believe it was.
Do you recall what date it was extended to?
That, I don't.
Would it refresh your memory if you saw Exhibit 20, which is the director's grant of that extension? Excuse me, 21. Let's see. Paragraph 1.
The soil stockpile was extended to July 1st of 2015.
Okay, thank you, Mr. Fisher. Were these deadlines requested after the 2013 field season?
Yes.
In CM's request for its extension, did CM acknowledge the potential for weather delays? This deadline, did the Form 27 state what was required to fulfill Order 1B412's requirements regarding the pit?
Yes.
And did the Form 27 state what was required to fulfill the order's requirements regarding the stockpile?
Yes,
Were these extended deadlines achievable?
they were.
Did CM decommission pits 4 and 5 to Table 910-1 standards by its chosen deadline of November 1st, 2014?
They did not.
And did CM decommission pits 1 through 3 or treat the soil stockpile to Table 9-1 standards by its chosen deadlines of July 1st, 2015?
No.
Okay, let's turn to CM's failure to pay its environmental consultants. Did CM hire Olson Associates as environmental consultants?
Yes.
Was most of your communication regarding the remediation at the Margaret Spalding location with Olson's Associates as a representative of CM?
Yes.
Was James Hicks the primary employee of Olson Associates whom you communicated with?
Yes, he was.
Shortly before the May 2015 hearing, did you have a phone conversation with Mr. Hicks?
Yes.
When did you receive this call?
I want to say that it was around May 15 of 2015.
And what was the subject of the call?
Mr. Hicks stated that Olson was no longer working for CM Productions as they were no longer being paid.
Was this the first time that staff learned that CM was no longer paying its consultants?
Yes.
Okay, let's turn to CM's failure to fulfill its obligations under the 2015 AOC. Did the 2015 AOC require monthly progress reports on the remediation beginning on May 1st, 2015?
Yes.
Did CM submit this report by that deadline?
No.
Has CM submitted this report as of today's date?
No.
Did the 2015 AOC require semi-annual groundwater monitoring reports beginning on May 1st, 2015?
Yes.
Did CM submit this report by that deadline?
No.
When did CM submit this report?
September of 2015.
Okay, let's talk about CM's failure to fulfill its obligations under the 2015 Form 27. This was the Form 27 that was conditionally approved on March 9, 2015. What were the conditions of approval on this Form 27?
To actively remediate the pits, remove the fluids, submit the land farm work plan.
And did you inspect the Margaret Spalding location in June of 2015?
Yes.
Was CM complying with that Form 27 at the time of that inspection?
They were not.
Let's turn to the land farm. When did CM begin construction of the land farm?
That was in May of 2015.
And when did staff first discuss the possibility of land farming with CM?
Early March of 2014.
To your knowledge, did anything prevent CM from beginning the land farm earlier than March 2015?
No.
Okay, let's discuss the Table 910 standards. Based on the information currently available to staff, do the soils in the pits at the location exceed Table 910-1 standards as of today?
Yes.
Do the soils in the stockpile and the land farm as of today exceed Table 910-1 standards?
Yes.
As you've seen at the Margaret Spalding location to date, indicate that CM has the technical capability to meet the requirements of the 2013 orders.
No, they don't.
Do you support the approval of the 2015 AOC?
No.
Thank you, Mr. Fisher.
Thank you.
You're not leaving.
Oh no, just doing some switching. I don't know if it matters, or I guess.
Good afternoon, Commissioners. Kyle Davenport, Assistant Attorney General. We're switching gears now to the MIT and financial assurance violations. If you would like to take a break, this might be a good time.
So far, your judgment has been really good. Just for clarification, we're going to act on this in combination, all three items, or we're going to go piecemeal?
We are presenting all of staff's presentation, and then Mr. Teff and CM, and then staff will have rebuttal. But we are going to ask that when you issue your orders, when you issue your orders against CM or whatever you wish to order, that you do it separately in each matter. So in the interest of time, the presentation is combined.
So even after we close the record, there's going to be someone here who will be able to help us, help me keep those three items.
I believe that's correct, yes.
Have a 10-minute break at the suggestion of the council.
So Commissioners, again, Kyle Davenport on behalf of the COGCC staff. I'm appearing in front of you on the two other matters in this case, 1601-00078, the MIT violations, and 1601-00079, what we were referring to as the financial assurance violation. As Mr. Rouse stated in his introduction to you, liability has been shown by staff based on the undisputed facts in the MIT violations issue. If you are interested, pages 191 to 192 to 193 are the undisputed facts or stipulated facts, and those are the pages that relate to the MIT violations. Staff, because liability has been shown by the undisputed facts, staff does not intend to call a witness in this case right now. With me at table is Martha Ramos, who will be staff's witness in the financial assurance violations. But before we get to Ms. Ramos, I want to just direct your attention real briefly to the basic undisputed facts of the MIT violations. MITs were due pursuant to Rule 326 on all 5 wells by no later than March of 2014. COGCC staff issued a warning letter to CM on October 6, 2014 that set a corrective action deadline of January 7th, 2015. NOAVs on all 5 wells were issued on June 18, 2015, and to this date, no MITs have been performed on any of the 5 wells, and CM has not plugged or abandoned any of those 5 wells. That concludes our presentation on the MIT violations. Unless there's anything that commissioners would like to ask, we're going to move to the last docket number, the financial assurance violations. Yes, sir.
Prior to the March 14 MITs, the due date, right? And they were doing March 14. When were the last MITs taken on these wells?
The last MITs taken on these wells, you know, I may have to look that up for you. I can tell you when the wells were shut in and the initial shut-in date, which drives the 2-year requirement for MITs to be performed after the initial shut-in date. The last time MITs were performed on those wells prior to that date, I don't know off the top.
May not have been if they were producing.
Stuart will know.
Okay. So according to Mr. Ellsworth, there were no MITs performed prior to that date.
Right. If they're producing, they probably didn't require that. They're only when they're shut in that they have to have that. So March of 2012 roughly is when the wells were shut in.
The wells, a few of the wells were shut in earlier than that, and I can give you the specific dates, but by March of 2012, all 5 of those wells had been shut in.
Okay. Thank you.
Okay. Okay, so we are changing gears again to the financial assurance violations, and we are no longer just at the Margaret Spalding location. We are now statewide for CM, but we are just in Washington and Jackson counties still. Staff would like to call Ms. Martha Ramos to council table, and I believe Ms. Ramos needs to be sworn in. She was not here when we did our en masse swearing in.
Okay. Hi, Ms. Ramos. Would you raise your right hand and repeat after me? I swear or affirm. I swear or affirm to tell the truth. To tell the truth. Regarding the facts of these proceedings. Regarding the facts of these proceedings. Thank you.
Would you please introduce yourself to the commission?
I am Martha Ramos, Financial Assurance Supervisor for COGCC.
How long have you been at the COGCC?
For 16 years.
Would you please briefly describe to the commission what your job is, and specifically as it relates to additional financial assurance?
We register and bond all oil and gas operators for the state of Colorado. We enforce and regulate Rules 302 and the 700 Rule Series. And we conduct audits on operators for inactive wells.
Now, I think this leads into what you just stated about audits on operators for inactive wells, but when you're determining whether or not an operator needs additional financial assurance, could you please generally describe to the commission what you do?
We run reports on operators, and when reports indicate that the operator is operating or not operating inactive wells, then we review those wells or all wells further by reviewing their production data. And a calculation is determined by Rule 707 and 706.
Thank you. Would you let the commission know what, under your understanding, is an inactive well as it relates to Rule 707?
Per the COGC rule definition, an inactive well is a well that has not produced or sold product for a period of 12 months, a well that is temporarily abandoned for 6 months, and an injection well that has not been utilized for a period of 12 consecutive months.
Thank you. Let's turn to now the facts of this case. And would you please describe to the commission, how did COGCC staff first learn that CM operated inactive wells?
We run reports on all operators, and our research indicated that they had a number of inactive wells, so we further reviewed all their wells for inactive wells by reviewing all of their production data.
Thank you. Let's turn now to Exhibit 105, and this is the that was issued to CM Production for additional financial assurance. Is that correct?
Correct.
And commissioners, for your reference, the Bates label is down at the bottom right-hand corner. And this is just sections of that up on the presentation for you. It's just sections of the letter. You can see the full letter at that exhibit. And Ms. Ramos, using that letter, could you tell us how many inactive wells does CM operate?
A total of 23 inactive wells were found.
Thank you. And was that number of inactive wells determined based on your review of the production reports and reviewing which wells had sold product on it or produced in the last year?
Correct.
Now, using that letter again, can you describe the depths of those wells and explain how the depths of those wells is important to the calculation of additional financial assurance required?
Of the 23 wells, it was determined that 19 of these wells had a total measured depth of less than 3,000 feet. Those wells required a $10,000 financial assurance. 4 of those wells had a total measured depth of 3,000 or greater, requiring an additional $20,000 per well.
And you determine those depths of the wells based on COGCC records?
Correct.
And I will let the commission know that the depths of those wells are also in the undisputed facts at undisputed fact 48. Let's turn now to page 1285. I think it's page 4 of Exhibit 105 as well. And we put the pertinent sections up on the board for you all. And Ms. Ramos, please explain to the commission how the required amount of additional financial assurance was calculated.
19 of these wells required an additional $10,000 financial assurance per well, which equaled $190,000, plus the 4 that required an additional $20,000 per well for those wells that had a total measured depth of 3,000 or greater, for a total amount of $270,000 minus the $60,000 that was already secured as a blanket plug-in bond, resulting in a total of 210 financial assurance requirement.
Thank you. Commissioners, CM's $60,000 plugging bond can be found at Exhibit 107. That's Bates 1292. Going on to the next slide, I want to confirm some dates with you now, Ms. Ramos. The warning letter was issued July 16, 2015. Is that correct?
Correct.
And it had a corrective action deadline of August 17, 2015?
Correct.
And that is the deadline that CM was either to submit the full $210,000 in additional financial assurance or contact the COGCC and work out a plan to submit that financial assurance. Is that correct?
Correct.
Did CM do I by August 17?
No, they did not.
Would you please turn to Exhibit 106 for me, please, which is Bates 1289? Is that the NOAV that was issued to CM for failure to submit additional financial assurance as required by Rule 707A?
Yes, that is correct.
And was that issued on August 27, 2015?
Yes, it was.
Did CM submit any additional financial assurance or contact staff to negotiate a plan after the NOAV was issued?
No, they did not.
Did anyone at the COGCC give CM an extension on on submitting financial assurance or negotiating a plan?
No, they did not.
Did anyone at the COGCC waive the requirement that CM submit additional financial assurance?
No.
Would you give us a brief explanation of why this additional financial assurance is important?
These inactive wells are not producing or product, well, they're not selling product, and therefore they are not generating revenue. So it poses a financial risk for the state of Colorado.
Should that operator no longer be able to operate? Is that
Right.
correct?
It's a potential risk, right?
Okay. Thank you. I do not have any further questions for Ms. Ramos. Thank you.
Commissioners, any questions from Ms. Ramos?
I have one question.
Yes, sir.
I saw on your exhibit, it looked like there were, well, maybe you can tell me, are there wells that CM operates that are producing in the state and selling product?
Without the full report, I'm not able to tell you the number of wells that are, but I believe they are. There are some.
They have some revenue coming in, we believe.
Right. But, you know, the exhibits here are listing the ones that were considered inactive. But I believe there were some that were selling product.
All right, thank you.
This concludes staff's presentation on all three matters in front of the commission. And I think the next step in the process is Mr. Teff and CM may give their statements.
Mr. Teff?
We have your written 5/10. You're going to add to that, flesh it out a little.
Yes, sir. Yes, sir.
I'm sorry.
Oh, yeah, it's okay. All right. Mr. Teff, do you understand that because you're not represented by an attorney today, that you are limited in presenting information to your 5/10 statement,
Yes.
and that you won't be able to cross-examine any witnesses or make legal argument?
Yes.
Okay, thank you.
Just for the record, so people out in Crawford know, tell us who you are.
My name is John Teff. I'm the manager of CM Production. I do have one statement that if you guys would permit me, Mason County Commission, I'd like to have spoke on the phone or heard this hearing today, if I could read it.
You may.
The Lone Pine Field has had economic value to our county for many years before a previous operator put that value into jeopardy. We were under the impression that CM Production had made significant progress in addressing the environmental impacts and necessary operational and maintenance issues at the Lone Pine Field since acquiring the field in 2013. This board would hope that the COGCC would be willing to work with CM Production to resolve environmental regulatory concerns so that the field may become operational and productive once again. CM Production should be afforded the opportunity to expend funds on remediation as opposed to payment of penalties and fines, enabling them to bring the field onto production and generate revenue for the company and once again become an economic benefit to Jackson County. We understand that there is still work to be completed, but it would be to everyone's best interest to avoid the very costly procedure of plugging and abandoning the wells at this site. This board believes that the field can again be productive, profitable, and environmentally friendly if CM Production is given the opportunity to correct the mistakes of the previous operator. We sincerely hope that you will allow them to work towards finishing that job that they started in making these necessary corrections. And it's signed by James A. Murphy, Ben Clayton, and Betsy Blecka, the commissioners and the chairman of the Jackson County, Colorado Board. I've taken a number of notes while they were speaking on all this, and I'd like to be able to address a few things if the time permits. And I'm quite frankly a little shocked at kind of some of the rhetoric that's been stated here today, but I'll try to temper that as much as possible for the benefit of the commission. First of all, I'm not represented by an attorney. CM Production has limited funds and none to continue ongoing litigation. Since taking over this field, we have consistently had to exhaust precious resources on legal counsel and various consultants just to try to withstand the staff's constant claims, barrage of claims, and deals with broken staff promises and unreasonable demands. The Lone Pine field is an operational problem, yet has taken many hours of legal bills and specialists to attempt to communicate with the staff. This doesn't solve the operational problems, it only creates further adversarial proceedings and slows progress. CM cannot afford to maintain legal counsel, nor can I justify further legal counsel cost. Funds need to be spent to resolve the problems of the field and less litigation. It is clear to me and unreasonable and unfair to me that CM not be represented. How can the commission hear both sides of the story without this? As per the hearing officer's direction, I cannot ask staff any questions today or be fully able to defend CM's position. This would be similar to me as a situation without a public defender. The staff will get to show their side of the story and pretty well has, and I won't get to speak up much on CM's behalf with any disagreements other than this one statement. We believe the commission's rulings limits my rights and is can just borderline unfair. If I could fully speak up on CM's behalf, you would get to see the staff cause many ability to solve operational environmental field issues. Solving these problems is the key issue. If I cannot speak up when staff will drive me out of business and leaving the state with what I estimate is a $10 to $12 million abandonment problem. CM has been working for several years to try to improve the field. Another example is my deposition was admitted into the exhibits. I had no chance to correct it before the deposition was just placed as an exhibit. It was already put in the exhibit package before I was provided a copy of it to even correct it. I don't know if they're going to ask me questions about that or use that, but you'll get to see that. I'd like to talk about CM's ability to pay fines as opposed by this process. An operator's ability to pay fines is a consideration the commission may take into consideration when assessing the penalties. Enforcement guidance published by the commission includes a section on this subject. I've provided financial information and statements to show the staff that there is simply no ability to pay fines. It would seem to me that limited resources should be used to continue to address the issues in the field and not to pay fines. I've provided many of these statements and repeatedly asked staff and the staff's counsel what other information they would like to see regarding CM's ability to pay. I've asked staff and staff's counsel to consider this. Prior to this, staff's response to me has been to increase the penalties, ask for additional bonding funds, and state to me that they should get the money before other things happen to me. A small private company does not have the ability to secure a surety bond. I think the director brought that up earlier. Other than to be able to post a full cash bond with the state, and the proceeds are held with a CD in a bank. We're not a public company, and it's just not that simple. I'd like to tell you that in the past 3 years, we've spent over $1.5 million and still are spending money to address the operations and the care of the field. $1.5 million is what we poured into it in various aspects. 200 to 250 grand is my estimate for legal bills and consultants. I'd like to talk a little bit about this 3-year time frame. We purchased this field in May of 2013. We continued to produce until the end of October in 2013. So we basically used 2014 to treat the pile during the limited time frame. I don't necessarily agree that we have from May till November to work in the field. Some of those operations are more limited than that. We treated the 6,000 plus yard pile of soil that was left by the previous operator in 2014. In 2015, we pretty much spent all summer waiting on some sort of an AOC approval that we really didn't get some assurance that we could continue to produce and operate the field or try to get it into production. I think you guys have heard a lot about there's been 3 years that we've been working on this. It hasn't been 3 years. There's limited time scheduled during the certain summer months. 2013, we continued to produce, got some stuff in order. In 2014, we treated the pile and drained the pits until after that, so we couldn't work on it. So it's not 3 years. That's completely blown out of proportion. I want to talk a little bit about the history of the field. My background, I'm an engineer and I've worked 20 plus years and in different operational environmental aspects of the oil and gas industry. I've worked in many other states from North Dakota all the way to the Gulf of Mexico. In other states, when the commission sees us making progress, they work with us. They try not to work against us. I feel that is not the case of what's happened here. Prior to us, the field has had a history of spills, leaks, and compliance issues, and major things like pipeline breaks, oil going into the creek system, hundreds of barrels spilled into the creek system. What I saw when we originally took the field over, it was, to say it was one of the worst messes I've ever seen in the oil industry is a complete understatement. I can talk a little bit more about that or answer any questions, but I'd really just explain it like my first reaction to the field was walk into the treater house building and stick a stick down 2 feet of oil laying inside the building while it was producing. Not only is it a safety hazard at that point, it was just a total disaster. That pile of soil that Mr. Fisher showed in the beginning, I think they were dumping oil and tank bottoms on top of it while it was sitting there. Things that are just amazingly shocking to me that what I saw. The decision to excavate that original treater pit, and I don't know if that was a treater pit. We have some indication that there was water being treated in it, but I don't even really know. I don't know what caused the spill into the creek system. We've had some indications that they carried over tanks in the field and it actually spilled into that drainage system. We haven't had any of those problems. We don't have leaks. We haven't had spills. We haven't had pipeline breaks. We haven't had wells blowing out of control. That seems to be like that's what's insinuated here. When we buy a field like this, we can look at the database, we can research all the records and try to figure out what has happened in the field, what's occurred to it, where it came from. We always find unknown things that happen after the fact. We do studies and environmental assessments when we take it over to try to figure out any potential problems that we may see. but we take it on good faith that as long as we show progress and go forward, that the regulations and the inspections that we get in the field, that the state will see us make the progress and go forward with it. This field, I think, has been a potential history of leaks and spills for 20 to 25 years. That pit that was used to dump tank bottoms in, I don't know if that's what it was. I know it was contaminated. Admittedly, we take over such problems, and many times these unknown problems we cannot see because we do not see everything or know everything that has occurred in the field or in the past. We know what is on public record from previous compliance inspections, just like the staff does. CM purchased this field from a retired widow whose husband died in a tragic plane wreck, and she was under all kinds of pressure and litigation from both the CDPHE and the Colorado Oil and Gas Commission. While negotiating the purchase of the field, we admittedly have agreements, both written and verbal, with both the CDPHE and the COGCC. Prior to purchasing the field, CM's staff receives several verbal promises were received by CM, specifically that of the disposal well, which would be administratively approved, which it was not. This delayed CM's ability to work in a timely fashion. Both the COGCC and the staff knew clearly the details of the water that we were injecting, the zone we would be injecting it to, and that would be used for the disposal. But then the staff suddenly involved federal approval at the last minute in the full process of the disposal well. Further, staff didn't timely submit a letter required to the local newspaper for public notice despite CM's offers to submit the letter article on their behalf. This was much like the delay caused in the AOC that we're talking about. The AOC not being approved in the summer of 2015 was spent discussing options rather than treatment of the previous operator's problems. Staff reneged on both agreements. CM took on a large mess that occurred over 20 to 25 years possibly from the past operators' poor operational practices of the field. All this was monitored, reported by staff and many other involved parties. Staff makes it seem like we created these problems, especially the unknown problems like the residual oil in the pits that were obviously there from the past. CM also took on the problem of a very poorly attempted excavation of one of the treatment pits, the one that they call the treater pit. The previous operator excavated this pit and penetrated the liner of the pit and created a huge problem and a potential large groundwater and environmental problem. This appears to all been approved by staff or even asked for by staff. This created a huge contaminated pile of soil that exceeds 6,000 cubic yards. Very oily soil includes free products sitting on top of the pile. This pile of soil was adjacent to the existing creek drainage and was not properly burned to control runoff of either the contaminated soil or the free product into the creek or drainage system. That's what I saw when I went there. I was shocked at what I saw. You could see that there was a pattern of potentially dumping tank bottoms on top of the pile. CM is well aware of the accidental discharges that occurred into the creek and the drainage systems on multiple occasions. All of these items are contained in the COGC database website. CM was aware that there were many wells that were due for MITs that the previous operator did not comply with either. We fixed those. CM was aware that the previous operator had no agreement with the surface owner or any form of what we call a surface use agreement. We solved this problem. No, I feel like we should have been grandfathered in. That further delayed the disposal well permit. CM was well aware of many of those problems. CM fully recognizes that this field is potentially a $10 to $12 million abandonment liability, and it could be as much as 15. CM purchased this field partially because the widow that owned it was at her wit's end and couldn't afford additional litigation. I do believe that the state would have ended up with it if we wouldn't have stepped in. CM took on the project believing the staff would work with us as promised for the benefit of the state of Colorado and the people of Colorado. CM has done this in many states, North Dakota, Wyoming, Nebraska, and Texas, for example. We have many revenue streams, by the way. We operate in several different states. We have many producing wells. Our shut-in wells are in Colorado. When you guys hear that our shut-in wells are in Jackson County and Washington County, there's one shut-in well in Washington County. The reason that we've kept it is we want to use it for water flood, but we're reluctant to do that. CM and I fully thought that our efforts would be appreciated and that our continued progress and efforts would provide incentive for the staff to work with us side by side. CM never expected the staff to choose to litigate, fine, delay, and stop our efforts to improve the field. This is clear to me. This is what has happened. As discussed when purchasing the field, staff agreed to administratively approve the disposal well. This well was utilized in the past for many years to inject many millions of barrels of produced water. It was conveyed to me that this administrative approval would occur in front of many people and that this simply meant that when we purchased the field, the permit would be signed. They knew the details of the well and the details of the water that would be injected, and this was also brought to their attention. However, after purchasing the field, this was changed and the permit was required to be submitted in full. This caused several months of delays and drastically affected the economics of the field, especially after the discharge permit had expired and production ceased. This is an example of not working together and providing CM with false expectations. This was the start of a major problem that caused the wells to be shut in indefinitely. It also alerted me that the verbal commitments made by staff would likely not be honored. Today's hearing and how these things are connected. There's basically three items we're talking about. This AOC extension, the MITs, and the financial assurance. If the AOC was extended in 2015 when it was initially approved, it's likely that the field would have been producing last year. The MITs and the financial assurance are directly connected to that because we wouldn't have shut-in wells. We wouldn't have the necessity for MITs if the field was producing. The AOC was signed and the staff reneged on the deal. This AOC was signed by the staff. Despite what you will hear or you may have heard, these are all directly connected and each items depend on each other. Staff has made repeated attempts to separate these items, to try to pull them apart, and while ignoring the operational financial improvements made on the field. In April 24th of 2015, the AOC was approved. This was brought before the commission in May of 2015, and it was placed on hold due to a last-minute concern by the CDPHE. This was raised by one commissioner, though the CDPHE had a separate agreement with us, which we addressed, and a letter was received from the CDPHE that their concerns have been addressed. This letter addressing the CDPHE concerns was provided to staff, but then the staff decided not to approve the AOC shortly after that. The MITs, like I talked about, they're very simple. If the wells were producing, the MITs would not be necessary. The financial assurance is very simple. If the wells were producing, then they would not qualify as shut-in wells and wouldn't require the additional financial assurance. Requests were made and these items were discussed despite what they might be stated here today. Requests to delay the MITs were asked for, but staff seemed okay with this at first, but then they reneged on that original deal. When the field was first purchased, all available wells in the field were MIT'd, even some that didn't require it. Several of the wells were not accessible due to the stockpile of soil that required staff's approval to touch, treat, or remove it. I hope you see that the MIT on a couple of wells required removing the large pile of soil. And if you look at this exhibit, the one well's right here. We can't even access it. So if we move the pile of soil, we're in trouble for moving the soil. If we don't move the pile of soil, we're in trouble for the MIT. The field has not produced a single drop of water since the discharge permit expired. Consistent ground watering, and this is the most important thing here in this whole thing, consistent ground watering of the monitoring wells that surround these pits have consistently showed that there is no contamination from anything that's happened here. Operational progress. You've heard today, and I've heard several times, staff's allegation is that CM has done little or nothing to improve the field. This is simply false, and quite frankly, it's offensive towards our efforts. The field has improved dramatically. First, since CM has operation of the field, there's been no reportable release discharges of any liquids, not like the past, which occurred repeatedly as per the COGCC's records. Second, the groundwater testing has showed nothing impacting the groundwater. The CDPHE requirements have been satisfied. We have a letter stating this. Nothing would stop that continued progress. The CDPHE and Kelly testified today that $18,000 of our efforts were applied to the pits. That's simply not accurate. The invoices that we provided them came from our third-party consultant and our in-house engineer. They attested that well over $100,000 was spent on it. I've got a comment on that when Kelly talked about nothing towards the decommissioning of pit. How did the water get moved? The electricity used, the diesel fuel, the labor transferring the water from those pits and dewatering them. I would submit to you that Kelly just does not have the experience to go through those invoices and just arbitrarily throw some of them out. CM's field foreman, engineer, and our environmental consultant do have that ability. They have the experience. They provided this information accurately and swore to it, the accuracy of the information. CM has done things to limit the production risk and limit the leaks in the field through our many different operational methods. Again, we've had no leaks. CM ceased discharge of the produced water when the discharge permit expired. I think that's been clearly admitted to. CM immediately properly bermed the pile of soil that was left by the previous operator, which appeared to satisfy both Mr. Alex Fisher at the staff and the EPA concerns. CM has had little concerns expressed by the EPA since this item was completed. In 2014, CM chemically treated the large pile of soil and dramatically improved the pile. Testing done after the treatment actually passed the COGCC 910 table standards, but we worked together with Mr. Fisher and took it to an independent lab, and there's one constituent that did not pass. We've owned up to that. We want to continue to work on that. We've continued to work on treating that pile of soil through the land farm method that you saw pictures of. After the discharge permit expired, CM spent money and efforts to evacuate all the water out of the treatment pits and hasn't produced a single drop of fluid into those pits. I've heard allegations in the past that we've continued to do this. This is simply not true. This process continues and continued when ambient temperature allows and safety allows this to proceed. Walden, as Mr. Fisher described, is a very cold, windy place and has a very short summer, which allows for certain things like transferring water to occur. When weather permits, CM continues to evacuate water and residual oil from the pits regularly. I hope you can see that some of those pictures Alex showed is natural water coming from natural moisture, snow, and runoff. CM did not anticipate residual oil to be in the pits, especially pits number 4 and 5. We made that arrangement partially because we didn't expect anything but water. We didn't expect residual hydrocarbon to be in it. These pits are naturally lined with a bentonite liner. There's more likely, I think the pictures are deceiving. When you see some of the pictures that Mr. Fisher showed, you have oil spread out over some water and you see some black outlying soil. That is also wet soil, and it's not just oil. I absolutely do not agree with excavation of these pits. This could be potentially create a huge environmental issue with the groundwater, as the one pit that we inherited could have done. It would also create huge amounts of contaminated soil. This method would be similar to attempting to hang a picture frame with a 12-pound sledgehammer, as it would create potential damage than it would repair. This is what happened with the previous operator. It created a huge, large pile of soil and the necessity to monitor the ground. This excavation method is continually brought up by staff and staff's counsel, and it could create huge problems as evidenced by the pit that was already excavated. CM does not agree to chemically treating these pits until the natural seepage from the banks of the pits limits or ceases, because it would be a waste of money and effort. CM does not agree with backfilling the pits and potentially creating additionally contaminated soil that would eventually have to be excavated. CM continues to land farm and naturally treat the soil, and the results are improving. Throughout discussion with staff and staff's counsel on this, in this hearing, this fact continues to be discarded, ignored, or taken out of documents. That land farm is helping. It's doing the trick. We have test results that show that. I realize that Mr. Fisher says that that's a passive method. To me, a passive method is you add no chemical, no product to it. The sun and the wind and tilling the soil helps it. We've done that. We've repeatedly tilled the soil. We may not have done it every week on the dot, but we've done that regularly. Currently, staff will not approve reasonably or communicated acknowledged proposals by CM, despite approval of the original AOC and many attempts to ask for further justification and attempts to create an approved plan for the pile of soil in the pits. Staff continues to dictate methods that are unreasonable. Recently, Alex Fisher denied further investigation of a chemical treatment or extension of such discussion. The product supplier of this chemical, who has the expertise but is unwilling to commit to the cost and timing of the project due to lack of accessibility to the field and full visual access to the pits because they're full of snow. They can't see what they're trying to treat. We put this proposal in a few weeks ago. Towards the end of February, Mr. Fisher denied it. He said we still got to come up with some method. I believe Alex has attempted to deny attempts to continue to land farm the pile, even though the soil that's in the pile, even though that is ongoing, regardless to multiple reasons, with what appears to be a full attempt to litigate this situation rather than repair the past operator's problems. Mr. Fisher has conveyed to you today and the director that little or no progress has occurred. This is simply false. Alex has been very unprofessional in many of our aspects and efforts to repair the previous operator, both to us and the previous operator, towards executing a plan to get this entire field in compliance. I'm quite frankly shocked with some of the things that I've witnessed. CM did set up the disposal well. CM needed and has run three-phase power to the field, which was a major cost and major undertaking that took several months and us to closely work with the power company. I had real reluctancy about doing that when the disposal well got delayed. CM constructed a very safe and usable tank treatment system to be able to treat the produced water before it goes into the disposal well. CM has spent huge amounts of money funding its efforts and to properly and effectively restore production from the field. As we stated today, huge efforts and improvements have been made to the field. CM continues to regularly monitor the field and the wells as a good operator should. In the event the staff would like to operate the field, this would be a challenge for them, especially if a small leak is not addressed immediately. This could be a huge problem for the state of Colorado. We have a pumper in the field that monitors the wells every day. Any little leak is immediately addressed. We're still spending $10,000 to $15,000 a month. Fuel, removing snow, monitoring wells, taking care of problems that are in the field. I think we've talked about we've got no leaks. The MITs and the financial insurance is directly related to this. CM has no ability to pay this fines. CM has tried to do everything properly and timely for the benefit of the state of Colorado and several interested parties. CM continues to be hindered by continual problems with weather, cooperation of the staff, very low oil prices, and litigation. Funds need to be spent on the field and past issues left by other operators and not litigation. CM has limited resources. We have been directly harmed by low oil prices. We don't have the funds to continue to litigate or pay fines. We want to try. That's the best thing I can continue to tell you guys. We want the AOC approved for 3 years, no penalties assessed. We need to spend money on and funds on the field to continue the operational items to turn the wells back on production, which will eliminate the MITs and the shut-in wells. There's a few things I'd like to address that's been brought up already. The 3 years, and that is simply just not an accurate depiction of what's happened. We purchased the field in 2013. We couldn't evacuate the pits while they were being used. We couldn't stop that process. We stopped it when the discharge permit was ceased. I talked to the director of the health department and the director of the Oil and Gas Commission on October 31st in 2013. They both assured me that you could continue to produce and you wouldn't be fined. Roughly 2 days later, I got a call from Mike with the health department telling me that they're going to fine me. Why? Because you're discharging. No, we weren't. We shut it in, despite assurances from staff, director, and the CDPHE. Not attempted to negotiate on the bonding. That's simply not accurate. We proposed some bonding that was smaller amounts. We did try. One of Britta's major points was CM failed in its meaningful progress of the field. That's just simply not accurate. We're given unrealistic choices. Pay a $150,000 fine or put $250,000 into a bond. What's the next option? Put $500,000 into some other project? Well, Matt Laporte testified that we made sure that we were aware of the issues. That's mostly true. There's issues that Matt didn't know. There's issues that I didn't know. We took on a field with 25 years of problems. Decommissioned to 910-1 standards. That was something that was sort of slipped into the agreement, and I signed it. I didn't realize that. Decommissioning of the pits meant to me that they would stop being used, water out of them, and treat them over time. The summer of 2015 was completely wasted, waiting on the AOC approval. Revenue stream concerns. This isn't the only field we operate. It's just, we operate 2 fields or 3 other fields in Colorado, the Rice, and 2 other fields called the Hyde Tap. Several in Nebraska, North Dakota, Wyoming, Texas. We have other revenue streams. Progress reports not submitted. I take responsibility for that. My environmental consultant isn't paid. You know why? Because he didn't do his work. He didn't submit his progress reports. I don't think I should pay him. That's pretty simple to me. That's part of the reason why staff's frustrated with me. Did not respond to the demand for bonding. Yes, we did. I made it pretty clear that we couldn't post the $200,000 bond. A question came up about the freshness of the water, the salinity of the water. The water is quite fresh. In fact, it's fresher than the water that's naturally in the creek. Kelly Morgan expressed a concern of lack of progress. I think that the health department visited the field on one occasion after they agreed, after we capped the pipes to see that we weren't discharging. When she states that there's a lack of progress, I am concerned by somebody that would state that that's never seen the field. Throwing out the invoices that I understand from Lone Pine's attorney that Kelly is going to re-review them with Lone Pine's attorney, that we only spent $18,000 decommissioning the pits. We spent all the money we have to try to go forward on this project. The $130,000 was testified or sworn in an affidavit that is accurate by 3 independent people. They do this for a living. They supervise the invoices, they approve the invoices, they allocate things to certain projects. They know whether it occurred. There was a comment made by Kelly, no plan to get going. No, I have no ability to pay vendors. That was on a phone call. I don't agree with that. I don't agree that I made that statement. Alex talked about a few things. He doesn't subscribe to methods. He doesn't, but he pretty much tells us what he'll approve. So he pretty much does subscribe to methods. He also directly recommends consultants. I don't agree with the passive description of treating the soil. In fact, I've told you that the results are improving. The aerator is not an effective method. It's used all over the oil field. It's very effective. The pictures showed it worked. The pit levels dropped. Rain and snow that refill the paving in those pictures. No change in the field. Every time I heard that today, I just shake my head. So the money we spend and the time we spend to pump the residual oil out of the pits, that's no change. That's taking the free product out of the pits. That's what needs to happen first. We need to continue to evacuate that free oil out of the pits until it dries up, until it becomes less of a problem, then it can be treated. No tilling of the stockpile. That's just not accurate. No progress and no further along. I just absolutely don't agree with that situation. I hope that you guys will have lots of questions for me, and I hope that you understand our position. All we're asking for is that the AOC be reapproved for 3 years. We want the extension back. We want the ability to go back to work, and we need some kind of an assurance to be able to do that. Thank you.
Okay, thank you.
We do have some, staff does have some questions on cross-examination. Mr. Teff, Kyle Davenport, I thought I heard you testify that the field has not had any releases, leaks, any major problems since you took it over. Is that correct?
Reportable releases.
Okay, reportable releases. But it's also true that the field has been shut in since October 31, 2013. Isn't that correct?
Yes.
It would be difficult to have reportable releases once the entire
it would
field is
not.
shut in.
No, it would not.
You could still have portable releases after the field was shut in?
Absolutely. I think the condition now of the field being shut in is actually worse than it producing. The freezing cold temperatures in Walden, this is a recipe for a major problem. Freshwater freezes at 32 degrees. These wells will build up gas heads behind casing. They will expand steel, break it, and they'll leak.
I'd like to talk about the current status of the field. Do you agree that the soils in pits 1 through 5 do not meet table 910 standards as of today?
Absolutely.
Do you agree that the soils in the overflow treater pit do not meet table 910 standards today?
I don't know the last, I'm sorry. I don't know the last time that was formally tested. Originally, when we purchased the field, we were given some results that it did pass. Then after buying the field, we were shown some results that it didn't pass. I think we took some samples within the first few months and it didn't pass. We retreated it, and I don't know that we've tested that soil. To me, that's totally irrelevant, because until the stockpile of soil passes 910-1, I don't want to put it back in the pit. That would just make illogical sense. There's one more comment I wanted to address. Alex showed several pictures of runoff. They're showing the side of the pit running off into the pit itself. The pit is bermed. It wasn't at one point. Mr. Fisher brought that up. We addressed it.
All right, so returning to my question on the overflow treater pit, though, you don't have any samples that you can show us that as of today that the soils in that overflow treater pit meet table 910 standards, do you?
No, but we treated it. It probably passed. I don't know for sure.
I'm sorry, your statement was if you treated it, it probably passed?
We treated that pit when we treated the pile of soil, and my guess is right now that it would pass.
But that's just a guess. It's not based on any hard data.
No, it's based on my 20 years of experience.
And how about the soils in the stockpile? Would those be, do you have any evidence today that those meet table 910 standards?
No, they do not.
Okay. And soils in the land farm?
No, they do not.
And you agree, would you not, that that's what CM's been required to do by the 2013 orders, is remediate, or excuse me, get the soils in the pits and the overflow treater to table 910 standards?
Yes, we took on the method of treating that pile of soil. The pile went from this black, loose oil laying on top of it to almost something that is, it looks to me like topsoil. It failed one constituent, and it will not pass that, but it's improving.
And you would agree that as part of CM's obligations that it took on in 2013, that it agreed to get the soils in the stockpile to table 910 standards?
Yes, I agree. We did everything we could to try to meet that at that time.
I'd like to talk to you about your statement, and correct me if I'm wrong, but I believe you testified that nothing was being done in the field in 2015 because you were waiting on the 2015 AOC. Is that correct?
I feel that way, yes, I do.
And that was CM's or your decision not to do anything pending a resolution on the 2015 AOC?
We don't have approval by the staff to do anything.
So your testimony is that you didn't feel that you had approval from staff to do anything until that 2015 AOC was approved? That's
how I interpret it, yes.
And what did you base that interpretation on?
Because the AOC was not approved.
Did anybody from COGCC staff tell you that you shouldn't be doing anything until the 2015 AOC is
No, but
approved?
we need some type of assurance from the COGC staff that they'll approve a plan that's realistic, that's cost effective, that will actually do the work in an environmentally friendly manner.
That was still nothing that you actually confirmed with staff though, isn't that right?
Directly, no.
All right, I'd like to talk to you about the UIC permit. I think you talked at length about that UIC permit. What I'd like to talk to you about, first of all, is the permit itself. Isn't it true that that was approved by the COGCC on February 28, 2014?
I think that's correct. I think it was also conditional upon the surface use approval.
But nothing, that well hasn't been used for 1 day since you received that permit, is that correct?
No, it hasn't.
And isn't it also correct that CM submitted the itself on October 29, 2013?
I think that's accurate. Sounds right.
And the field was shut in on October 31, 2013.
I think yes, that is correct.
And is your testimony that the COGCC staff did something to delay CM filing that permit application until October 29, 2013?
Absolutely. They agreed to administratively approve it. Denise Honkio told me that meant I would sign it and you would have it in a few days. Not go through a 4-month process and submit all the data on a well that was previously used for disposal.
When was that promise made to you?
Multiple times before we purchased the field.
So that would have been before June 13, 2013?
Yes.
Now, correct me if I'm wrong, but CM hadn't even decided which well it was going to use as an injection well.
That's incorrect. We told them which well, which zone, and what the water would be injected into it.
And you did that before June of 2013?
That was the whole decision that convinced me to go ahead and purchase the field.
Would you help me and would you turn to Exhibit 13 in your book, please? And I'd like you to look at page 3. Actually, no, stay on page 1 of that exhibit. And for commission, we're at Bates 302.
Right here,
If you look at the bottom of that page, there's the top of the page is an email from James Hicks to Alex Fisher and Kelly Morgan. Is that right?
Yes, looks like it.
And the date of that is July 31, 2013.
Yes.
And then at the bottom, it looks like there is an email from you to James Hicks, some other people, that's also dated July 31, 2013. Is that right?
Yes.
So I think what's happening here, and correct me if I'm wrong, you sent an email to James Hicks, and then James Hicks kind of sent that email along to Alex Fisher and Kelly Morgan.
That's kind of what it looks like, yes.
All right, would you please turn to page 3 of that exhibit? And I'm looking at paragraph 4D. And paragraph 4 is titled Implementation of Injection. And then D says, after we identify the appropriate disposal wells, we will work to provide necessary paperwork to the COGCC. Isn't that saying that we haven't identified the injection wells yet?
Injection wells. We already told them which well that we were going to use before that.
So wait a minute, I'm still confused. Explain to me, this says right here, after we identify the appropriate disposal wells. Isn't that referring to implementation of injection of which well you're going to use?
There was more possibilities at that time.
This was after you purchased the field, though.
Yes. We continue to explore other possibilities.
Tell me what work needs to be done to get that UIC well into working order right now, please.
There's a pump that needs to be set and some electrical connections. The 3-phase power is brought into the field, so the electricity needs to be jumped from disposal well itself, and there's some more safety controls that need to be installed on the tank battery. Some testing.
And how long would that take?
Depends if everything goes correct. Months.
And how much?
On the good side, 50 to 60,000 could be more than that.
Now, I understand that there was a conversation around the time that the director's demand for payment was issued, in which case the amount of the bond that CM could provide was discussed. Is that correct? Do you recall having that conversation?
I'm sorry, can you repeat that?
Sure. Around the time that the director's demand for payment was issued, and in 2015, there was a discussion of CM providing a bond. Do you recall that?
Yes.
And CM at the time said it could not provide a $75,000 bond. Is that right?
I believe so, yes.
That was a true statement on your behalf that CM couldn't provide that bond?
Yes.
You've seen the pictures in September of 2015 where there's water in the bottom of some of the produced water pits. Is that correct?
Yes, I have.
Okay. It's possible that some of that water is from groundwater seeping up?
At that time of year, it's hard to completely say. I know some of it came from precipitation. There were certain times of the year that were really wet.
Is it possible that that's groundwater though?
I don't know. I think it might be unlikely with a bentonite liner in it.
You're talking about the summer of 2015?
Yes, sir.
And I understand you testified that in 2014 you chemically treated the soil pile and that samples showed it met Table 910 standards?
There were two different labs that the soil was sent to. The environmental company that treated it for us, they sent it to a lab in Texas and their results passed.
Did you provide those samples to the COGCC staff?
Mr. Fisher reviewed them with us, I believe.
Just give me 1 minute, please. Now, it's my understanding that you have a different definition of passive than Mr. Fisher does. Is that right?
I do,
Okay.
apparently.
So you've described what CM is doing as using sun, wind, and natural precipitation to help the process of reducing hydrocarbons in the soil. Is that right?
No, I don't.
Okay, please describe to me what you meant by what CM's been doing.
Passive to me would mean that you're exposing the soil and tilling the soil regularly when you're not adding any sort of product to help it become any sort of chemical or any other outside product into the soil, but you're tilling it and wind and sun access regularly, where I think Mr. Fisher's definition would be that it just sits there. But
And it's my understanding that you've testified that as of today, CM can't provide a $210,000 additional financial assurance bond. Is that right?
not with our current financial situation and the low oil prices, no.
And it could not provide, I don't think we have any further questions for Mr. Tuff.
Okay. We have your written, I can't say. You, no. I'm sorry, we have another
You have one from,
royalty owner.
you have one from Tony Martin, he's one of the royalty owners. They're all related to each other and family. So he spoke up on their behalf, and then we wrote one for CM's benefit.
Okay, and do you have any questions? Oh, I don't know, Brett, where do we go from here?
Now it's staff's chance for rebuttal. We have a few witnesses that we'd like to call.
I suspect we can just make our own rules. We could ask questions now if we want.
That's fine with staff.
But we could wait until she does her. Okay, let's go ahead.
I think also Commissioner Howard, I was just wondering how much time staff had.
I think we can rescind that here. Okay, Commissioner Benton, you have some clarifying questions.
I do, but I'll defer to other commissioners first. All right. Trying to understand a few things.
Commissioner Benton. Thank you. Trying to understand a few things. There's a lot to try to digest as we go through this. Sort of at the top, I'm kind of left with two leading questions about why would, other than to help out a widow, why would you acquire this field? And what level of field due diligence did you undertake before you decided to buy it?
Well, we thought at the time in 2013 that the good oil prices were reasonable and we could easily make money off the field just the way it was. We also see the potential in the field. I think when we took it over, it was making about 25 barrels a day. I think if the field was correctly set up and some of those operational items that I talked about were mitigated. And I'll give you an example of something like that. When we ran the water line to the disposal well, we put in a brand new pipeline and we pulled plastic inside of it. The previous leaks created by the other operators were lines that run over the creek drainage systems. I think on that, but you can see on this one, Spring Creek or Spring Gulch. And there's also another drainage over here. And those directly feed into the river system in Walden, which drew a lot of headlines when Lone Pine had their leak. But those lines that run in those areas, they need to be engineered correctly and they need to be put in like double walled lines. So we didn't really consider the wells on this side of the field turning them on. When we purchased it, we kind of based our situation on the stuff over here. We think it needed water flooded properly. This well right here that says injection wells at the top of the structure, and that's not good for anybody to pump water into it, even though it was done in the past. But we saw the potential of a field that could make maybe 150 barrels a day. The past history made well over 100 barrels a day. Even at 25, 26, our 14-year oil price low right now, that those prices or at those volumes, it would make money. We ran the three-phase power to the field because the electric bill would essentially go from like 12 or 15 grand a month down to like 6. There wasn't really enough power to even supply everything in the field. I guess the situation you asked about the widow, I do feel for her. We purchased another property in Northeast Colorado from another lady that her husband passed away. It's creating a win-win for everybody. She wins, we take on the problems, I wear the pressure. Hopefully that we produce it in a very friendly way and that the mineral owners make money and the taxpayers make money and the county makes money, everybody makes money. That was our goal.
Okay. When you were contemplating acquiring this asset, we
gone on quite a bit about the level of environmental issues with this and the lack of sort of conscientious field operation. Did you make a trip to the field and get a rough idea of what you were taking on here?
Absolutely. We do usually a phase 1 environmental assessment. We try to look into, we read all the documents that are available on the website. We spoke to the COGC staff about it. We spoke to the health department. I guess my assessment of the situation was that the previous operator had a pumper that wasn't taking care of things. He wasn't checking the wells every day. He wasn't, they say they're doing that, they're not doing it. That's their number one responsibility, is not to have leaks. Just one example, we bought something in Northeast Colorado. We found out that the previous operator buried some waste out in the field. We did pay a fine for that. We didn't do that. I don't know if that's going to come up here in a month or so, but that's something that Mr. Farron, Jeremy Farron, assessed a big fine for us that we went ahead and paid, but we had no idea it happened. There's no way to prove it happened. There's no way. It was out in the middle of the field. They dug a hole and buried some tank. You guys know it happens. Corrected the issue. We cleaned it up. We hauled it off to disposal. We anticipate those things in this field too, that could have happened in the past. We're just not all knowing and not all seeing, but we try to do what we can and do our best.
I think a phase 1 would at least given you some idea of what was going to need to be done and the timeline, so that when you started the discussions with the commission, that would have given you an idea that at least you could have gotten close, because we're sort of, or at least I am, I won't speak to the rest of the commissioners, it kind of looks like acquired the field in July of 13 and we're now in 2016 and the pits are emptied. We've seen that. The soil pile is still there and the field is shut in. So you kind of struggle with it. To me, there's something missing on not picking up what all the potential issues were you were faced with and the time estimate to remediate those. And I'm thinking I would have asked for more time, I guess, or something different if enough work had been done up front. I'm not trying to pick on you, but it just seems like there wasn't enough in-depth look at this thing to really understand what your issues were up front.
I think you're absolutely correct. I mean, knowing what I know now, obviously I would ask for more time.
Small questions, and then some other ones. I think, when you consider what's at stake here for you, what was the decision? And I think you were using Davis, Graham, and Stubbs for an attorney. What made you decide to quit using an attorney?
Stop paying the attorney bills and focus the money on the field.
Okay.
I mean, that's pretty much simple to me.
Yeah. And am I correct? You said since you acquired it, you spent about $1.5 million. Is that right?
I believe that's pretty accurate.
Okay. You mentioned something in here before I forget. You thought the field was in worse shape. You're concerned about a gas pressure buildup and leaks at the wellhead. Do you have any gauges on any of those wellheads so you can monitor that?
Can you repeat that again? I'm sorry.
Yeah, you said you think the field's in worse shape now because it's not producing. And you're concerned about gas pressure buildup, I guess I'm assuming on the annular space. Do you have gauges on that annular space to see if that is a concern?
Well, I guess what the other thing I should clarify too, the water from these wells when they're producing is very warm. It keeps everything nice and warm. The treater building, all the pictures of everything you see there, when it's shut in, then it's obviously cold. And that is potentially something that scares me. Fresh water freezing and Walden gets very cold. And we've done some things on the wells when we took it over to put some pressure relief type mechanisms on them for the expansion of ice so that it doesn't break things. I'm just fearful of getting a phone call anytime that
Yeah. Have you thought about putting any glycol in those vessels or antifreeze?
We have it in there.
Okay. Probably one of the things I was trying to get the dates right as you were going along, that you received your injection permit, and was it for the Entrada well?
Yes.
And that was October 29th of 2013?
I think that's when roughly we submitted the permit.
Oh, submitted it?
Yeah.
When did you
I think it was approved a few months later, and then I think it was conditional upon surface use permit. The surface and were owned by the Spalding heirs. That's why they're the Spalding wells. Mr. Martin is one of the royalty owners, is one of the heirs, but there's a large ranch in Walden that purchased the surface, and the heirs were left with the minerals. So there was no surface use agreement with him. So when we implemented the disposal well, that was part of one of the requirements, is make sure the surface owner was okay with it. Ironically, they wanted the water discharged back into the creek.
When you were, which I forgot about this, when you were contemplating the acquisition of the field, did you understand that you probably weren't going to be able to continue to use surface discharge?
I didn't think that was a very really feasible option. I mean, I'm not aware of too many places that allow surface discharge at all anymore.
So you made the assumption
Except the Gulf.
You couldn't do it. Okay. So you said you submitted the permit in October, and then it was 4 months before it was approved?
I think that's roughly the
approximately.
Time, yeah.
4 months. There's a gentleman in the back with his head going up and down. So
he knows, because he was hugely helpful getting it.
Okay. And it was already an existing injection well.
It was in the past, but for what we found records of millions of barrels injected into it. I don't think there was any records in the COGC database, because I think it predated that. I'm not sure exactly why.
Yeah, because you wonder if it was, there's been a lot of back and forth between EPA and the state of Colorado on who has primacy on underground injection control, and if maybe ran afoul of that, maybe there was some other paperwork that was missing along the way.
And multiple operators involved in the ownership of the field.
So notionally, when you think about that, if it's 4 months, that would have been November, December, January. So you're going through the winter time. You shut the field in October of 13.
Yes.
And I read in here, and I may have misinterpreted this. This goes back to that Exhibit 13. It was an update in July of the letter. CDP-HE compliance items. This is our Bates page 304. The comment you had in here is that we will be able to accomplish, this is related to the pit closure, reclamation, and discharge, be able to accomplish this after the injection process has been implemented. Were you speaking about the Entrada well there?
Well, my idea with the pit water from the pits was get the disposal well permitted and take the water out of the pits and pump it into the disposal well. And I think there was a specific agreement for that, but later I got concerned with the snow melt and the rainwater that was in the pits, because that wasn't approved for disposal. Whether I would have to have separate approval for that, but if back up in time, if the disposal well was administratively approved, we still considered we had to bring a rig there and do the work correctly, make sure the casing had integrity, and do it correctly and safely. But as soon as we could place tubing and a packer in that well, the water out of those pits right into we would have laid temporary lines there and drained them immediately.
Okay. I'll come back to that in a second. Going on down back to Mr. Davenport's talk about item 4D. I'm almost left with thinking you were maybe talking about injection wells for water flood. You said rig work with injection tasting. After we identify appropriate disposal wells, we will provide necessary paperwork in the testing injection zones. It goes on to say this is far enough into the future that I don't want to predict the timing. So when you think far in the future, were you thinking how far into the future?
Several years.
So was that related? That comment was related more to pressure maintenance wells?
Also, and I still have this concern, is how much water that Entrada well would take on a daily basis and be within the pressure limits, as you don't, you can't pump it in above frac gradient, whatever that limitation is, and then try to inject more water. So as we thought we could produce the field maybe 100+ barrels a day, we recognized the field could make 3 or 4 times the amount of water. But so we would have probably had to have more additional disposal wells or water flood. The concern I had about the water flood is the drainage is on the other side to be able to pump down dip.
Right.
To be able to do that safely. The Entrada well is on the uphill side.
In terms of structurally in the formation, is it? I think you said the one on location was the highest well in the field structurally.
It's one of the 4B well that's in this picture is one of the higher wells. The Entrada well is further up structure, but it's in a deeper zone.
Okay, so it's not in your actual producing horizon.
Correct.
Okay. So here's what I'm left with is that if I'm looking at this field, and you can correct me if I missed something here, I need to get the pits drained, fields shut in. If I get those pits drained and a disposal well going, I could at least start some production up. So I'm sort of coming into the spring of 14. I get my permit approved. I know I only have to spend, by your own estimate, $50,000 to get the well on. So let's triple that, $150,000 to get the well on. Why would that not been the first order of priority? I can do that, then I can drain the pits and I can start producing some wells.
I'm sorry, the 3-phase power that we talked about running into the field, we worked with a power company to run that, and it was several miles. They made a couple of different proposals to come in from the south, and then later they had a project, I believe, at Lake John, and they decided they wanted to run that and then take a portion of the line off that to us, so they came in from the north. So that's the power access to 3-phase power delayed it a little bit, but I was pretty reluctant to spend that money at that time. That was a pretty good commitment to me until the disposal well was approved, especially when it had to go to full EPA or federal approval.
But you did get the approval in early.
Yes.
When did 3-phase power come in?
I think that was through the summer of 14, like the end of 14 it was run.
So fall of 14?
Yeah, and they were slightly a little bit behind schedule too. They got to get approval from all the landowners to run the lines and power poles and everything.
Still a struggle for me to understand that is that, when you say you spend $1.5 million on it and it's, worst case estimate, it's only $150,000 to have that disposal well operating by the fall of 14. And I could get get some wells producing. I'm having a hard time understanding that one.
I think at the end of 14, when the power was finally run, that there was some limitations on us ditching and doing certain things, digging in the field because of the cold weather.
But you just got through saying you'd lay a temporary line over there if you could.
I would have, yeah.
Still left scratching my head here a little bit.
Well, I think the power was run at the end of 14, and by then it was wintertime.
What would you do next if you had it? So, okay, we're going to start with a clean slate. What do you do next here? It's okay. Hypothetically, you say, okay, well, as a commission, we give you a couple of years to continue to move forward, because it certainly appears like in your mind you've done a lot. In the commission's mind, you can look at the slide that was put up there. Still got a big pile of dirt and a bunch of pits with oil under the ground. There's a lot of discussion about how best way to remediate those pits, but what would you do next?
Well, the pits need to continue to be evacuated of any free oil product, and that's kind of my description of using the sledgehammer to fix it. You drop a hose in a trash pump and you suck it out of there regularly. The pile of soil, to me, does not. We used a method where we treated it with hydrogen peroxide, and it basically kills all the natural bacteria in the soil. That needs to continue to be spread out on their available land farm space and treated, piled up, exposed to the air and the sun. So the pile of soil can be done in that method. The pits themselves just continue to evacuate the free product off of them, and when it kind of gets to the point where there is residually like little or none left, then there's some methods that we've talked about using, either some fertilizer or a product called Coolox, and treat that. But I would be adamantly opposed to excavating any of those pits. The minute you punch through that liner, you're going to create a catastrophe, just like in the one pit that's there. So I would take the time with that and try to do it in a method that's friendly. I think the land farming in a couple of years that it would pass 910 standards.
Okay.
In the meantime, I would continue this spring, late spring, summer to do the rest of the testing on the disposal well and finish the hook and turn the field back on.
And what you said earlier is that the reason why because we've got all of summer, and you essentially have all of 2015, because you said you got power in the end of 14. So let's just say it didn't do anything in the winter, but now all of 15, nothing happened with getting the disposal well hooked up in the well and the field started up again.
Well,
was that just because of waiting on the AOC?
That's, in my mind, that's part of it, but we also spent a huge amount of money on the tank battery. We set new tanks and we built a system there that we've used in several other places to safely and adequately treat the produced water so it could go in the disposal well. So that's what we worked on 15.
Okay. But what I didn't hear is well, I guess I did hear you would try to get your disposal well put on this year so you could get the field started up again.
That would be the plan, yes.
Okay. Well, for the moment, I've run out of questions. So.
Those are really good. I appreciate them.
You stated, I thought I heard you say, you need to wait till those pits dry up before you can use the treatment that you mentioned. Did I misunderstand that?
Well, my assessment of it is that there was residual oil in the banks of the pits. The water set on top, especially in pits 4 and 5. When you would go out there on a normal day, there was no oil floating on the pits. When we drained them, I didn't anticipate there would be oil that would come out of the walls of the pits because oil should float. So when we signed that agreement that we would be able to reclaim those pits or decommission them, I didn't think that would really be a problem with those two. I anticipated it in pit 1 and 2. Pit 1 is the first treatment pit. It's the one with the net over it. And there was obvious signs of oil in it. Some in 2 regularly. 4 and 5, I didn't anticipate that we'd have that problem when we drained it. I thought that it would be muddy soil and there possibly could be some hydrocarbon that was dissolvable in the water that would be in the banks of the pit. I didn't even anticipate the liner in the pit. When we evacuated it, I thought, wow, this was something they did that I just didn't even think they had done. Then it made sense to me what happened to the treater pit too, because the huge amount of soil pile of soil that was created out of it. So I don't know if that answers your question.
Yeah, that answers my question. So 2015 in Southwest Colorado was a wet summer. I don't know what it was like in North Park.
I think there were parts of the year that were pretty drastically wet up there.
So you're going to continue to get runoff all summer long, just from rain.
I believe so.
And that, whatever, theoretically should continue to move some of that oil product out of the banks, out of the sides, into the bottom.
where we could evacuate it, correct?
I'm amazed, I guess, a little bit, like you were amazed. So I'm not alone. I'm not an engineer. So that pit 5, in fact, would have so much hydrocarbon. I mean, that's the pit from which the discharge went directly into Spring Gulf.
Yes, yes, and I think when they had I don't know when they had the previous leak up there. I have a suspicion that it came right out of the treater building and right into the creek. It never went through the pits. I don't know though. I wasn't there. I think it happened in the winter time too.
Okay, other questions? Shoot.
Give me a minute or two. You mentioned earlier in your statements that I think you said you operate in North Dakota, Oklahoma, Texas. I think were some of the other states where you said, and I noticed last year your production for Colorado was around 11,000 barrels or something like that. So I'm assuming that's out of these other 2 fields that you talked about here in Colorado. Is that correct?
I'd have to think what's 11,000 barrels per day or
no, 11,000 total.
Yeah,
it's around a little under 1,000 barrels a month, something like that's what's in the state records.
I think so. I think that's about 20 for the rice and about 15 for the hide cap.
Okay. The other states, and then you use that as an example, said that you've been able to, where you've taken on some of these other sort of problem children, that you worked with the other commissions and they've been more, and I'm putting words in your mouth, and you said they've been more cooperative than this state. Can you give us an example or two?
Yeah, the state of North Dakota, we purchased some wells along the riverbank that the river flooded. This was about 4 or 5 years ago, and they floated their tanks and broke lines and spilled oil into the Missouri River all over location. We went in and set up a process where we added additional tanks to it. We fixed leaks in the tanks that were there for a number of years, and our process involved berming the locations to protect them from the river flood. So step 1 is if the river flooded, the berm around the outside would protect it. We cleaned up all the pile of soil that was there, all the contaminated soil. We fixed the tanks that had leaks in them. We added additional tanks so that when the river would look like it was going to flood, we could fill the tanks 8-10 feet high so that if it did flood, the tanks wouldn't float. We put in some remote sensing or remote shut off equipment where we could shut them off. And we set up a program with a spill provider that would provide some material and equipment and boats to be able to get to the wells if the river did flood. The state was very happy with us for working on that and taking it over the way we did and cleaning it up.
How many years did that take?
About 2. By the time we were finished. It wasn't nearly like this field though. That's probably one of our best examples.
Okay. Anything in Texas that comes to mind?
Wyoming, we have a couple of wells there that we had some problems with, that contamination on the surface that we fixed. This is by the previous operator, not checking them every day. Our Texas stuff has been pretty straightforward.
And about how long on fixing those Wyoming wells? You get the practices corrected and
probably a year.
About a year. All right. Thank you.
Commissioner Hawkins.
I just have a few questions. And a little bit of a comment while we're talking about it. You know, I feel like, and I understand your concerns that if we put the field back on production, you wouldn't have the MIT issues with those 5 wells. Those wells would have been producing. Would have reduced the number of inactive wells in the state, so it probably would have reduced whatever financial assurance increase you might have. But it wouldn't take care of all 23 of the shut-in wells. And I think ultimately what we are looking for in the state is to take care of the environmental risk and problems rather than have you pay a penalty. So I'm struggling a bit with having, really high penalties and not being able to apply some of that money back towards a remedy for the pits and the contaminated soil pile. But I have the same problem that Commissioner Benton has, is that I can't understand why you wouldn't get the wells on production with the disposal well to get rid of the produced water and start making some more revenue there and applying that towards the environmental cleanup. So that would be my preference, is to see the wells that are shut in back on production and apply that revenue towards environmental cleanup. And I guess I'm not really asking you a question. I'm just wondering if that's why that's not what you're saying to me.
Well, I think it is. The 23 wells that are on the list, there's 1 in Washington County, and the others are in this field. So that could potentially take care of all of them, except I believe the Knopfsinger, which I believe the lease was expired when we purchased it. So there would be 2 wells that couldn't be turned back on, basically. As far as bringing the revenue stream back on to help pay for the environmental issues, I absolutely agree. I mean, I guess I elected to delay the electrical, not really by my choice, but also with the ability of the power company to bring the 3-phase power to us timely. My concerns over whether the disposal well would be approved at all. That was my first real concern.
But you've had that approved now for over a year.
Correct, but that process was finalized before I could get them to do it, and then they usually put you on a schedule that takes several months. So I think going back in time at the end of 14, when they brought the power into the field, basically right before winter time, we still had work to do with the tank battery and the final hookup, and we haven't been able to do that, or the winter time delayed that into 15, and we worked on the tank battery a little bit, but the treatment of the pile of soil and the treatment of those pits was kind of ongoing during that process too.
It just wasn't real obvious to staff that that any progress was being made. And I think that's, a big issue. They started out the hearing with saying they've lost their patience. They've been trying to work with you for 2, or now they say 3 years. So difficult to have more patience, but I can tell you my preference is to see the economic or the environmental risks remedied and the field back on production, as opposed to paying a large fine. So I have a little bit of a dilemma to kind of resolve before we vote on this, I guess. Thank you.
Other questions? We're getting like that close to deliberating. Closing the record and, oh, I'm sorry, I forgot. Ms. I'm sorry. That close went to. Sir.
Sorry. Let me get clear. I think I heard what you said, that if you were going, what your work plan would be for this year, if I'm correct, it would be to get your disposal well hooked up and to get some wells producing, and then continue in parallel to work on cleaning up the pits and the pile of dirt. Is that correct?
That's correct.
And how much would you, to the nearest $50,000, how much will you spend on that field this year, 2016, if you were to go do that?
That's a really good question.
You want me to give you a broader range?
I mean, in the next year, I mean, I think there's probably somewhere between 50 to 70,000 to get the final hookup done for the disposal. There's roughly 10 to 15 grand a month for the pumper to be out there. There's that, I mean, he kind of maintains the land farm for us. I haven't seen the proposal for of the pits, and I don't know if that could be done towards the end of the year. I don't know.
Okay. If you mentioned earlier the field made about 25 barrels a day when it was shut in, is that correct?
Yes.
Out of how many wells?
I think there was 8 or 10 producing.
And would you be able to turn those all back on again?
We should be able to.
I'll have to noodle on the math during the rebuttal here to kind of think about that.
I don't, I'd have to weigh the risk of producing the wells on the other side of the drainages I talked to you about. That just seems like a potential problem without some more safety procedures put in place.
As far as potential flow line leaks or what?
Yeah, I don't want that. That's the last thing I want to be sitting in here, have somebody exposed to a pipeline leak in one of those drainages.
But you could pressure test those.
Yeah, but even then, it's whether that do it one day and then 3 months later you have a problem. I just think like double lining
You
this.
said you had lined.
He ran a plastic liner in the disposal line. Yeah.
What I'd almost see with those wells on the other side of the drainages is some sort of a double lined pipeline where you could check the integrity of the inside line by
Those have electric power to them, or
no, just like 2 pipelines, one inside the other.
No, what's
and then put
they're rod pump wells, right?
Some of them are rod pump. They're various. And some of them are rod pumps. Some of them are ESP. Some of them are jet pumps.
But they're all artificial lift.
Yes.
They have electric power.
Almost, I think every well in the field except maybe the Knopf Singer is electricity's run to it.
So notionally, you could put some kind of a pressure switch on there that in anticipation of a leak, you could shut the wells down. So that would mitigate your risk to some extent if you needed to. Tell you how to do your business. I'm sorry.
No, I mean, that's just keep the simple process.
Yeah. I'm just trying to think about it. If you do the work, then can you get that thing to where it's cash flowing for you so you've got some incentive to continue the cleanup efforts? Because I'm like Commissioner Hawkins, you struggle with sort of what happens next. You say, well, not doing a good job, here's a bunch of fines, then field gets shut in, notionally it becomes a ward of the state, the wells get plugged out. So I'll be quiet. Thank you.
Yeah, I mean, we in our kind of overall business model, we anticipate that this field is not going to be solely economic by itself until we Part of it, when I talk about these operational problems with these wells, you can't have one guy out there 24 hours a day. You just can't do that. You got to set it up where one guy should be able to check 20 wells in the field for, 3 or 4 hours and take care of it correctly. And that's not the way this field was set up. And so we put some capital dollars into it to try to get it to the point that it's easy to take care of and it's safe and it's simple.
Okay, thank you.
Okay, staff.
Staff would like to call some rebuttal witnesses. And the first witness we'd like to call is Stuart Ellsworth.
I already swore. Stuart Ellsworth, the engineering manager at the Oil and Gas Commission.
All right, Mr. Ellsworth, you heard Mr. Tuff's testimony regarding the UIC permit at issue here. Is that correct?
Yes.
And you also heard that the permit application was filed on October 29, 2013 and approved on February 28, 2014.
That's correct.
Can you tell us, that's about 4 months, and can you tell us how that time period relates to the average approval time period of a UIC permit approval process?
At that time, in 2013 and 2014, our average time frame was 238 days.
So this was less than half that time, is that correct?
Correct.
All right. Now, you heard and you're aware that CM purchased this field in June of 2013 and the permit was not filed until October 29, 2013. Are you aware of anything that COGCC staff had to do with that period of time? Did COGCC staff do anything that could have delayed CM in filing their UIC permit application?
You said prior to their actual submittal?
Prior to their actual submittal.
No.
Okay. And would you please briefly explain to the commission what the complicating factors on this particular permit application approval process were?
Well, this was actually a pretty complicated permit from the standpoint of it's a pretty shallow field. The field itself is kind of in the 2,500 feet-ish, and then the injection zone is at about 3,000 feet, kind of in general numbers. So it's relatively shallow. And then the TDS of the water, I believe it was about 1,600. So it was very fresh water. And so it was, once we got the permit and were able to kind of get into the details of it, that's when it became complicated from the standpoint of assuring that the freshwaters were protected. In other words, there were shallow wells shallow water wells that were in an up-dip position that were being used within several miles of this. So in this injection zone, we perceived it as potentially usable water. So we went through and CM provided us a lot of information. Bob Kaler, the UIC lead, did a detailed geologic review, and the structural complexities of this area really gave us the impression, and it took a while to do that. Actually, it took a couple months to get the feedback and back and forth and get understanding of this. In that same time frame, we do a referral on a permit. We refer it to the Division of Water Resources, the Water Quality Control Commission, and when it's this fresh, we get an EPA approval of an aquifer exemption. The importance is that when this well, and we had no documentation of this well being an injection well back in the 70s. It was used, and Mr. Teff provided that information to us. In correspondence in November, he provided us that information. And so we acknowledge that this was used as an injection well from 1977 to 1984. And then, 1984. And then it became a producing well for a time frame from 84 to, I believe, about 2010. But in our minds, once we got this well, we believed that it needed to go through I'm going to say, modern review. And so that's what was maybe a disconnect in the communication. But based on how quickly, I think Bob Kaler did a fabulous job in doing this review.
So to sum up, is it fair to say that prior to receiving the permit application on October 29, 2013, COGCC staff was not aware of the extensive work that would need to be done to have this well approved as a UIC injection well?
That's correct.
All right, thank you. I have no further questions.
Apparently you've stimulated
Oh.
Commissioner.
Oh, no. Well, that explains, I mean, 7784, EPA would have had primacy over anything related to injection wells at that point in time. The state didn't get primacy until late 80s, I think, or something, before they got primacy over injection wells here in the state. You mentioned you had to go to the EPA for approval for an aquifer exemption. It's either the producing horizon or the entrada, sorry, up here, underground source of drinking water, listed as a USDW.
It would be a USDW based on the fact it's less than 10,000 parts per million.
But it's TDS, yeah.
But it's a hydrocarbon producing zone.
You can still have it
Well,
be a
that's correct.
potential USDW, even though if it makes oil, it could still be a potential USDW.
Well, let's make sure we clarify. This was not injecting into the producing zone.
Correct.
So it was
It's
not
into the entrada,
which is below the Lakota, Lakota is the producing zone.
which is a potential, both could be potentially underground source of drinking water at that depth and at TDS level.
Yes, sir.
Okay. Thank you.